Well, good evening. Happy Friday to everybody. It is 8:08 p.m., which means I am only 8 minutes late, which I think is a new record for me. Uh, so, welcome. I'm glad you guys are here. We've got so much to talk about, so I don't want to do too much dilly-dallying. I want to get right to the subject because I had so many questions at the end of the day. Did I make a pit stop on my way home and test out some reverse driving techniques? I think I did. I did. But let me roll the intro. We'll get into it. We might have a guest. We might have two. I don't know. Who knows? It's a fun day. It's Friday. We'll see you on the back end. Cheers. So, welcome in earnest. Glad to see you guys here. Happy Friday to all of you. I hope you had a wonderful week. I had a great week. One of the highlights of my week this week was, uh, well, some of the shenanigans we're going to talk about tonight, but one of my highlights of the week was hearing a certain person giving commentary in response to those shenanigans. Um, and we'll call it like just righteous indignation. So, without further ado, Natalie, how you doing?
Hi, I'm great. Ooh, am I echoing? Hold on.
No, you're good. I got you.
Oh, okay, good. Hi. Thanks for having me. My dog decided to come on in here as soon as you popped up the camera, so excuse me, but thank you for having me.
Well, I'm happy to have you here. So I know we only have an hour with Natalie. I stream late at night. Natalie doesn't do that. She has life. She needs sleep. Um, but Natalie, you were prepping for a murder trial this week, right?
I was prepping for a murder trial. That one got moved, but then I have another one in 10 days, so, you know. That's why I'm home I'm home the past couple days so I could do some prep work.
The life of a trial lawyer, man.
Yeah.
Ugh, people don't get that. When we're doing the live streams trying to break down stuff, I've got clients calling, opposing counsel calling.
Yeah.
On the topic of ex parte communications, I had an opposing party send an email to the judge that heard a motion I had last week.
Uh-oh.
Oh,
Yeah, there's always something. The thing I always try to remind myself is, I have clients that are in jail pre-trial and they watch this. So I'm like, hello. I'll sometimes in a stream, I'll be like, I have to go back to work. So I'm working on your case. Don't think that I'm just like sitting here putzing around all day.
yeah.
Mhm.
So, Young Thug trial is where I want to kind of start just with you right now.
Yeah.
Is Brian Steele your new favorite attorney?
Oh, yeah, absolutely. I have, like, the legal hots for him now. Like, as far as, like, legal mental, things are concerned, I was really impressed with him. Absolutely.
So good.
So
We'll
good.
later. I don't know if you'll be here when we play that, but you'll probably be watching and laughing along.
Mhm.
Today, I saw that you were covering some of the Karen Reed stuff, most notably Trooper Proctor.
Yeah, little flashback of Trooper Proctor, um, and I covered the end of his testimony, which was redirect and then recross when he kind of went off the rails and accused Yannetti of harassing his sister, essentially, which just like wasn't true. And then it was stricken from the record. So more of him just being a completely unreliable, off the rails type of witness who is somehow a law enforcement officer.
Question for you.
Mhm.
There were a lot of people that I saw on the interwebs after Trooper Proctor testified. They
Mhm.
were basically saying, "How does any of this about his text messages do away with anything that he
Oh.
was saying for his findings?" How do you?
Oh. Oh, wow. Thank you for asking that question. I've seen that on Twitter too. It goes to bias. He collected a lot of the evidence in the case. He interviewed a lot of the witnesses. You have to believe that he's credible when he says he collected the things he collected and that the witnesses said the things that they said and that the evidence the prosecution is presenting to the jury is substantially the same as when he collected it. So bias goes to credibility. So bias is about whether or not someone has some type of favor or non-favor towards a person that would make it more or less likely that they would testify in a way that would harm that person or help that person based on how they feel about them and not based on the truth of what actually occurred. So that's why they're allowed to get in such a wide range of questions about the things he said about Karen Reed, because it's called bias cross-examination. It's a whole section of cross, and you're allowed that wide-ranging latitude because it shows the person's less likely to tell the truth because they hate the person that they're testifying about. And here, it doesn't always have to be hate. Bias could also be you really love a person, and so you won't testify honestly about them. But he really hates Karen Reed, and so he's more likely to lie as a result of that.
Yeah, it just questions all of his credibility. Because the thing is, you're relying on this witness. And I think so. Lolly was facing a double-edged sword, right? You either call him first and you lose your case within the first day,
Yeah.
or you allow the defense to salt the earth throughout the first, 5 weeks, 4 weeks of trial.
Mm-hmm.
Call him so that the jury is already sitting here going, I want to hear from Proctor. And what
Mm-hmm.
here is, well, it's something.
I don't think strategically there was anywhere that they could have put Proctor that would have made his testimony have less of a terrible impact on the Commonwealth's case. His testimony was that bad. And the way in which he testified was that bad as well. The panned phrases about him being emotional and all that type of stuff. He just was not a good witness. He was a terrible witness. And it seems like he was lying a lot. And so there was really nowhere to put him. I don't even know if it was strategic. The fact that we haven't heard from the medical examiner yet is very interesting as well. I think it's a sloppy, messy case, and there's nowhere for them to put their witnesses because they don't have a good case.
And Proctor was one. Natalie, have you ever had the opportunity to recite vulgar curse words in an open courtroom?
Yes. It's fun. It's fun. Happens all the time. Fun.
You are 7 minutes into a live stream, so I can't play
Yeah.
how much fun Alan Jackson had.
Mhm.
But when I say the individual, Jackson gets up and uses the C word, see you next Tuesday, and
Mhm.
a hard C and the hard T at the end.
Mhm.
Oh my gosh,
I
and
know.
visceral tone.
And the R word, we were talking about that in the stream I had just now that, Jackson looped that back in as well in his questions. The C word, that's tough. That's bad. It's terrible. It shows like his misogyny and everything. But that R word, I mean, I find that one so much more offensive for some reason. It really bothers me. And it just makes me think you're just a bad person. You're just a bad person to be calling people that. And and so I didn't care about anything he had to say. I didn't trust or believe anything he had to say because of the way in which he was talking about the suspect in the case. It was horrendous.
And that's my question for the
Mm.
people that are sitting in the jury box right now.
Mhm.
What are they taking home? What is it that they saw? What were they expecting? I mean, it is wild to think that you've heard this boogeyman throughout the entire trial, and all of a sudden he's called to the stand. And
Mhm.
Lolly, to his credit, well, I'm not going to give him too much because he kind of botches it. When you have bad evidence, you like to take control. Lawyers like to take control of stuff. So I like to take control of bad evidence and to get it right out in front. Right.
Yeah, absolutely. Mhm.
But when you do that, you have to do it with absolute sincerity. Otherwise, it comes off like you're just bullshitting and spinning and trying to make people believe something you're not. That's not true. Lolly, whether it's the monotone delivery or how he did the text messages and the dry nature of it, there was nothing. I felt nothing other than, okay, you're trying to get in front of this, but I know it's going to come slamming home.
Right. He did not take the sting out of it at all because this is one of those rare occasions where there was no way to really take the sting out of it. As the lead detective in a homicide investigation, you just should not be talking about the lead suspect like that or the prime suspect like that. You just shouldn't. And I have seen officers, I was saying this on Surviving the Survivor. I have seen officers text messages before because I've sent subpoenas for them. And rarely we get them. And I've never seen that before in their personal conversations. It's just, it really is not the norm, the level of personal animus he had towards her. And so I don't think there was any way to clean it up. It wasn't there, you know?
Well, and one of the things that's very unique about this is we don't usually get the officer's cell phone. We don't know whether this is how they
Right.
every witness, every defendant, because we don't get the cell phone. They got the cell phone in this case based on the federal investigation of the investigation.
Yeah.
We
I always have to like quibble with everyone that keeps saying that. I've gotten lots of officers' cell phones, lots of them.
the whole
When
thing.
when I see on body worn camera that they're texting on their phones on the crime scene, I subpoena
Oh,
their personal phone. I send a subpoena to the court for tangible evidence to be served on the officer. Because if I can pick up anything of them texting about the case, those are notes about the case, and I want to see them. And I really am glad I'm here because I would encourage any other criminal trial practitioners to do that. Please,
push
please
the
do it.
envelope,
Yeah.
push it.
Hmm?
You push the envelope. You don't know what
Yeah.
they're going to say, so make the request.
Make the request.
Yeah. Yeah. Well, Natalie had a fun announcement today, and I want to see if the chat can help out because we've got right now 2,600 of you guys watching. And I don't know how many of you have been introduced formally to Natalie Lawyer Chick and her group of chicklets. Natalie's a criminal defense attorney who practices in Maryland, just north of me, honestly, like a
Mhm.
stone's throw away.
Yeah,
Uh,
we're really close to each other, actually. It's crazy that we haven't hung out yet. That's crazy. We're really close to each other.
it's shameful, actually, to be honest. Uh, but please consider subscribing to her channel because I know that she's close to a milestone and I want to see if we can't hit it tonight.
Oh,
So, what I'd like to do in the chat, I'm going to post her link and it's going to be pinned to the top of the chat. So do me a favor while you're doing something else, which is hitting the little like button
oh yeah.
right beneath, right there. Like and just that's good. If you like to, if you want to subscribe, subscribe. But at the top of the chat is a pinned link, and that's to Natalie's channel. So go subscribe because I think if you guys do, she'll hit 150,000 within the next hour that we have her.
Oh, that would be so nice. Thank you so much, Rob. You didn't have to do that. Thank you.
I like encouraging people that explain the law in a fashion that makes it approachable. Like that's a huge thing for me.
Yeah.
So please do that. Please go hit like and subscribe to her channel. Watch her content, particularly scroll back to her video this week on the Young Thug trial. Because if you ever want to see a lawyer righteously losing their mind,
Oh.
you know what? Have you read the affidavit yet?
No, I haven't read the affidavit. What affidavit? Oh, see, I always miss things. Catch me up to speed.
You know what? Chat motion to take the affidavit first. Put a one in the chat if you think the motion should be granted. Do we do the affidavit first? Do we shock Natalie's conscience? So I want to see that because I'm going to go ahead and pull that up.
Yes, they're saying.
There was a motion to recuse after what went down with Brian Steele. And don't worry, I'm going to go over the Brian Steele stuff
Yeah,
second.
yeah.
But, and honestly, I had saved it on my work computer, but Calypso and Vixen was kind enough to save it here and send it to me as well. So I'm going to go ahead and save that and pull up the affidavit so I can get Natalie's reaction to this because I think she's going to lose her mind. And
Okay.
I mean, just being honest, it's going to be kind of fun to watch that happen live when she hasn't read it yet.
Oh my God.
Let me do this.
I'm already like probably lost all the hair out the side of my head because of Judge Glanville. Like I think I have a bald spot now because of him. I was so angry watching him. So
You're gonna get so much angrier. Don't put the cart before the horse. Um,
um,
where's Ian? I think Ian was he's gonna join at some point. He always joins. He was excited. He's probably pulling timestamps for his thing tomorrow. Plus, he's 3 hours different, so it's like 5:20 for him.
mhm.
Let's do this. Let's go ahead and blow Natalie's brain. So this is the motion that was filed on behalf of this particular defendant, Parte Kendrick. Now, the motion is one thing, because the motion is just the attorney putting gloss on it and basically saying this is why, Judge, you should recuse. But what I found fascinating was the affidavit that was accompanying it.
Okay.
And that is right here.
Let's see it.
Weinstein affidavit in support of motion for recusal of Chief Judge Young Glanville. Personally appeared before the undersigned officer duly authorized to administer oaths, Douglas S. Weinstein, who, upon being duly sworn, deposes and states the following under oath and penalty of perjury.
Okay.
So Copeland was held in civil contempt on July 7th. That's the Friday contempt finding when he refused to testify. So he spent the weekend in jail, and the judge said, everyone get your butts back in court on June 10th at 8:30 in the morning. And we're going to see if Copeland has had a change of heart. So defense counsel shows up, and they're all in the courtroom at 8:30 on June 10th. They're all there, and Judge Glanville was not. Upon information and belief, an ex parte meeting was held in Chief Judge Glanville's chambers on June 10th. Among, here are the characters, Chief Judge Glanville, ADA Love, ADA Hilton, so there's a prosecution team, other officers of the DA's office.
This is inappropriate.
Deputies, the sworn witness, Kenneth Copeland, and
which is, it makes me so mad. Okay.
In the middle of testimony.
Right. He's testifying. He was on the stand. He's under oath.
People aren't understanding that part. That's the part that's blowing my mind. This is in the middle of testimony where the right to confront is at the pinnacle. Like, this is the peak of the right to confront, is when that person is actively testifying against you or under sworn or has been sworn to be in the process of testifying.
Absolutely, you're absolutely right. It's a big problem.
So no member of defense counsel was aware it was taking place. Then at 11:30, Judge Glanville comes out, takes the bench, and says Copeland is ready to testify. Well, that probably a lot of defense attorneys say, well, Judge, where were you at 8:30? Like, what and why are we announcing this now? Like, what did you learn and how did you learn it? That is, every defense attorney is just going, how's this happening? Attorney Steele at that time inquires with the court as to what occurred prior to Glanville taking the bench, and the inquiry was not accepted.
What does that even mean? That is insane. That is insane.
People are saying to make it bigger. So let's see. If
I had to make my screen bigger to see it. Yeah, much better. Thank you.
There we go. You know what? I think I can actually zoom in. Oh, no, that's too much. Too much zoom. Let's zoom.
You must have really good eyes.
There we go. So Copeland then briefly testifies. This is after the confrontation. Now, backtrack. We're going backwards to the ex parte meeting. At the ex parte meeting, apparently Copeland announces that he's going to invoke his Fifth Amendment rights and not testify. Okay? One, I don't like that being done outside the presence of defense counsel.
No, of course not.
What happens next is worse. Copeland apparently then says he would rather sit in jail for 2 years rather than testify. Fine. Okay. Transcribed. So we're going to get that at some point. But Chief Judge Glanville then informs Copeland that he could keep Copeland incarcerated until additional defendants were tried, not just the defendants currently on trial.
What?
I told you guys.
What? I
told you.
You're threatening him to make him testify? I can hold you not just for the 2 years. I could hold you while other people are tried. Are you kidding me?
Oh,
that is a threat.
It gets so much better. I already love that you're already losing your mind. Yeah. This is, it gets worse somehow. Then, after this, the DAs chime in. Ex parte. Either ADA lover Hilton informs Copeland outside the President Defense Counsel, so no objection can be made, that there were over a dozen defendants left to try.
This is end this trial right now. End this trial right now. How is this happening outside the presence of the defense counsel? How is this happening at all? Even in front of the defense counsel, these comments wouldn't even be appropriate from the court, because the court is not supposed to involve themselves in a witness testifying or not testifying. Hey, boss attorney Bree, that's
Hey,
wild.
Yeah. But
okay, let me shut up.
There's more.
Oh my God.
Do you have a cocktail present? Because you probably should.
Oh my God.
So following those actions, Judge Glanville, he's the chief judge, by the way, chief judge.
I know. Ran unopposed.
Yep. So they state with more of the DAs, and Copeland, after being confronted, that says that he'll testify. Bad.
So he was influenced by the judge's undue influence. Sure.
Of course. Glanville also presented Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting.
No. This is crazy.
Mm-hmm.
No, you can't do this.
Why, Natalie? Why can't a chief judge print out a statute after the person says they're going to voluntarily testify and say, by the way, if you're testifying, here's the statute. What happens if you lie?
Well, he's putting his finger on the scale. He's putting influence on the witness, and that's not his job. His job is to call the balls and the strikes at the trial, not involve himself in the prosecution preparing their witness to testify. And also on top of that, the defense is supposed to be there. This is clearly meaningful communication with a witness in the case. The defense is supposed to be there. This is horrific. I am so disgusted by this. I'm so disappointed that this is a display of our criminal justice system on national television. Disgusting.
And mind you, this is after this witness had been sworn.
Right.
Took the fifth. Was then offered immunity to force the testimony. Pretty clever idea by the prosecution. And
sure. Yeah,
they can do that.
Mm-hmm.
But we get more into the immunity here. So Copeland, in response to what Judge Glanville does, tells ADA Hilton that if he's called to testify, he's simply going to lie on the stand.
Good for him. He's so ridiculous, Mr. Copeland. But you know what? Good for him in the face of all this madness. So this means that, well, that's a big problem too, because that means the prosecution is knowingly suborning perjury, and the judge knows that they are knowingly suborning perjury. So you're not supposed to call a witness to the stand who you know is just going to lie when they get on the stand. And here he's saying, I'm going to lie when I get on the stand, and they're calling him anyway. So to say that in front of the court, you're allowing the prosecution to do something extremely unethical, which is suborn perjury. So nice. Good job, prosecution. Good job, Judge Glanville.
Gets worse. So in response to Copeland's statement, Hilton says she wouldn't prosecute him if he would lie on the stand.
Oh, no, you can't do this. Here's the thing. This is crazy. This is an immunity deal outside of, if you plead the fifth, we're giving you immunity in this case. That's an immunity deal because usually an immunity deal requires that you testify truthfully in exchange for immunity, right? Because they cannot suborn perjury. They cannot put a witness on the stand who they know is going to lie. So if you say, we are going to immunize you from perjury, you have to further disclose that to the defense. And then that's like a catch-22, because you can't put a witness on the stand who tells you that they're going to perjure themselves. And the jury should hear this. They should know that he's getting an immunity deal from, not just from prosecution for whatever crimes he committed outside of the courtroom, but he's getting immunity from prosecution for perjury. I've never heard of a prosecutor giving immunity from perjury. That's crazy.
Was it Billy May who said, but wait, there's more?
Yeah. Oh no, there can't be more. No, it's already so horrible, Rob. I'm gonna have
There's so much
an aneurysm. Okay. All right.
So Copeland, at this point in time, says that he's going to say that he killed Donovan Thomas. So now, a witness, having been sworn in an ex parte proceeding, is now telling the judge and the prosecution that his testimony, the sum and substance of his testimony, is that he, not anyone else, killed this individual. Now you're Brady.
The immunity from prosecution for perjury was Brady. This is definitely Brady. Definitely Brady. This is horrible. I knew this. I knew about this little piece, but all this additional context makes it so much worse. Oh my God.
It somehow gets even worse.
No.
In response to Copeland's statement of that he's going to testify that he killed Donovan Thomas, Hilton tells Copeland that she would then prosecute him for perjury if he testified to that statement.
So the only way that you don't get prosecuted for perjury is if you point the finger at someone else for committing a murder that you say that you committed?
If you say what we
is
want you to say, I will not prosecute you.
Oh my God. Oh my God. I'm speechless. I've never heard of anything like this.
Then
This is more than shady. This is unethical. This is unethical.
And that's the thing. All of that is the pretext to Glanville going back on the bench and basically saying nothing happened. Don't worry about it. So that happened. Let me see if I can't find. So one of the people I've come to follow on Twitter as a result of this is
horrible. This is horrible.
So horrible.
This is disallowed in the rules of professional conduct. It is disallowed under the Sixth Amendment. It's disallowed under the Due Process Clause. It is disallowed under Brady v. Maryland. All of this is horrible. You should not be doing the things that you're doing. Yo, where is Runkle at? Because the people want to see Ian. Okay. Me too.
Let me message him real quick. People, maybe send a message covering Thug Judge. I'm gonna call him the Thug Judge now. Yeah, that fits. Thug Judge. Thug Judge Glanville. Chat wants to see your head explode.
I'm so disturbed by this.
Well, the attorney that makes that motion, let me get to it. Where is it? Where is the motion to recuse? Scroll, motion to recuse. There we go.
I am so disgusted. I can't believe this. None of this and the judge should not be participating in any of this. This judge is sanctioning rank misconduct and thereby committing misconduct on his own.
So this little snippet comes courtesy of the Twitter handle Thugger Daily, who is, I don't know how, but watching this trial to the level that they're getting all these little snippets and back and forth. I mean, it's pretty impressive.
Might be somebody hired by Young Thug's team, because who would have time for that? This trial's been going on for like over a year. So
do you know that there are attorneys right now who have asked to withdraw from this case because they're facing financial hardship? Like they cannot continue defending in this case. Because their law practice is going under and the judge has said you can't withdraw.
You know, I'm not surprised by that. I did not know that. But and also I don't even necessarily that's another catch-22, because it's like, you know, the people paid you know what I'm saying? And it's like, are you going to leave them without counsel? But then they can't lead themselves to financial ruin because of how unwieldy and ridiculous this case is. My husband said, how are they keeping the jurors for this long? Because people are not working. How are they able to pay their bills? Are they paying them a salary? How is this happening?
I have no clue. They have been seated and hearing evidence for 91 days.
Now, that's insane. That's absolutely nuts. And then the attorneys have been involved in the case since a year ago, right? Last year, I think they started jury selection or something like
10
that.
months to seat a jury, and that's not
Yeah.
it took to prep for that.
Jeez
So
Louise.
here's the motion to recuse.
Okay.
And Judge Glanville makes some statements that, well, I mean, a little bit strange.
My attention, Mr.
That's
Weinstein, you filed a motion to recuse me. You filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit. Baptiste versus the state, I invite you to take a look at that. And that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's
what? No, I don't think he's interpreting that correctly. Just like I don't think he interpreted the cases correctly when Miss Merchant was citing cases to him. That's not right. That's not what they're talking about. They're not talking about your rulings on objections. That's not what so the case is probably talking about when you rule on objections, when you do things within the trial. This is something you did outside of the trial. Outside, ex parte, outside of the hearing of both parties. Only one party was present and the witness with his attorney. So this was not a ruling that concerned necessarily the trial itself. This was you inappropriately putting pressure on a witness to testify and put your finger on the scale in favor of the prosecution. You are not supposed to be shielded from that. That's not what they're talking about when they're talking about your rulings in the trial. Get out of here.
Let me just break it down to what you would say if it was a motion that you were not in a formal proceeding. Judge, I'm not trying to remove you because you ruled against my motion to exclude. I'm trying to remove you because you effed with a critical witness during the middle of their testimony.
Right.
Yeah.
The witness was testifying. He was on the stand saying words, sworn under oath. And you brought him into chambers and put the fix in to force him to testify the way the prosecution wants him to testify. That has nothing to do with your rulings within the case. That's not what they're talking about. And he just keeps making these very disingenuous statements when he's reasoning from the cases. He clearly either doesn't understand or he's arguing in bad faith. And I think it's the latter.
It feels like the latter. So let's keep listening, because I've gone away from like the double down, triple down, and quadruple down. I'm just gonna say he's just going Glanville at this point. Like, he doesn't care.
He doesn't care.
Listen to what he does and how he argues this. It's a 4-minute clip, so we're gonna watch it through, and then we're gonna just kind of give our interpretation of it.
That's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings.
Get the fuck out of here, man.
For the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value. Okay. All right. I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling.
Tell me where in the affidavit he made a ruling.
There was no ruling.
Where in any of that, is there anything
There was
about
no ruling.
like
There was pressure. There was undue
Stop.
influence.
Yep.
An ex parte conversation, not a ruling.
Mhm.
Unless your ruling was, I'm going to commit ethical violations and no one can do anything about it because I'm the chief judge. That's not a ruling.
Mhm. And how does the court memorialize its rulings? By order. You know what we haven't seen yet? Anything about the ex parte.
No, not even an order saying based on representations from counsel, this ex parte proceeding is necessary for the safety of the witness or something like that. Nothing.
That was right
Nothing.
there. That's some lawyer shit. That's what
Yeah.
the lawyer's supposed to, that's what the judge's supposed to do.
Mm-hmm.
This is why I had the ex parte. We have not heard, and I have a speculation as to why we have not seen that yet. Because, and this goes back to what the judge is doing with trying to bring everyone in to hold them in contempt unless they tell how they got the information. The
Yeah, I
judge,
heard about that.
like we saw with Ashley Merchant, the judge is not going to make a ruling until the judge hears what their arguments are, so he can rule in some little crack and try to
Mhm.
wiggle out of it.
Yep. Yep.
You got your
Absolutely.
hand caught in the cookie jar, and now you just want information so that you're not fully busted.
That's right. He wants to do his own investigation to figure out who the snitch is, essentially, like a mobster. He's
Ugh.
acting like a mobster. That's exactly how he's acting. You bring him to me. You tell me who told. What type of judge behavior is that? It's
It's not.
disgusting.
It's not.
Particular case. Remember, bias. I've got to do something extrajudicial.
You did.
And I don't, you're in your
You did.
particular,
Sorry.
like I would have to say something about you or
No, Natalie, you can chime in. What was extrajudicial about what he did?
The ex parte communication off the bench outside the hearing of the defense, in which you put the finger on the scale and told the defendant that this is what the perjury statute is, and this is what will happen is if you testify, and you sat there and you listened to him confess to murder and didn't disclose it to the defense. That was extrajudicial.
I agree with everything she just said.
or your clients or anything like that, which I would never do because I'm a steward of this picker process.
For shame.
So I understand what your objection is, or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to address, you have to cease acting right now.
No, I don't.
And then
Yes,
if I could just finish. And then
He's
promise
so
I
reactive.
can
No, I
finish
don't.
this. I believe.
Yeah, you have to let the lawyer make their argument before you cut him off.
That was my issue with him in the last video, was that he doesn't want them to make their record. That's a part of him trying to cover up what he did. He cuts them off all the time. Horrible.
Natalie, people in the chat are saying, hey to you. Tracy Fagan says, Natalie, great guest, Rob. I made the decision the second I saw Natalie explode, I was going to let her go off on this. So
I am so furious. Rob, my anger is so genuine. So genuine.
Yep. It has been a week. But yeah. Equality. Hey, I heart this duo. Natalie, simply the best. I have to go eat a cake now, but can you guys wish me a happy birthday? Happy birthday, Equality.
Hey,
I love
Equality. Happy birthday. You're awesome. Thank you so much for being such an amazing supporter of LawTube. Thank you.
Not to mention one of my favorite screen names of all time.
I love saying the name Equality. I like saying it like that. I love the name.
Yep, with the avatar. It's phenomenal. I love it.
Yeah, it's so good.
Yeah. And this entry required says subscribe to Rob and Natalie for a long time. Natalie, what's your subscription at? Are you at 150 yet?
Oh, I am at 149,604. I started the day at 149,100. So 500 and something more people. It's amazing. Thank you guys so much. Thank you.
You see, she has it pulled up on her screen right now. So there's 4,319 of you guys in the chat right now. 4,319, which means there should be 4,319 likes on the stream, which why isn't there? But two, why doesn't Natalie have 154,000 subscribers? So go subscribe. It takes you 2 seconds. You're not going to miss much. Go hit the button. Come right back. Open a new tab. Hit the button.
That was some good quick math that you did just there. So that comes from your carpentry skills, not your lawyering skills.
No, I don't do the maths. The maths
Maths.
I don't get along. You know what else doesn't get along? This judge and understanding precedent.
No. And there's no way he doesn't go home and see the reaction from other attorneys and probably judges. Judges can't really comment, but I'm sure there's no way he doesn't see the reaction to his rulings. And the fact that he keeps digging his heels in is just very concerning to me.
He wants to explain it, but he's wanting to explain it on his terms at his timing. No, judge, you got to explain it now.
Yeah, you got to do it. You got to have a hearing on it with another judge hearing whether or not what you did was right.
Yep. Witless prosecution. Yay, Natalie in the house, but no Spicy Canadian. Spicy Canadian is on with another channel right now. He'll be over here in a minute.
Nice.
He will. K-Rab says, isn't one of the charges the murder of Donovan Thomas? Uh-huh.
Yes.
Yeah, it's a rather large charge.
Yeah. That's why it's Brady material. I mean, it really is, because one of the defendants is charged with murdering Donovan Thomas and someone else has just confessed to it. Think that defense attorney would have liked to know that. The attorney for Donovan Thomas, I mean, the attorney for the person accused of killing Donovan Thomas would have liked to have known that.
Can the Supreme Court intervene? Not yet. The Supreme Court can intervene on the specific rulings being made by the judge. Like, you can issue a writ of mandamus. Like, here's my writ for mandamus. Supreme Court, please come down and mandate that the judge do something A, B, C, D, E. But that's not really what this is. This is a recusal issue. Now, I guess the lawyer makes the point, and I'm going to let the lawyer make the point, because it's something where I think we're going to be parsing law that I don't fully understand.
I believe that under 25.3, you have to look at the timeliness of the motion and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion. Okay.
Would you grant a certificate of immediate review?
No, sir.
Because
no, sir.
If you grant that certificate,
why not?
You're always talking about how the appellate court.
No, because if I grant the certificate, it stops the case. Okay.
I don't agree.
And I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it. Okay.
This part I really hate. You can appeal it at the end of the case. There have been, by my count, there's got to be at least a couple hundred motions for mistrial in this case. To say that you can appeal at the end of the case is to give no relief at all. It basically says you are going up with the 9 million other issues. The appellate record in this case, the appeals that will come from this case are going to be, I mean, you talk about when you appeal a case, you have to prepare the court record of the trial proceedings. I've talked to people about how voluminous that is for a 5-day trial. You're talking about $10,000, $20,000 of transcription costs and a record that's what, 30,000 pages? A trial that is in day 91 and is anticipated to go well into next year, you're talking about a room, like a full ass judge's chambers full of boxes of paper. And all of those assignments of error. I mean, the appellate court is going to hate you.
Oh, yeah.
Your career is done.
Oh, he's over. He's over. The fact that because this is, I appreciated that, you know, you guys, if you are subscribed to me, you know how I feel about Mr. Trump. But I appreciated that the judge in that case allowed for his ruling with regards to Fani Willis to immediately go up. This is Georgia, Cook County, right? Immediately go, because it impacted too much to do. An issue with recusal has way too much impact on the actual trial itself. That bias, that taint is happening all throughout the trial. His issue of recusal needs to be dealt with now. It needs to be dealt with right now to remove the stain from the trial. And he's right. There is a stain hanging over this trial. It's disgusting. I saw that in the tag. Like, don't you want the stain to be removed from the trial? There is a stain hanging over the trial.
Oh, he says it. Luna's mom, I have no qualms with this. Natalie's my spirit animal. She's passionate. RAF, Rob, love you too, but Natalie's on another level. Yeah, she's criminal defense. I mean, they go hard in the paint, like they're fighting.
It's why we go to jail. It's why we get held in contempt and stuff.
Why
We're slightly unhinged, a little crazy, but damn, do we care about our clients and our cases? Okay.
Well, and yeah, they do. Which is why the coolest thing I found out about Georgia was they have the criminal defense strike team.
I know. So cool.
Yeah. How much do you want one of those? I want one of those.
Absolutely. No, I talked to some people that I work with and I was like, we need this. We need this now.
They even have a name. They're the strike team.
I know.
So, like, we should get matching ties.
Yes. It should be a national thing, the strike team.
Oh, it's so awesome. But the lawyer goes on and gets a little testy.
Interested in removing the cloud that's hanging over the case right now, Your Honor?
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. I just, as a matter of professional responsibility,
you're a bully.
We haven't nugged out all of the issues involved in that affidavit, and I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court, and so I would be.
Is he suggesting that
I'm wondering
there's no factual basis for this, or that the lawyer isn't acting on information and belief that would be good foundation for this motion?
That's what I'm wondering. But if that were the case, that should have been his response the minute that Mr. Steele said something. He should have been like, that didn't happen. That is completely false. I don't know where you're getting your information from, sir, but that is false. That did not happen. You know what I'm saying? That would have... everyone's reaction to it would have been completely different. But instead it was, who told you that? Which is inherently an admission that it happened and you want to know who spilled the beans. So I don't know what he's implying by saying that he's treading, in his ethical obligations. Maybe because he's directly impugning the integrity of the court, but the integrity of the court has been called into question.
Yep. So he's got 30 more seconds and we're going to get to the order to show cause and observations by Brian Steele, who's back in court.
Mm-hmm.
I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that. I'm not.
Would you make factual findings regarding?
I am not at this point in time going to. I've denied the motion. Okay.
I believe that's an error, Your Honor.
All right. Okay.
But to not make any factual findings
Mr.
either.
Copeland now, please.
Like I did nothing wrong. You know what I'm saying? Like no factual findings at all. It's not a ruling then. Just like what you did in the ex parte meeting, it's not a ruling. You haven't made any findings of anything.
Yeah, you haven't done anything. You really haven't. And Jolene, this is a good question. Who can sanction the judge? The ethics committee. But that's a slow moving process.
Very slow.
Very slow. Full inquiry. The judge is entitled to a lawyer. It gets reviewed left, right, and center. Like that itself is going to take a couple months to even do.
Unlike what he granted to Mr. Steele before having the deputies take him into custody, he's actually going to get counsel when ultimately everyone files a grievance on him.
And this is a good question from Caden Banford. Can he be forced to step down as a judge because of the conduct? Yes, after the ethical review. I hope so. How many other times has he done this? It's not just him that I'm concerned about. Brian Steele is, let's just call him a lawyer of a different caliber.
Mm-hmm.
I mean, the man stood up, directly confronted the judge, yelled at the judge, "You should have told me." Now, we've all been in back, and Natalie's probably been one where I've been in a couple where I've got like, where's my toothbrush? I'm going to probably be spending right in jail. You get in the back and forth with the judge because that's your job. Brian Steele like went further and pushed harder than I think I've ever seen a lawyer push, to the point where as he's walking out the door, coat off, tie off, no watch, no nothing, asks permission to approach the podium to make one more motion. And as he's walking out, he has the forethought to make a motion for a mistrial based on him walking out of that courtroom.
Right. And a motion to go into the cell with his client so that he can prepare for trial. I was like, oh, be still, my little lawyer nerdy heart.
So good. It was the perfect. It was so
good.
So
good.
the topic of how mad the judge is. Let's talk about how mad this judge is. Because he's not mad, because he issued a show cause ruling to everyone under the sun.
Oh, he's
order to show cause. Court
how seriously are we taking this order to show cause?
You issue a show cause as a judge, that is the peak of your power. You have the power to, from the bully pulpit, to enforce contempt of court order by incarcerating an individual and in civil contempt until they comply, with no end date in sight.
Yep. I personally, given the context of this entire case, I have lost all respect for Judge Glanville, and I would just ignore it. Come get me from my house. I would show up to court, represent my client, and unless he brought it up, I would just ignore it. Because I feel like this was a temper tantrum, this order to show cause.
The court, having been presented with an issue of contempt for determination, all individuals that were present for the ex parte conversation, which he's now acknowledging, that took place in the court's chambers on the morning of June 10th, to include the witness, Mr. Copeland, his attorney, Ms. Kayla Bumpus, and all representatives of the state and court security personnel that were in attendance, are hereby ordered to show cause before me, the Honorable Young Glanville, on June 25th at 9 a.m. in courtroom 1C, why one or more of them should not be held in contempt. Now, here's where he screws up. Well, he screws up before, too. He doesn't specifically name the individuals, which you actually have to name them specifically and on notice that they're being show caused. But here's where he really kind of screws up. It should not be held in contempt, or, now there's a missing part here. You see a violation of an order stated? Because I don't. It says, for disclosing information from the ex parte conversation to members of the defense counsel.
There was no order in place that they violated, because he never made an order in chambers. Oh, listen, Rob, you're so smart. Absolutely.
This guy's just making the rules up as he goes along.
Yeah, this is completely invalid. You have to show cause for why you violated a court's order. The best way I always think about this is in like discovery disputes with the state. Like you'll say, Your Honor, motion to compel discovery. Judge puts in an order to compel discovery. State still doesn't provide discovery. And then you get a show cause for not complying with the order. But you can't skip that step. You have to get that order first. Great point. I didn't even notice that.
Well, now so in domestic relations litigation, I come into this a lot because there's always enforcement issues with child support obligations, spouse support, sale of home. So we get a ton of show cause is the tool that we have to enforce things beyond the court's dissolution of the marriage, right?
Sure.
So show cause, we're very familiar with this. And the standard that we have to comply to is it has to be a clear and unambiguous provision of the order. So the order has to be clear on its face, and the directive of the court has to be unambiguous. You have to show clear and convincing evidence of a willful violation in order to be held in contempt.
So we saw this in the Rust proceedings, because the judge said with one of the recent Baldwin fights, they said you violated an order, and the judge said no, the order is ambiguous, and because it's ambiguous and their behavior falls into one of those two explanations, can't be held in, can't be punished for that. So
Koberger too, where they try to say they violated the non-dissemination order.
Oh yeah, I remember that. Yeah.
Vague. You can't say they violated it. No, it has to be a clear and unambiguous directive. Now, if the judge had at the conclusion of that ex parte hearing sat down, rather, if he had thought about it more, he would sat down, he would have entered an order that said, it is hereby ordered that the contempt for Mr. Copeland is and shall be purged based on proffer given during this ex parte proceeding, counsel to be noticed immediately hereafter. Right? And the ex parte proceeding shall be sealed, and nothing about that. Like enter an order sealing the facts of that. Seal that, and then make the defense fight it.
Right.
At least then you have an order. Now you don't.
Now you don't.
Or
and that still would have been improper.
ethically.
Right, because that still would have been that would have at least given him a valid, show cause order, but it still would have been improper because under the Sixth Amendment and Georgia law, you have to notify the defense of meaningful parts of the proceeding, and the courts have found that meetings with witnesses are meaningful parts of the proceeding. And so no matter what, without notice and waiver from the defense and defense counsel, the meeting was inherently impermissible, and he did it anyway. Ian, I don't want to go apparently, but I'm watching you eat that pizza, so I'm going to go get my snack and I'll be right back. You guys, I'll see you in a second. You're making me hungry.
Good. So the judge goes further. It's further ordered.
This is my breakfast. Can I intercede or interject with one thing?
Yeah.
You want to know how when your pizza place has just stopped giving any Fs?
No.
This is one piece.
Yeah. No, that's not. That's proper pizza.
It's one giant piece, and on the other side, it's like a bunch of tiny pieces.
We got to hang out more because the thing is, they opened a new pizza place in Fairfax, Andy's Pizza. And it gives proper New York style pizza. And I mean like proper New York style pizza where the thing has got that crisp bottom and it's like this big and it's served on a double plate. Like it is proper pizza.
So is this who's doing the wedding catering?
Taken under advisement. But so finishing this one up, it's further ordered that the failure of any individuals who were present for the June 10th ex parte conversation will, and you can tell he's mad because he forgets a word, will cause the court to direct the Fulton County. Well, no. So if they fail to show up, the court's going to direct the Fulton County Sheriff's Office to take them into custody and bring them to the bar of this court. So if you were present for that meeting and you don't show up, here comes a capias. Here comes a bench warrant.
And you know what? I'm just enough of a jerk that I'd see that and I'd be like, I'm your or I'll be your huckleberry on this one. Come send the sheriffs. Like
that's what I just said. That's what I just said. I wouldn't obey that order.
Yeah,
come send the sheriffs and I will I'll own your house. So
I learned the fact that it's only relevant for the next 5 seconds. You just said, I'll be your huckleberry. Did you know that's not the quote from the movie? The movie Tombstone, where Val Kilmer's character says, I'll be your huckleberry. It's not huckleberry. Do you know what the handles on caskets are called?
You're wrong about this, but keep going.
Am I wrong about this? Why am I wrong?
He says huckleberry.
Because it's a myth.
Come on. I was so happy.
Sorry.
Sorry, man.
One of my favorite movies, Doc Holliday, one of my favorite movie characters, definitely says, I'll be your huckleberry. When he does that with the cup, it's seared in my brain forever. It's like a core memory for me.
And the thing is that the huckleberry thing, it's got a very clear etymology of not that. It has nothing to do with huckles.
So, Rob, whoever told you that, all like, well, actually, send them a text and be like, you're stupid.
That's pissing me off.
Sorry.
I'm going to go on like an ADHD, like complete sidetrack. No, I got to get back to this. I got to get back to Steele. Where was Steele? Oh, here we go. So Steele, appropriately recognizing this for what it is, I'm going to take the loss on this one, by the way. Oh, the rest of the story is the theory, I guess now. The theory that the handles on caskets were called huckles. And so the individual that carried your casket was a huckle bearer. So that's the theory. So now that's now my new task after the stream ends to go research the hell out of that and figure out what's going on.
Yeah,
Gotta get to the bottom of this.
The Huckleberry thing is there's other, sort of things for it, from basically the likely meaning of it, the likely sort of etymology or or origin is just that it's a sweet, it's like kind of like I'll be your sweetheart on this one kind of thing.
Yeah, because the huckleberry is a real thing.
Yeah.
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 Somebody says don't eat huckleberries. Apparently super acidic. Huckleberries are excellent. They used to grow where I spent a lot of time as a kid. So,
I mean, also Tombstone, solid watch, and Val Kilmer's role in that, phenomenal. Doc Holliday, man, that was one of the best movies of all time, and one of the best performances of all time.
One of my fave. Let me mute myself because I'm clearly smacking on this peach. It's delicious.
Oh, you enjoy, because I'm going to enjoy snacking on some of this argument.
Shop, so you can go ahead and make your record.
This is a record. This is important.
Okay, but it's your allegation and assertion, sir. Okay, so, well, we don't know that. We don't know whether or not they're true.
Going on every time Mr. Copeland comes in the court. This is important.
Okay, but it's your allegation and assertion, sir. Okay, so,
you know who does
don't
know
that?
Oh, this is pissing me off.
I know. You know who knows?
The judge knows that it's true, and the judge actually, like, the lawyers have an obligation of candor to the court, but the court also owes an obligation of candor to the lawyers. And when the court is saying we don't know that it's true, yeah, you fucking do. So either say, yeah, that's what happened, or say, no, that's not what happened. But don't be like, oh, yeah, no. It's like, and this also tells us, judge, you're a witness. Get off the case.
That is the other part. Judge, you now, Judge, just challenged Brian Steele, saying he doesn't know what took place, which means what's the foundation of knowledge, testimony, evidence? You have now stated on the record that you are the possessor of knowledge that is critical to the disposition of this particular motion.
Which inherently conflicts him out of dealing with the issue, which is why he refuses to have the motions hearing.
I mean, honestly, at this stage, and I'm surprised nobody's telling him, like, pulling him aside, being like, you screwed up. You need to unscrew this up. And the only way I can see him unscrewing it up at this point is just to say, I rescind the contempt. I find that I have an irreparable conflict now on this file.
And I
need to recuse myself. But the last thing I'm going to do on this file is I also think that we need a mistrial. Or I need to recuse myself, and I'll leave the question of whether a mistrial is necessary to the next
job. Yeah.
But honestly, if he declares a mistrial, nobody's going to, like, I don't see how they don't have a mistrial here.
Oh, they definitely should have.
Millions of dollars of taxpayer money is being spent in this trial right now.
Tough shit, mistrial.
Yeah.
No, but that's what I mean.
And that's also why what he's doing is so wrong.
Yes.
Because he's dragging out something that ultimately, I don't know much about the evidence other than watching Mr. Copeland's testimony. I haven't seen a lot of the evidentiary testimony. Mr. Copeland's a terrible witness for the state, but whatever. Aside from that, if he gets convicted, if they get convicted, I don't know if they will. I don't know the strength of the evidence. This case is coming back on appeal. So you've just wasted all this money trying this case all the way to a verdict to have to do it all over again as to all of these defendants. So say it cost $1 million, just, wildly throwing that out there to try this case to verdict. It'll cost another $1 million to try it to verdict again. That's the problem. You have to end it now. Stop it now.
And if we're worried about the money, we can just dock the judge's pay.
Oh, absolutely. That's a good point.
If we take half of his pay from now until
I have so more things that are going to piss you guys off.
2092, then we'll begin to have made a dent in the cost of this trial.
Just trust the trial lawyer and me that I'm going to bring it out. Like just trust the trial lawyer. We're going to do it.
so you can go ahead.
Trust the hungry lawyer in me that I'm getting more pizza.
More about prosecutor or anyway. This is a record. This is important.
Okay, but it's your allegation and assertion, sir. Okay, so, well, we don't know that. We don't know whether or not they're true.
Going on.
Well, then tell.
Mr. Copeland comes in the courtroom or out of court, he's escorted by a DA's office investigator. You see that? This court is observant. You're not just sitting there in a cloud. You see exactly what's going on. You hear the prosecutor tell you, we were in a room with Mr. Copeland and he said these things. Why?
Okay.
Why do I have to bring it up? You should be bringing it up. This is crazy.
Yeah.
This is like communist Russia.
Yes.
Mr. Williams is having the worst trial. So I am moving again to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct.
Oh, but you've also accused her of shop, so you can go ahead and.
So we have the communist Russia comment. Then, it's one of my favorite clips. Give me 1 second.
I love the communist Russia comment because that's exactly right.
It's pretty good. One of my favorite clips was this one. What's a summary of where we are in these proceedings so far?
I can give you a summary.
No, it's here.
Message.
I'm just looking for my summary machine.
See how any conversation with Detective Thorpe.
I understand you can slow it down, but I'm gonna keep asking you these questions. Do you recall texting or telling Detective Thorpe that another guy called you and said that those people were just lying?
So here's my summary.
That's the end there. I wish it did. I wish it did. But it doesn't. It doesn't end there because this
is so embarrassing.
he's now my favorite. This guy's now like I thought.
Oh, we can't hear you, Rob.
Oh, hang on. Why?
And I don't know. It looks like you just briefly went underwater. I don't know how to
Can
describe
you hear
it.
me now?
Mm-hmm.
Okay.
Oh, and they're asking to please turn up the court volume. Mm-hmm.
I can do that. Hang on.
Okay,
Maybe.
cool.
Court volume bumped.
Nice.
I
love this witness. He's now my favorite witness.
He still coming to grab me. Every time they grab me, I had a different story for them. 100% facts, and I'm telling you now, I was not truthful. I was saying whatever they wanted me to say. I was saying whatever I could come up with. I was trying my best to convince them that I didn't do nothing, that I'm an innocent person, and that people put their hands on me. When they ask me about any of these things, you sitting here keep asking me step by step by step by step. And I'm telling you now, because you asked me, was I being truthful?
Okay.
I know I wasn't being truthful.
So is your testimony today that you lied in every interview that you did in 2015?
See,
based on his facial expression and how he responded to that, yeah.
Yeah. That didn't need any clarification. He said every time the police picked me up, I lied to them. I told them a different story. It's not ambiguous.
But he makes it clear.
The way you asked me that, I don't recall what I was saying in the interviews, but I'm telling you now, when they was questioning me 2015, 14, whenever they was questioning me, I was lying. I was making up stories. So when they were asking me about this right here, I was making it up. When they were asking me about this right here, I was making it up. And when they was getting me and they would let me go, I'm just telling you.
Do you recall telling every detective?
Every time they got me, I have told the police, I tell y'all whatever y'all want to hear, just let me go.
Do you?
The most honest testimony I've ever heard my entire life.
And it's the fact that she couldn't believe him when he was like, she was like, but they said to tell the truth. And he was like, but they're the police. So she doesn't understand that inherently people involved in criminal activity are not going to tell the police the truth. And that's the problem with snitches. They're not telling you the truth. They're just saying what they need to say to get out of the problem. They're serving themselves, which is fine, but it means that you don't have a credible witness on the stand. He's just saying the quiet part out loud. You call us in so that we can lie to you and give you what you want so we can get out of this. In that moment, he's being so honest with her, but she didn't know how to accept it.
She can't, because she needs one version of this testimony to be true.
And
it's one specific version.
Exactly.
Not a case of mine, but I did get to see a clip of like an interview with an accused, and they basically said, so you told us all this stuff in this previous meeting, and we've investigated it and we have some questions. And he says, yeah, none of the stuff I told you was true. And they're like, well, then why did you say that? And it's like, because the arresting officer was really hot and I kind of wanted to impress her by pretending I knew all this stuff. I was just like, wow. That is a guy being straight up honest.
That's honesty right there.
It didn't work out for him. He didn't get with that officer, but
this is honest.
All telling every detective in every interview, you got to believe me. I'm telling y'all the truth. Okay.
This sound like me.
Do you recall telling every detective?
Yeah, that sounds like me. He's
like, yeah, that is exactly what I'd say if I was lying.
Yeah. That's something I said when I was lying to the police so I could get out of it. So I wouldn't be in trouble.
And so when you watch Copeland testify, it makes the allegations of what took place in that ex parte meeting that much worse. Because it just shows that, like, it's not just the prosecution that was aiming towards one version of that testimony on the stand. It was the judge.
Yeah.
How is this trial going forward? How is this?
I don't know. It should stop because he's the key witness in the case. He's the one that ties it all together. That means there is no case.
And if the judge is preferring one version of things, wants this guy to be cooperative with the prosecution, that is clear bias on the part of the judge, because the judge shouldn't care who wins or loses. That's the judge's literal job, is to have no opinion on that, and just run things fairly. And so if the judge is found at this stage in the trial to have had his finger on the scale, then you have no remedy other than a mistrial, because he probably had his finger on his scale the whole damn time. And there is no way to save that. Every single decision that this judge has made in this trial is now suspect and can't be relied on. So end it, because
would you say that
it's over? It's done.
His trigger finger on the scale?
Is this the trigger finger we speak of?
This finger on the scale that we're talking about? Solid move, Natalie.
So good.
I love that movie.
Hey, Dr. Barry.
So let's catch up on questions, because I know that we got it. Oh, you know what? There was one more clip. Hang on. Wasn't that one?
I'll stay for the one more clip and some more questions, and then I got to dip. I'm literally falling asleep as I'm sitting here with you guys right now. I'm so tired.
We're that boring?
No, I'm that old. I have a bedtime.
I'm just being a jerk. That's all.
It's a natural thing. Here. So some of the questions. Just Jill, would this be something the U.S. Attorney General would look into? Realistically, no. Well, no.
Maybe should be.
This is state courts. This is Georgia. This is the Georgia Ethics Committee, like on judges. Like, they have a judicial panel that looks into it. So they're going to be the one they're going to do it. RICO in Fulton County, but not YSL. There's a couple of these things going on. Natalie, you have to give us an update. Sandy says, subscribe to Natalie, which again, top of the chat.
You guys are so nice.
Natalie,
Thank you.
Over 150,000.
Wow. It's up to 149,846.
Oh.
Whoa.
Come on, guys. We can get her to 150 by the end of today.
Get
on that, folks. If you haven't subscribed, do that right now. You might be that 150,000 mark there, and wouldn't that be awesome?
And you know what's great about us practicing lawyers? We don't inundate your feed with all these notifications because we have a lot that's going on. We can only do like one time a week.
Right. Yeah. Like, or I can get like a slew of uploads up and then go kind of quiet for like 2 weeks because I'm in trial. So
Yeah.
trust me, I won't be spamming your feed or anything like that.
Rocket Fish asked the question. Judge keeps saying appeals court will deal with it. If forbid they guilty, they sit in jail for years. Yes.
Mhm.
Yes. Yes. It's really horrible what he's doing. People's
Well,
lives
and
are at stake.
allow me to repeat the mating call of the appeals court, which is, this was a harmless error. This was a harmless error. He was going to get convicted anyway. And we know that because he must have done it because he got convicted in this trial that's full of errors that we know were harmless because he got convicted. So, yeah.
Yeah, there's many ways in which appellate courts help out judges in the trial level when they commit error. And that's one of them, finding that it's harmless error. So,
Especially in
It's
criminal
bad.
cases.
especially
Couldn't the defense lawyers contact the bar immediately? Are ethical violation? Here's what the bar is going to do. Give us a formal complaint and we'll investigate it. Maybe. Natalie, have you ever seen a judge in your jurisdiction go up on an ethics review?
Yeah.
Yes.
Yeah.
That's a yes.
Yeah. I can't talk about it.
That's a fair response, but we got a yes.
Yeah.
So it happened.
But it's one that makes me even more curious.
We'll talk off of here. I won't I
Fair.
can't talk about it on here. Yeah.
Yeah, no, that's entirely reasonable. And
Yeah.
Angie makes a comment. Sunny off topic, not anymore. On a lighter note, Rob, did you hear, or Rob or Nat, did you hear Steele tell the judge this is like communist Russia?
Yeah. My favorite thing he told the judge, Angie, was he was making an argument. He was like, this honorable court. Oh no, I'm sorry, this court. And I was like, oh, burn.
I honestly bet if you put Steele and you actually asked him whether he would say that again, he probably would say, no, that was me being pissed off. But it was a solid burn in the moment.
But we still got it. Just like when Mr. Jackson, when he was cross-examining Trooper Proctor in the Karen Reed case, at the end, he goes, shame on you. He shouldn't have done that. And I'm sure that he wishes
he did that
could have
entirely on purpose, though.
Oh, no. Yeah. It wasn't like heat of the moment. Like he planned to do it, but he should not have done that. So probably in the future, he'll regret it. But I'm glad he did it.
I thought that was a badass move. And yeah, I will 100% give him that one.
I think it depends on what the jury's giving you. If the jury's giving you like the nodding, like the can't believe this, then you drop the comment. But if the jury's stone-faced,
I mean, technically you shouldn't drop the comment at all, but yeah. He said what I was feeling, so
yep.
Even here in Alabama, Fulton County has a reputation of being crooked as hell. People drive around it. I'm not driving through it.
I'm getting like this list of counties that I'm avoiding, like Canton and Fulton and
Angie, after hearing all the context, this is like communist Russia comment Steele made is no longer funny. It's just a reality in this court, in my opinion.
Wow.
I mean,
it's true.
Communist Russia, he probably would have gotten more procedural fairness than they're getting here.
It's just how it's on TV and on YouTube, and we can all see it happening, and he's just doing it. He's just going full on unethical judge in front of our faces, and it's driving me crazy. We can see you, Judge Glanville. Cut it out.
Yep. Entry required says judge says every
like a child. He doesn't realize we can see him if he's not able to see us. He's got no object permanence for the for those of us out here.
Judge says every defendant can make a motion to recuse and halt the trial. I sort of agree, basically saying you shouldn't be able to do this. I do. But a peculiarity of Georgia law says that explicitly. Yes, I did look at, there's a couple Georgia lawyers on Twitter who are covering this case like really closely. And I saw a bunch of breakdowns of the fact specific law on this issue. And apparently this is one where it's a mandatory, like he cannot review this motion. So
yeah, he's going to find a way to bullshit that though.
K-Rab, he keeps saying appeal. Appeals court has already punted to the Georgia Supreme Court based on the fact that the murder trial. SC has already acted on the jail for contempt. It's been stayed. That's a catch up on it's a different aspect of this. Steele held in contempt, sentenced to 20 days, which he has to serve every week consecutively for 10 weekends. He, despite what the judge says that he couldn't appeal, he did appeal. The Court of Appeals in Georgia says we can't handle it because the underlying matter is criminal, and they kick it to the Supreme Court. At the same time, he had filed a motion for an emergency supersedious bond, and the day that it gets kicked up to the Supreme Court of Georgia, within about an hour of the matter being before the Supreme Court of Georgia, unanimous decision by the Supreme Court, except for the one judge they couldn't get a hold of, saying, here's your supersedious bond. So he is not in jail this weekend with his client, which made for good photos had he been there, but
yeah, he's not going to jail. The Supreme Court, or whoever, is it the Court of Appeals or Supreme Court that took it up?
Supremes took it.
Say it again?
The Supremes took it.
Oh, the Supremes. Yeah, he's not. They're going to overturn that contempt. It wasn't done properly.
Yeah. Rachel Dueck, is it still possible to tar and feather somebody?
I mean, legal or possible? Because those are different things.
Right. Not legal.
Elise Charlene, love that Natalie is here. Where's Ian? He's also here.
Hi. Ian.
ZZXXZZ. Does this mean more of you will start covering live thug trials? Some of us are on day 92. I can't cover this thing every day. They, based on my understanding of today's testimony, they had today's proceedings, they had 90 total minutes of testimony for a full day of court. I can't do that.
Nope. Can't cover it live. You have to wait until it's clipped. It's an inefficiently run trial. It almost feels like it's like money laundering or something. Like they're in there for hours and hours and weeks and months and nothing is really happening.
No, they get through like one witness in a week.
Yeah.
Tracy Sires, please forgive me if this has been answered. I just joined. What is the judge so worried about them knowing? Natalie,
that he behaved incredibly improperly.
Yeah. That's it.
Kelly Mack, would an interlocutory appeal be possible, or does Glanville have to okay that, or would that not apply here? This is a good opportunity to talk about the certification for the immediate appeal. During the pendency of trial, if you were to allow people to appeal every decision right there in that moment, the trial would never end. So the Court of Appeals has rules on what you can and cannot appeal in the immediate part of the trial. And you can actually ask a judge to authorize this for immediate appeal because it's such a significant issue. Some things the judge has to, some things the judge doesn't. This apparently is permissive, so it's not available here unless the judge says it can.
So the one who is accused of committed the ethical violation gets to decide whether or not his ethical violation is reviewed immediately or not.
Got some sort of problem with it.
Yeah, sounds like a bit of a conflict, wouldn't you say?
How is the prosecution okay with this?
Oh, they love it. They love it. They just care about the conviction. The fact that I always had an issue with this case when they were playing rap lyrics in the trial and stuff like that. This case is not a serious case to me, so they love it.
I mean, if I was a judge, I can say that, like, you know, if you want to bring lyrics in, you've got to really have a good argument. Like, it's got to be something specific, like, hey, I'm the guy who killed Bob.
Yes.
You know, like, if it's a confession in musical form, cool. That's fine.
There's only one time. Go ahead. Sorry.
But if it's just like, you know, rolled up with my gun, bang, bang, I'm like, okay, so that literally applies to every drive-by that's ever been. And at this point, like, you know, 80% of rappers could be convicted for any particular crime you want to name. Like, no.
No, absolutely.
Finishing their mark, all the work they've done for this trial, and they're going to let it all get thrown away because this judge, they don't care. They really don't.
Care.
And they never do it to country singers.
And Natalie, I'll let you go. The last one is this one. If it was Copeland's lawyer, is she breaking attorney-client privilege?
Maybe.
Yes, unless her client gave her permission to disclose, which is very
Which
possible that he would have.
Would.
Yeah.
Yeah. Before I go, I hit 150,000 subscribers. Wow.
Yes.
Thank you so much. What?
Well deserved.
Thank you.
You
I
gotta
know.
have a celebration now.
I knew it would happen. Congrats, Natalie.
Thank you,
deserve it.
Rob. Thank you, Rob's audience. You guys are amazing. Oh my gosh. I'm in disbelief. Thank you all so much. All right, I'll see you guys. I'll see you guys later.
Fun.
Okay, bye.
Bye, Natalie. See, we can do some good stuff too. That was awesome. Awesome. Let's see. What would happen if defense attorneys essentially strike? They won't. They can't. They're ethically prohibited from doing that. If they strike, their defendant gets essentially jailed. The Chugi Show. Oh, I'll pull that up later. Casey Cat.
There are ways you can strike, but they're not very effective.
It's not going to get you anywhere. We all talk about Glanville, but what about the prosecution team and their part in all of this? They asked for an ex parte meeting where they sworn witness. I think they're equally culpable. The thing is, I kind of expect that from the prosecution, not from the judge.
Disbar everyone and rebuild.
That's the frustration. Alex Davy Duke discovered Natalie lawyer chick a week ago or so. A week or so ago, and she was talking about the Karen Reed trial. Natalie and Andrea Burkhart are the best. They are. I love all the people that I get to deal with on this, and I watch them too, guys. I end up in their chats a lot, including Ian's when he does his recaps.
I was like, am I chopped liver here?
And I'm in your chat all the damn time.
I know, I'm just
Girl Rye, I transcribe courts full time. I'm thinking Baldwin. Rough estimate for transcript for 6-month trial, average 6 hours per day. Georgia per page rate is $106K, assuming average 6 hours a day at 20 days per month. Okay, that's not income.
that's just for the transcripts.
That's the transcript only. Yeah. Rachel Duick, motion to give Thug Judge a one-way ticket to the moon. How about just off the bench? I'll go with that one.
I mean, the moon is off the bench.
It is. Dead Weight Gaming, dear Judge Glanville, don't cling to a mistake just because you spent a long time or tax dollars making it.
That sounds like parenting advice.
Kind of does. J. Michael RN, hey, it's one of my favorite law tubers. Welcome to FNF Natalie. I was glad to have her join. I love her take on all this stuff. It's a shame that she, works a full day and can't hang out with us more and get more angry and all the irateness, but we got more to cover. Pam Bystrack, I heard the same thing. Val did say Huckleberry, but it really should have been Hucklebearer. Who knows? We'll see. I'm going to look it up later. Moonshot.
Not true.
35. Do we even need comedy and drama as genres anymore when real life exists? I don't know. We all been drinking the bad water for the past 10 years. I don't know. We're about to transition to the Karen Reed expert, and what are we, an hour 27 in? I'm going to go ahead and grant.
You got to stall us about half an hour for that.
No, I'm going to grant early permission to swear because I am so
okay, good, because I've got words. Most of them are 4 letters.
I talk about Bruno. This panel is as delicious as that pizza and that peach and that Gobi light. Doc gave me the yucky news. Like Eminem, it's back to the lab again. Well, hopefully the lab will get you back squared away and in order, and hopefully that recovery goes well. I really do hope that that's going okay. Bad news is brutal. Oh, this is a good update. Positive update. Caitlin, shoot. Special Olympics update from last FNF. 6 gold at powerlifting, 2 at bocce, and 2 at track. I'm one proud coach. They saw your toast and they were blown away. Thank you so much.
Amazing.
YouTube and this community. God, I love those things. Thank you for sharing that. That is so awesome. That made my weekend. Oh, God, that's so cool. That's so cool.
Yeah, it's all downhill from here, Rob.
Well, we're going to get yelling. I need a new mule. Any suggestions?
Make it with gin instead of vodka.
Ooh, that's a good one. I don't know if I agree, but sure. Raven 254. I just have to ask. I don't care if you're a prosecutor or defense, but how isn't it the right thing to do to disclose this ex parte?
I don't know why they had an ex parte anything. This is the kind of thing where, unless it's like my client, if I'm going to have a powwow like this with a witness, I've had prosecutors literally say, hey, I need to talk to my witness, and I want you there. So, yeah.
How can a prosecutor sit quietly by when this happens? Because they do.
Not all lawyers are good people. I know this is shocking to hear, but some lawyers are not cool. Yeah. I know it goes against all of the reputation lawyers have. Everybody thinks of lawyers as like, these saints, and I'm sorry to burst your bubble on that, but yeah.
Karate Cat Mom, Natalie, are your trials broadcast? I will have to ask her if she ever has one. If she does, I doubt that she'll actually share it with us, but I'll see if I can't track anything down. Billy Steins, won't defense just ask little Woody what was said in the judge's room? Yeah, they probably got that information from him. Bop it, but are nice here in Douglas County, Georgia. I have no doubts. I love a lot of Georgia, man. Lexi, he does it because there's nothing anyone can do.
I mean, there are people who can do things. It's just they're going to have to do it.
Yeah. Mindy FS, my favorite way to spend Friday night. Thank you for being here. Lady Draconis, I swear, as court streams get popular, it became a competition of who has the most hold my beer moments. I live in Georgia. This doesn't surprise me at all. I couldn't believe this was broadcast and then doubled and tripled down on. It was pretty wild.
Oh, I mean, it's one thing for a judge to F up. It's another thing for a judge to F up this badly.
And put it out there that strongly.
I did watch a trial at one point where the judge lost his temper and ripped into defense counsel, stormed out, and then came back and said, I think we need a mistrial. And like, that was the much better move. Now, to be fair, I would have yelled at that defense counsel too. So
some of them deserve it. Sandy, thank you for congratulating Natalie. She hit 150K. She did. Dean coming in and saying the same thing. She did. She had 150. That's you guys. You guys congratulate yourselves for doing that for her. She deserves it very much so. Crazy Cat Queen subbed to Natalie with all 4 accounts. I love it. Dina gifted memberships. Thank you so much. And welcome to all of those who received gifted memberships. Zoe B, FBI, Gray Lord case, Chicago. This looks like that. I'm going to have to look that up. The Gray Lord case in Chicago. Okay.
That sounds distinctly creepy.
John Common, where's our expert Nick? I don't know where Nick is. I know that Nick probably lost his mind and has been losing his mind. John Duncan, is Runkle's favorite exercise running to the front door to greet the pizza delivery guy?
I mean, I wouldn't say it's my favorite exercise because that implies I have to like an exercise, but
that's a lawyer's answer.
I've actually started trying to jog again, and it's not going well, but that's the point of trying to jog. So
Mary Coppola, prosecutors are under Fannie Willis, speaks for itself. It's been a wild prosecution. SB Farmer, another lawyer check 150 subs. Is Nat single? Nope. Happily married. K-Rab, Nick Stero is covering it close to live as possible. Good recommendation. Check out Niklas. Niklas Stero Trial Watch is the channel. He does the Young Thug stuff all the time. So check that out. Light Queen, congrats Natalie 150. Amazing. Let me do this. Let me see if there's any questions because I want to get to the Karen Reed stuff. Grammy 68, won't it bring up mistrial possibility if defense brings up ex parte in front of the jury?
They can't.
And that would be not beneficial.
The defense can't provoke a mistrial.
And it would be prejudicial because you'd be bringing it up in front of the jury. So, no. Yeah, I can't see that benefiting, and I really don't see that happening.
No, it's just not going to be a thing.
Megan Easton, how often do you see a judge grant a recusal request? Not often.
I've had it.
Voluntarily, or was it mandatory?
I just raised the issue, and the judge was like, Nope, solid point. Recusal. The judge had presided over one of my client's previous trials. And I just said, now it helped that it was just a matter of like they swapped us to a different courtroom. It was like the same day. The judge was just like, no, that's fair. I'm going to send you to a different courtroom. And me and a different group, we just traded courtrooms for the day and traded judges. So it was no big deal. But
Tracy Fagan, I received my call this week, breast cancer free 7 years.
nice.
Congratulations. That's an awesome achievement. Way to go. And the last comment I'm going to pull up before we shift is, well, maybe I chose shift appropriately. Die Hard, hail to the Redskins. How'd your drive test in the parking lot go? So,
What's
fun
this?
story. There was testimony today in the Karen Reed trial about the vehicle. We finally had an accident reconstructionist. We had 2 experts today that were probably the forefront of today's testimony. First expert I liked. She gave me a good explanation of why Jen McCabe's phone showed the search. And honestly, based on that person's expertise, I buy it. Okay. So giving that the benefit of the doubt, good expert, not a whole lot to cross her on. We're going to wait until we get to the defense's expert because it's going to be a battle between the experts as to who you believe or don't believe. The next expert. Well, based on the prosecution's case, the Commonwealth's case is that Karen Reed was traveling in reverse. Let me swoop to this. We're going to swoop to this. Chat's reminding me. We're going to swoop. Double swoop. That was the intro. That was not.
Yeah, that's not the right.
All the buttons. So,
Have we got the buttons mastered?
I don't. I love you. You're a good friend.
Rob's like, you bastard, but still.
This expert, Karen Reed was traveling in reverse at 5 miles an hour, almost 25 miles an hour, and traveled in reverse at 25 miles an hour for, I think, 97 feet. So I was really curious because 25 miles an hour sounded pretty damn fast. So can I get that? So on my way home, school is out. So I pulled into a school parking lot, put my truck in a position where I could make a reverse.
Wait, you did this in a school parking lot?
Empty. But don't do this. Don't say that. Just we're gonna let me. Yeah. So I threw the truck in reverse and tried to slam on the accelerator to reverse as fast as I could to see if I could get up to 25 miles an hour. I got to 19 before I felt remarkably unsafe. And that was like the car, when I parked, the steering wheel wasn't completely dead on a straight. So when I hit reverse, it started shifting this way. So when I started to try and correct at about 12 miles an hour, the correction does a quick correct because you're doing reverse. So I'm going, how the hell did this person get to 25 miles an hour? And at that point in time, I'm going, how'd they aim at 25 miles an hour in reverse?
Oh, I have a theory.
Go ahead.
You ever driven in snow?
I have a theory too. We'll get there.
Which is your wheels might be doing 25 miles per hour, but you might be doing not so fast.
And that we're going to get to that part of the testimony because we had an expert testify today and I had a lot of questions. So now let me remind you where I am on this trial and where I've been the entire time. I don't particularly buy into one way or the other. I don't care at all whether something is, well, let me rephrase that. Officer O'Keefe deserved a hell of a lot better than this investigation, period, end of story. And it's sad that he was taken from this earth way too young and that the children that he was raising are deprived of his role in their life going forward. That said, the prosecution has a burden to prove that the person they are putting on trial committed these acts beyond a reasonable doubt. So when I'm viewing this as a lawyer and I say I don't care, it's not that I don't care for the underlying facts. It's I'm viewing this as a lawyer and the burden of proof. So the defense doesn't have to prove anything. They don't have to prove a damn thing. They don't have to disprove the prosecution. They don't have to do anything. The prosecution has the burden start to finish to prove beyond any reasonable doubt that Karen Reed committed the acts that she committed. And I have felt that the prosecution was falling remarkably short on that throughout the entire trial. And actually, today, I got one of the questions answered. What day was today? Today was day 25?
Yeah.
Today.
Well, it was day 16 that they actually finally called evidence that John O'Keefe was dead.
Well, and today was day 25. We heard opposing counsel in opening statements, or the defense counsel in opening statements, make the comment about Jen McCabe's search. We heard from Jen McCabe in what, week 2 of trial?
Yeah, that expert should have been immediately after Jen McCabe.
Right.
Like 1, 2. I have no idea what Lolly is doing, calling them so far apart. It's insane. Like, there is no justification for that decision that I can possibly imagine.
And let me be clear. That expert's sole purpose.
Correction, there is one justification.
What's the justification?
If he just really, really hates Jen McCabe.
I don't know. But that expert's sole purpose, which they knew about for months, the sole purpose was to explain why Jen McCabe's phone showed this search at 2 a.m. And the expert was credible AF. Testified to the extraction method that was utilized, testified to how the data was maintained, how different extraction methods show different things. Their conclusions were rational, logical. They were connected via logical connections that were there, proven in evidentiary format. I mean, the testimony was fine. The best
played a few little games with her testimony.
There was a few, but the best thing about the testimony was Lolly stepped out of the way.
Yeah, there were a few places I was like, you're not explaining what that means, and I know why you're not.
And that was the defense's job. Their job is to jump in there and explain that in cross, and they get to.
I don't think they did a great job on the cross on that one.
I think
yeah, they're going to let their expert do it, but I was like, I wanted to see more cross.
Yeah. So at the very least, here's what I have. I have a logical explanation that I received 2 weeks after Jen McCabe's testimony. But I have a logical explanation. So there I am. I now have an explanation for that testimony. What I've been waiting for is an accident reconstructionist.
Hey, we get one of those today.
I don't know that we do. We got somebody.
We get an accident reimaginationist.
Before the ME, which pisses me off.
Are we even going to hear from the ME?
I don't know how you can't.
I mean,
let me explain why I'm pissed about this sequence of events. The only explanation we have of John O'Keefe's injuries are what was observed by the first responders and what was reported by the cops. That's it. So we have that understanding. So I'm left viewing this accident reconstructionist with the understanding that I have in mind, in that there are not abrasions, straight up cuts and gouges in his arm, that there's no bruising or broken ribs, no bruising on his chest, midsection, hip, legs, and that there's bruising, noticeable bruising up by his face.
Now, I have a theory for how this happens.
His head. Explain the theory. I want to hear this.
So she throws it into reverse. She guns it towards him. The Lexus grows hands and starts fighting him. And then the Lexus also has a dog that jumps up and bites him.
The one point of the dog comment that I really do actually understand is that there's no, if you look at his arm, there's marks here, but there's no lower jaw marks from where a dog would grip. So I get that part. But don't tell me that those marks are made by a cracking of a plexiglass tail. Where's the bruising on the body? You're saying that this impact was sufficient enough to send him spinning and thrown into the snow, but there's no bruising. And mind you, his heart was beating for hours after this collision, which would mean there would be blood that would be pooling in those areas.
Oh yeah, there should have been bruising.
So I am remarkably confused. And like I said, if I was a prosecutor prosecuting this case, I would have the ME come out and show those pictures and describe in detail the injuries that are there so that when the accident reconstructionist comes up, all of a sudden I can see the accident reconstructionist come and match those bruising and all those things to what I just saw. But we didn't have that. We had this. And I'm going to be very honest. This leaves me with so many questions, whether it's in the way that this witness explains his conclusions or what. But Lolly is still on direct beginning in Monday. He better clean some of this shit up. So here's the witness.
I mean, direct is kind of a generous way of describing his particular style of conducting examinations, but
longest questions I've ever heard in my life that don't make any sense. I've never seen questions this frustrating to listen to. Like
he's not on direct, he's on first rambling.
That includes Elaine Bredehoff. Yes. I hate so much. Oh, I did want to show this beforehand. This was presented by the witness yesterday of the camera that apparently captures Karen Reed's vehicle. So I want you to look at the conditions, and this is at midnight. And I think that the prosecution's case is that this transpired at what, 12:30 a.m.
This is super exciting.
To the testimony of snow being beneath the body,
and
look at the streets being covered in snow, because it's both relevant when we talk about what we're about to see.
Yeah.
Let's see. And play.
The court adjourned in case I guarantee the truth, the whole truth, and nothing but the truth, so help me God.
I do. Good morning.
Good morning.
No, we're not doing this. No spinning wheel. Come on. Come on. I need you to behave today.
I mean, it doesn't matter if you're talking to me or YouTube. The answer is no.
All right. Whenever you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for the jury?
Trooper Joe Paul, that's Paul.
And how are you employed, sir?
I am currently employed.
People in the chat are saying turn it up. Do I need to boost the volume even more?
Yes.
Okay, max boost.
Also, Potter is annoyed at me.
Why?
Because I have not yet given him my pizza crusts.
Why are you depriving your dog? Don't deprive my client of pizza crust. Give him the pizza crust.
All right, give me a second.
So
I need just like a little bit more lead on this. So I can sort of reach, but it's pain. Nope, we're gonna do
this. Is great. We're just gonna watch Ian struggle right now. Yep.
Potter, Zora. Come on. Come on, Potter. Hi, Zora. Hi.
This is the palate cleanse, guys.
Okay, Potter, come on.
Come on, Potter.
Potter, it's your turn. Oh, fine. Potter's being camera shy.
That's fair. Ian's going to go feed the pups. Come on, Potter.
They were getting pizza.
Ready? In ears, back in. And we're going to go to 1.25 with this witness until we get vehicle testimony.
So Potter was like, I don't want to come onto the camera. He's like, I'm shy. Zora, on the other hand, is like, I am climbing up onto your lap. He's like, I demand that crust.
Okay. Ready?
Yes.
With the Massachusetts State Police.
And how long have you been a trooper with the state police?
I have been a trooper for approximately 8.5 years.
And
Or sorry, 12.5 years. My apologies.
And where is it that you're currently assigned within the state police?
I am currently assigned to our collision analysis and reconstruction section, otherwise known as CARS, our recon.
And how long have you had that assignment to the reconstruction of cars?
That was for about 8.5 years.
And with respect to your assignment to that unit prior to beginning with that unit, let me ask you this first. As far as the cars unit is concerned, about how is that sort of divided up as far as is there certain regions that you would specifically cover?
Correct. We have four separate regions across the states. We have Southeast, the Northeast, Central, and the Western.
And which of those are you assigned?
I am assigned to the Southeast.
And geographically, how much territory are we talking about that the Southeast covers?
Anywhere from Boston down to the Cape, Martha's Nantucket, anywhere southeastern part of Massachusetts.
And currently, how many troopers are assigned to this specialized reconstruction unit within your Southeast region?
Within our Southeast region, we have, I believe we have 9 now.
And is there some kind of on-call system that your unit operates by?
Yes.
Can you describe that to the jury?
So we rotate every day. Our on-calls are for 24 hours from 0700 to 0700 the next day.
Can I make a comment?
Now, with respect to yourself,
You may.
Isn't it weird that I have more hair than the entire, like, Canton whatever police force?
I mean, I wasn't going to say anything, but why are they? It's a like, is it a trooper thing?
I'm just reminded, if you play the first Hitman game, there's a level where basically they had a bunch of the clones, specifically 47 of them, and you have to fight the other 46. And they're all kind of like, you know, bald looking dudes just like yourself. So I'm kind of thinking that I'm reminded.
So we're going to fast forward to the beginning of this, I guess, the substance of his testimony. Accident reconstructionist, trooper.
A vehicle, usually at me, that's a collision. So where this vehicle first stopped. And a controlled final arrest is when an operator actually controls the vehicle to the stop.
All right, so crash versus controlled arrest. Controlled arrest being you stop the car.
And as opposed to the uncontrolled final arrest is when there is no control, usually acted upon by outside forces that will control the vehicle or pedestrian to its final rest.
and Your Honor, with court's permission, if I could publish what's now been marked as exhibits 584 to 587 for the jury.
Yes.
Ms. Gilman, if I could first have the diagram.
This is really going to piss me off.
As it should.
Have you gotten spinny wheels during recaps?
Oh, yes. And it sucks every time.
Every time.
And Your Honor, just to return the exhibits to the witness. Ms. Gilman, if I could ask you to zoom in just a little bit on that.
All right, here we go. So there's Fairview Road. Here's 34 Fairview up top left. Here's the road. This is which I don't know why they were allowed to designate this glass cup. I would have objected to that being the descriptor in there. Then they have these plastic designations, which you can't see the arrows, but they're basically between the blue text and the pedestrian shoe text, right? So it's right there in the middle. Call it like on the curb area of the drive. John O'Keefe is over here. Like a little bit to the left and up from that. And I know that they're going to zoom in. Let me see if I can't actually. Nope, that doesn't want to do that. So let's wait till we get to the next exhibit, because the next exhibit is zoomed in.
And now, Trooper, what you have up on the screen is that what you have before you as first in that exhibit.
Yes, it is.
Now, using the laser before you, if you could, I would ask you to draw your attention or direction to what, if anything, of significance you have noted within this diagram.
Okay.
Oh my God. I want to draw your attention to what, if anything, do you have highlighted of significance in this drawing? Trooper, did you identify anything in this drawing that you want to draw to our attention? It's not hard.
Trooper, tell us about this drawing. Also just works.
Yeah.
Like, I assume you've done more than like 6 seconds of prep with your witness. So, and I assume as well that your witness actually likes you. So like, hopefully your witness is trying to be cooperative, at which point you can, you can just do that.
That doesn't happen though.
Okay. So in this time, I labeled each part of evidence. So right here would be the pedestrian's final arrest, and they're all, since there's so many put together, everything was labeled with a red arrow. That would be pointing to where the final arrest is. And this is where a glass cup was found. And these are the red and clear plastic pieces. That's where they were found. And pedestrian shoe was found here. The smaller versions here in the light blue is one of the fire hydrants, the flagpole. This is a label for the street 34, and obviously the street name Fairview Road here.
Now, as far as measurements were concerned, what, if anything, were you able to do to measure sort of between different points of roadway evidence, or specifically from the pedestrian or Mr. O'Keefe's final arrest in reference to other items that...
This testimony should have taken 2 minutes. 2 minutes.
That's not how Lally rolls. I like the people who've nicknamed him Lallygag.
With respect to measurements, like, you're aware that there are measurements that existed like back when we had cubits, and now we use feet, and some places use metric. With respect to those things that I just said out loud, is there anything you want to draw attention to measurements, or possibly how did you equate distances between objects that maybe you found or didn't find? Your questions.
that you have to pick on back?
So we're talking about Mike. So on these diagrams, I can hard to see here, but it is a scale diagram. The diagram itself is scale. Once you put a roll up to the actual paper, it's scale. I've also have on here, sorry to see, but there's, I think it's right here. They're called ground control points. They're little X's on the roadway. They are used for the drones imaging, and using the drone imaging will use those in order to help put the all the pictures back together.
Also, this witness is annoying because he keeps saying the thing, and then he says the thing again. And these are used for drone imaging, and so the drone imaging uses them. And I'm like, you just said that.
He didn't. He didn't say. There's a scale on here. Did you tell us what the scale was? So that
he just told us that it is to scale.
Like we can see that scale is like each one of those little blocks is like a 5-foot distance. Like, could you tell us what the scale is?
No.
At the time of this, I measured between each point from ground control point 1 to 2 and put it as approximately 50 feet. And 2 to 3 is 50 feet and 3 to 4 is 50 feet. So it kind of is a second way to measure off the diagram and also using the program to measure to different points while using the diagram.
And as far as starting with the shoe that you have depicted in this diagram, what was the measurement of the shoe away from Mr. O'Keefe's body?
I believe the shoe was approximately, I have my thing, it's approximately 10 feet away.
Your Honor, with the court's permission, may the trooper refer to his report just for the specific measurements?
Yes.
That means trooper, you guessed the wrong answer. So I'm going to tell you to look at your report to make sure that you get the right one.
Okay.
It's on trooper. With regard to the shoe, how far away approximately was that from Mr. O'Keefe's body?
9 feet.
And did you also have a measurement for how far away the glass cup pieces were from Mr. O'Keefe's body?
Yeah, 1 foot.
And for the red plastic, you have labeled on this diagram as A. How far away from Mr. O'Keefe's body was that?
7 feet.
Now, with regard to the directionality, you also measured sort of directionality as far as the 9 feet that the shoe was away. Which direction was it?
Each evidence was measured from the pedestrian's final rest. So the shoe was 9 feet southeast from the pedestrian's final rest.
And if you could.
Let me rephrase all these questions to a place that actually makes sense. Did you measure a distance from the victim's final resting place to the various objects that are shown on this map? What are those distances? None of this directionality, as far as what directionality is. Are you aware of the concept of directionality? I've never used directionality in a sentence until today.
But now you're going to use it all the time.
I'm going to use it in so many ways. Insofar as directionality is concerned, can I navigate you to the directionality of where I'm going?
What direction was the body from the other thing?
So we're going to fast forward because an hour later, we're still working on this one.
Sorry, what if any direction was the body from the other thing?
I mean, we did take a lunch break in between, but we're back from lunch. So now we're back from lunch. So the jurors are fed. Everyone's fed. So we should be running on like full energy. Let's see where we go.
The taillight that was covered on January 29th within this diagram?
No, I did not.
Fair to say you did also not put every piece of taillight there you were aware was covered.
Oh, baby. How many people are streaming the Court TV YouTube stream?
This investigation and depicted in this particular document.
7.
That's correct.
Now, with respect to this particular area of Fairview Road, understanding that you were there in the daytime, correct?
Yes.
However, when you were there in the daytime, what, if any, note did you take as to sort of overhead lighting or available sort of handy street lighting in the area?
Yeah, so on the top corner, I'll try to right up here, there's a light pole right there, overhead light pole.
And with relation to where you've marked as far as the final rest position of Mr. O'Keefe and the other areas of items of evidence that were recovered from the scene, was there any lighting in that particular area?
There wasn't.
Ms. Gilman, you can take that down. Mr. Officer, we can have lights back. Thank you very much.
Side note, that hurts Lolly's case. Like, it hurts it a lot. Did you not hear that part? As far as where the evidence was recovered, where the victim was found, was there any lighting there? No, there was not. So 12:30 a.m., no, there's no lighting there, but intentional. Just keep that in mind.
Very much so. Now, turning your attention, sir, back to February 1st, 2022. At some point, you were at the Canton Police Department, correct?
Yes.
And where specifically within the Canton Police Department did you go?
To the back in the garage area.
And within the garage area, what if anything did you do in the garage area?
In the garage area is where we imaged the airbag control module.
And so, I'm sorry, it's fair to say the vehicle, the defendant's vehicle was located in that garage area?
That is correct.
And you imaged that vehicle, and what, if anything else, did you do with respect to that vehicle that day?
At that point, we just analyzed the damage to the vehicle.
Now, at some point, did you perform any sort of mechanical inspection of the vehicle?
Yes.
Was that day or at some later?
It was that day.
And was that within the garage area itself, or where did you perform the mechanical inspection?
We analyzed a little bit of the steering and the brake pedals while it was sitting in the garage. Then we did testing with it on the in the driveway next to Canton PD.
Now, sir, starting with a visual inspection of the vehicle. Your Honor, may I approach?
Yes.
So I'm showing you two photographs. Review those. Look up when you're finished. Do you recognize those?
I do.
And what do you recognize those to be?
They are crime scene photos that I've attached to my report.
Your Honor, the Commonwealth is to introduce in the minutes and next to exhibits.
Objection. Thank you.
Yep, sorry.
588, 589. Thank you.
Your Honor, may I return those to the witness?
Side note, I hope this court reporter gets paid so much more than every other court reporter I've ever dealt with, because I've never had a court reporter have to mark every exhibit as it's introduced for the record. This is wild. And then go right back to transcribing.
Oh, there's no right back to. She's just doing the transcribing at the same time.
Apparently I can't.
Witness?
Yes.
And Your Honor, with court's permission.
Yes.
Thank you.
Move it along, Lolly.
One moment, Your Honor.
While the stream takes a moment.
Did I attach my report with notations that I made on it?
And what's contained in this photograph, is that a fair and accurate portrayal of what you observed in the rear passenger side area of the defendant's vehicle in the garage on February 1st?
Yes, it is.
Now, step back a little bit here. With regards to what you've noted within this, if you could, using the laser pointer before you, just direct the jury's attention to what, if anything, of significance you observed in your inspection of this area of the Lexus.
Okay. So on the left side here, I put down that scratches, and there's a dent there.
Now, this is a preview for what I'm going to cover towards the end. This was an accident reconstructionist, and I don't know that this is what the defense knew he was going to testify to immediately. I don't think they were that caught off guard by it. But when we get to the very end of today, this little picture becomes a lot more relevant because there's some opinions that I don't know that we're going to get to. But yeah.
There. The broken tail light here was here. There's some scratches on the bottom right rear bumper here. And there was glass from a cutback on the bumper.
As far as the glass on the bumper, what, if any, observations did you make of that in relation to the vehicle itself?
Yeah, it appeared to be from a cup as opposed to any glass that came from the vehicle.
Objection. So I'll strike the first part of the answer, but the second part will stand.
I have no objection to the second part. Thank you.
Now, with regard to the dent that you've delineated within this photograph, did you take any measurements from the ground as to where that was located?
Yes, I did.
And how far did you measure the dent to be approximately from the ground?
Approximately 48 to 50 inches from the ground.
And what, if any, measurements did you take as far as from one part of the vehicle to the other, as far as where the dent was located?
Yeah, so it was approximately 19 inches from the right side of the vehicle.
Now, the scratch.
So vehicle looking on, 19 inches in from the right side of the vehicle is where those scratches are, and it's 40 inches up. I am 6 feet tall. 40 inches up comes to about here, right? Thereabouts, something like that. Like chest
Rob,
hair.
it's not polite to do inch measurements on a stream.
We were talking in the 40s, buddy. I'm not talking about.
I mean, you can brag, I guess, if you want to.
Yeah. No, so we're talking about this thing. So now the elevation. So think about this. Human man. So John O'Keefe, I'm 6 feet tall. I think he was about the same height, a little taller. That is right there, like chest, upper body area that he is being struck. So that's the crux of this testimony.
That you were talking about before, where were they in relation to the neck?
Right above the dent. I can see right there. That's my hand shaky.
Now, as far
Yes, I'm
as,
12. I'm
you
also very
obviously also
tired.
made observations of the driver's side tail light as well.
Yes.
And so, from what you observed of the driver's side tail light versus the passenger side tail light, what, if any, observations did you make as far as the color of the pieces that you found missing from the passenger side tail light?
Oh my God, Lolly, do you really need this? Do we see the picture?
Yeah,
on the screen?
that picture is in evidence. Just freaking move on.
Move along. I'm really sorry I missed this earlier, Britt. Britt with a very generous super chat. Not that my opinion matters, but the Commonwealth is closer to the end of their case than to beyond a reasonable doubt. So unless they can hit Candyland Rainbow Sugar,
Solid reference.
shortcut to it was absolutely her, they're a bit screwed. Here's the thing. I have made comments in the past. Start strong, end strong. I am not going to try and predict what the Commonwealth can do in the next 5 days, 6 days, 7 days. We still have the people in their case that they believe are the strongest bit of evidence. We still have that coming. If this is one of
They
the
started crappy though.
problem. Go ahead.
They started pretty crappy though.
Yeah. So they didn't start off strong. And based on where we are, I don't know where we are with this. Now, I want to fast forward to the part that left me with a whole lot of questions. We have some back and forth that goes on about the vehicle, how far the vehicle drove, the distance driven, whether it matches up with the map. That was objected. It was properly stricken. So you're not allowed to testify to additional miles driven. We then learn that essentially the airbag deploying, or the, what's it called? The ACW. That itself triggers there's some triggering events to that, but it only processes some limited data, very limited data, like is the accelerator depressed, did the airbag deploy, stuff like that.
And he also noted that we wouldn't expect to see any of that accident data because when you smuck a pedestrian, it isn't a big enough deal to your car.
Yep. And I also did confirm with somebody that basically, especially if you're reversing, the airbags are very unlikely to deploy on reverse.
Yeah.
So you're not going to find that. But this is the part of the testimony that gave me fits. And this trooper learns into this case, as this case is ongoing, he learns that this Lexus has a proprietary feature. Call it a black box of the Lexus. Toyota owns Lexus. And he discovers this not in 2021 when this car is manufactured, not in 2022, not in 2023, but he discovers this leading up to this trial. So then he goes and plugs in the data and tries to surmise what the vehicle was doing, because apparently this onboard computer processes that and stores that data. I have questions about this particular data and the conclusions that leads me to believe, that leads the trooper to reach.
I was going later, but so the 36 is just within the realm that she could travel 36. The odometer mileage is odometer mileage. So 36 is 36. That's what's on the vehicle. So within the realm of possibilities that the vehicle could travel 36 miles after the two triggers that are in this vehicle.
Now, with respect to that minimum and max, as far as the 36.1, 38.8, what, if any, relationship does that have to the difference in the odometer readings that you observed between when you conducted the braking test and when you observed these two triggering events that you were talking about at the earlier mile?
I said no difference. The odometer mileage is 36.
And so I guess what I'm asking, sir, is the 36 miles, is that within the range of the two triggering events that you were just talking about?
Yes, it was.
Now, as far as within your report and your analysis, did you come up with some sort of a label as far as these two different triggering events that you observed?
Yes, I did.
And that incorporated the mileage, is that correct?
Correct.
And that was, again, 12,629, is that correct?
Yes.
And as far as any further label that you put on it, how did you label it?
I laid them as in when they occurred. One's 12,629A and the other one's 12,629B.
And with respect to the A and B, which one occurred first?
The A occurred first.
And may I approach, Ron?
Yes.
First, you can have the document after you just review that. Finished.
That
Do
is
you
an
recognize
accurate
that?
description.
I do. It's the data chart from the 12,629 miles A chart.
May I approach, January?
Yes.
Almost to introduce.
No objection.
The 593.
And again, if I could just have a moment, Ron.
Yes.
May I return this to the witness, Ron?
Yes.
For submission, may I
Yes.
She's not even waiting for him to finish.
Okay, so with the document before you, what's now up on the screen, you recognize that as what's now been marked as the next exhibit.
I do.
Is if you could describe to the jury sort of what these rows indicate as far as what information is there, and if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you observed in this as far as 12,629 miles A.
Okay. So each row, starting from the top, is the vehicle control history time, which is the time that's recorded in the module itself, or in the software that gets recorded as each time, and it's recorded as seconds. This time is the time from the start of the key cycle. So it starts off with 652.8, and each one is incremented in approximately half-second increments up to, let me show it, right here where the trigger, this is what's called where the trigger happened. So right here is where it kind of goes from 4.5 to 4.6, then it goes up to 5, then everything after that is about half-second increments from each other. Recorded 10 seconds of time, which is labeled in this one, total time of 10 seconds. And I'll put time from trigger, just kind of label it back to, here's the trigger right here. And that's the time between each one. Sorry if I can read this right. So and right here, this is the vehicle speeds. The blue is just labeled because that's the speed. Zeros are labeled as a light blue is a 0. So if I could read this. So it starts from, shows that the vehicle is traveling at 9.9 miles per hour. It's slowing down to about 0 right here, and then stops for that time, and then increases back, speeds back up to, it goes up to 6.2, and then slows back down to 0, and then back up to 1.7 to, I think it's 8.7. If I can read that right. The next below for us is miles per hour to kilometers. This is the accelerator opening ratio, which is really where this trigger comes from, because the trigger is labeled as the accelerator pedal opening angle is medium to higher immediately after shifting to reverse, or they label it as R.
If I could stop you there just
Yep.
a second. So as far as the accelerator pedal opening angle,
Right.
Can you explain to the jury sort of what that term means and how that relates to sort of the operation of the vehicle?
So the accelerator pedal is, the part where everybody puts the foot.
He pushed the pedal.
We know what the gas is, Lolly.
He pushed the
Your jurors are familiar with the concept of a car. They are not the like Geico caveman. They have not like just stumbled out of 1601.
Just get me to the math. This is why the state should have hired a private. The state should have hired a private accident reconstructionist, because I guarantee you, if they had gone outside the state police and they had actually hired someone that was a professional expert, right, who testifies to this stuff, that expert would be in a narrative right now, I would be captivated. Instead, I'm captive against my will to this.
Foot on and gets the vehicle to go. So the pedal. So this is what's showing how far the pedal was actually pressed by the operator of the vehicle, and that gives you a percentage of that. So if it was, on zeros not pressed, then 100% is all the way down. So they label the trigger. I think 30% is medium to higher in this way Toyota labels it. So then that's where you'll see the trigger is around 31.5%. And it also shows start from the beginning, goes from 0 and increases up to 50.5%, and that's 5 seconds. That's only a little over a second past the trigger. And so it's 50%, and then back off, and then back onto the accelerator again, up to 34%.
Now, as far as this data is concerned, for the VCH data from the Toyota tech screen, what, if any, information are you able to glean as far as directionality, as far as forward, reverse, left, right, things like that from this data?
So on this label right here, so it shows the shift position signal. One is forward and two is reverse. So this right here is showing the vehicle was in drive and going forward, and then the vehicle got shifted into reverse, and then back to drive again.
Now, from your experience,
You know what would have been really easy? Trooper, you have a chart in front of you. There's various colors on this. Can you explain how these colors correlate to the operation of a vehicle? For example, I see in this part of this chart, it says speed, and this part says accelerator. Now there's colors here. Trooper, could you explain what those colors mean in terms of how the vehicle is operating? And then the trooper gives a nice long narrative that explains all of these things without the broken up little questions.
I don't know if the trooper gives a nice long narrative, but a long narrative.
He would have, well, I don't know. Just thinking. Maybe.
from your training when it comes to interpreting this type of data, do you have any opinion as to sort of what type of maneuver or what type of actions the vehicle was taking during the course of this triggering event?
Yes, this appears the vehicle was slowing down and making a U-turn. Because also the other thing into it, it shows steering signal, and the steering wheel still showed that she was driving left and then right and the back left again. And also when she's on the brake switch.
I shall be right back. I require more caffeine.
This is good. So here's a good question that I saw here. Kat, do we know what time this data is from? No, we don't. And actually for this part of the testimony, it doesn't really matter. The trooper is walking through this, and this is why I'm pissed off at Lolly. Because the trooper is walking through this, not because this particular incident is significant. He's walking through this as an example to show the jury that this is what this measures. This is how it measures. When you see a similar chart that I'm about to bring up to the jury, this is what you're supposed to look at. And these are what the numbers, the colors, and this column on the left is what all these things are supposed to mean. This is explanatory. The trooper is saying, look, the vehicle was in forward. It was in drive, that being the 1. Then it hit 2 and went in reverse. As it went in reverse, you can see the accelerators are pressed a little bit to about 31%, which caused acceleration while in reverse. And then the car was shifted after the accelerator was, all the pressure was removed from that. The car was shifted into forward or into drive. And then this accelerator gets depressed again as the vehicle drives on into its ultimate direction. And in the interim, while that's happening, you can see the angle of the wheel. So the wheel is turned, so you can see what's happening. So the trooper's about to say it's a U-turn. It's not. What the trooper's trying to describe is a K-turn. That's what the vehicle is doing. But this is all an example. This could have been laid out in, quite honestly, one question and an example or a question or an answer, rather, that went through a full narrative of what we're seeing. This is a very easy chart to explain. I don't know why it feels so painful to listen to. So that's what's frustrating me, is that this data is so important. And this trooper is trying to explain how the data is supposed to work. But it's being broken up by some of the worst questions I've ever heard. So this is a good question. What would you have to ask to explain the chart? Great question, Mary. All I would have to ask is basically saying, trooper, this system reports out data, correct? Yes. And it reports out data on various operating systems in the vehicle. Yeah, it does. And when it reports that data out, are there different data points that are measured? Yeah, it's the things on the left-hand column. You mean the things that are looking there, like speed, angle of the steering wheel, whether the car is in forward or reverse? Yes, it does. Well, it seems like there's a bunch of numbers on this chart, trooper. Can you explain to us what the numbers and the colors mean and what they correspond to? Well, yeah, I'd be happy to. Actually, trooper, let me cut you off. Is there a particular event that this vehicle is engaging in this particular example, that would help you illustrate what the numbers and colors do? Well, yeah, let me explain what happens. Here's what, and then boom, 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 boom. And now you have a jury's full attention, uninterrupted, as the trooper or expert is explaining this K-turn or 3-point turn that's taking place. And and let's say, for example, the trooper pauses on something, or a juror looks somewhat confused. You can say, well, trooper, you went over this number. What's that again? Because I'm confused about that part. you turn it into a narrative and you bring the jury into the story. And now a chart instead of a chart is now displaying in the juror's mind vehicle actions and behaviors. That's what you would do. And to be honest, if this is your most critical witness, one of the most critical witnesses, you have these questions. You have them scripted. You know what to do to get the expert there. And to be honest, the expert sees you floundering and the expert picks up on it. So what is a simple K-turn that would have been a great example to show the jurors how this chart works becomes a painful exploration of what the question is intended to ask and how I'm supposed to translate that with what I'm seeing on the page.
Ms. Gilman, you can take that down. And Your Honor, may I approach?
Yes.
Sir, if I could just retrieve one now before.
Absolutely. Yep.
That document that I've just handed you now, do you recognize that?
Yes.
And what do you recognize that to be?
It's the one, the 12,000, the data chart from my report for as labeled as 12,629 miles B.
So that's the.
Ladybug Lisa, good question. Is it weird to have a trooper as an expert? No. Most law enforcement departments have to have this because they have to do this investigation. This is an element to their investigation. So they will have someone within the department this is their specialty. Now, in high profile cases, you might go outside of that to get a hired gun. But no, this trooper, if the questions were asked properly, you would have a better foundation than what was laid by Lolly.
The second triggering event within this same mileage reading on the odometer, same key cycle?
Correct.
Your Honor, may I approach?
Yes.
Commonwealth seeking to introduce the minutes of the next exhibit.
No objection.
Okay.
Again, just one moment, Your Honor. May I approach the witness?
Yes, and for the sake of taking the best use of our time, if they're in evidence for the rest of this afternoon, both of you can then just ask to go ahead and put them up and not ask for permission this time.
God, I love it. That is like, I'm done with this bullshit. Stop. Like, just move things along.
Yeah.
I got a better explanation of the freaking chart than that back and forth. I'm frustrated. Breathe.
My headphones seem to be screwing up. That does not fill me with joy.
No. Those are the nice ones too, aren't they?
They are.
Can you hear me?
I can. It's just one ear. The left ear is on them is toast.
So you don't have me in stereo, so I'm only nagging in one ear. That's fair.
Correct.
And Ms. Gilman, if I could. And if you recall, you recognize what's up on the screen now?
I do.
This is the VCH data chart from that same mileage or the second triggering event as far as 12,629 miles peak, correct?
Correct.
And again, this is in the same odometer range as well as the same key cycle as what was just up on the screen as far as 12,629 miles A, correct?
Yes.
All right. I'm going to save you the torture. We're going to translate this chart based on what I just explained to you. Remember, we talked about the orange numbers. Orange numbers, if you see a 1, it's in drive. If you see a 2, it's in reverse. So the vehicle is in drive for a period of time, several seconds. Now the dark blue numbers, that's the rate of acceleration. Okay, so the vehicle's in drive for a period of time going forward. And then that 0, that little blank between the dark orange and the light orange, that's the vehicle shifting into reverse. And then you see the accelerator depressed. The accelerator is depressed from 30% upwards to 75% of the accelerator being depressed. Okay, so it's being pushed full throttle. So you have vehicle drive, then in reverse. And now that entire period for the rest of that chart is the vehicle is in reverse and the accelerator is being depressed almost to full throttle. So you have 30%, 60%, 65, 59, 63, up to 75. So that's the percentage. Now, let's see if his explanation comes any better than that one was.
This occurs after A, is that fair to say?
Correct.
Now, similar to before, when it comes to this BCH data up on the screen, if you could, using the laser pointer, demonstrate to the jury what, if anything, of significance you note with respect to this data.
So for this one, same label as before, as you said. The vehicle control history time is, if I can see that, the trigger time is 1,142.2 seconds after key cycle. And this one shows all the same thing, 10 seconds of data. And it was good. So the vehicle speed on this one shows that she's slowing down. It's 13.7 miles per hour and gets down to 0. Then she's down to 0 for a while. And then the vehicle's speed increases up to 24.2 miles per hour at its max speed. Then it goes down to 23.6 as the last two labels. And the accelerator pedal angle at this point at key trigger is 36.5. It increases up to 74.5%. And it stays around 74.5%, 74, 73.5, and 74.
Now, I don't know if you guys can read this on the screen, but I can. So as she's starting to depress the accelerator, it's at 4.2. So 42.2 seconds, 1142.2. So 42.2 seconds. At the end of this, we are at 47.55 seconds. So during that time, you have 5.3 seconds? 5.3 seconds of time. That is what ends up happening. So in 5.3 seconds of time, this vehicle goes from 0 miles an hour in reverse to 22 miles an hour. That's what the data is telling us. That's what his explanation of the data is.
Now, that's 74.5% as far as the pressure being applied to the accelerator pedal, correct?
Correct.
And with respect to that, 74.5, that's about 3/4 down, is that correct?
Yes.
Now, with regard to this data from 1269 miles B, what, if anything, are you able to tell from this data as far as when that occurred in relation to 1269A?
So they occurred about approximately 8 minutes. So 1269A occurred 8 minutes prior to the other one, and they both occurred on the same odometer mileage.
Now, with respect to the
3-point turn, 8 minutes later, rapid accelerate, rapid reverse.
duration of the data that you were able to obtain from this one, specifically 12629 miles B, what kind of duration of data are we looking at in this particular table of chart?
Say that again.
How long a period of time does this?
So this is from the start of key cycle, or this whole just this one?
Just this one.
Okay, so this is 10 seconds of data.
And with respect to that 10 seconds of data, as far as the 24.2 miles per hour, when does that occur within the 10 seconds of data for this particular event?
So 24.2, as I'll point out, is right here. It's actually around the 9-second mark.
Do we need to see the rest of this, or does my explanation of the chart make more sense?
We don't need to see the rest of it, and I don't know if it makes more sense, but
The chart is what it is. Like I don't. Fast forward a little bit.
Now, as far as significance does that have, or what, if anything, does that indicate to you from this data also?
It shows that the accelerator pedal angle went up to 74.5%. 5, 9, 13.5, 13.5. I think it's 13.5, 0, 4.5. And that's, we're talking about steering wheel. How far does the steering wheel move from left to right?
This part's relevant. That little bottom one, steering wheel. Is it straight on? Is it moving this way or this way?
So that's the degrees of a steering wheel angle.
Now, as far as when the vehicle is shifted sort of from drive or neutral or park or whatever it was, at some point, is there an indication in this data set on this table as far as when the vehicle was placed into reverse?
Yes.
And how far into this 10-second data set was the vehicle placed into reverse?
At 4 seconds, it's right here.
And so am I correct then that there is a 5-second difference between 4 seconds when it's placed in reverse and 9 seconds approximately when it achieves that 24.2 miles per hour?
Correct.
Now, as far as the 74.5% pressure that's placed on the accelerator pedal, when is that reported in seconds in relation to the 10-second data set in this table?
74.5 starts at the 8 seconds.
Now, as far as this trigger is concerned,
The trooper's explanation is as follows: that in the course of backing up, the vehicle achieved a maximum speed of this 20-something miles per hour. At that maximum achieved speed, the angle of the steering wheel changed because the vehicle struck a human body, John O'Keefe. And that to this trooper is conclusive of what transpired and how this is proof of a pedestrian-related incident. Let me explain a different hypothetical that would blow this to pieces. We're going to use all the same data points, and I'm just going to play out a factual scenario. And it turns on one thing that we didn't hear the trooper testify to. I didn't hear the trooper testify to how the speed is measured, whether it's in the drive shaft, whether it's in the wheels spinning, or whether it's, I don't know. So I don't know how the vehicle is internally measuring the speed that's being recorded in this data set. So let me give you a hypothetical that I think is, well, I think in line with this. Let's say that the vehicle, while in forward, seems to, well, reach a point that it wants to stop and wants to reverse out of a snow patch or a slick spot. And the driver, who is intoxicated, throws the vehicle into reverse, and upon depressing the accelerator, realizes that nothing is happening. Pushes the accelerator further and further, thus spinning the wheels faster and faster. And the wheels
This is a super common mistake in snow.
Yep. And especially when someone's drunk. Now, let's say that the wheels are spinning faster and faster and faster, and all of a sudden, the person who is confused shifts the steering wheel a little bit. And now the vehicle is outside of the snow, or has shifted a little bit, and has gained a little bit of traction. And the operator of the vehicle now suddenly realizes how fast the vehicle was going and takes their foot off the accelerator, at least briefly. I'm fascinated because I can completely see that being consistent with this chart. And it turns on one fact. How does the speed get measured? I don't know. And to the people that are saying it's not the correct key cycle, I don't know what it is. I'm going off of their assumption. And I am taking their assumption that this is the incident. And I'm also giving you a scenario that I think is equally plausible based on that one fact.
I understand from your testimony that the maximum speed is 24.2. Is that correct?
Correct.
And what is the vehicle speed recorded at the end of this 10-second data set?
23.6.
Now, as far as the vehicle being in sort of different sets, as far as drive, reverse, things of that nature, what, if anything, did you observe within this data set as far as how it is at the beginning, how it changes at all? What happens with regard to that in the data set?
So this one shows that the vehicle was in drive. It starts off in drive. It's slowing down to 0, and it goes to 0, which is neutral. Then it goes down. Then it goes into reverse. So it's going straight. It stops. Then it's placed in reverse, and then goes back. Goes in reverse.
Now, as far as the reverse is concerned, you indicated there's also some steering angles that are recorded with this data.
Yes.
And what, if anything, was recorded in?
Worst question ever. 41934. My God, this is freaking painful. I'm going to stick with
all of this. Makes me want to buy like a 1960s Buick.
We fast forwarded. So now we have a new chart.
No, Judge. Okay. Go ahead and publish it if you're inclined.
Just so that then I know it's not spying on me.
what's up on the screen. It has now been marked as Exhibit 596.
I do.
And again, if you could, using the laser pointer, let me ask you this first. As far as this table and this information up on the screen, I should have asked you this before. How was this table created, and what, if anything, does this illustrate?
Yeah, so this illustrates from the chart of 12,629B. I started from when the vehicle was placed into reverse, and when it immediately goes from 0 and travels up to 23.6. Just that's like the last part of that last chart we had.
And what, if anything, were you able to do as far as distance travel, and how were you able to determine that?
So I used the this vehicle speeds and the time, and calculated a distance that the vehicle traveled during this time.
And as far as the total distance traveled from the 0 to the 23.6 at the end, what was the total distance there?
97.35 feet.
And with respect to the vehicle's maximum speed, as far as 24.2 miles per hour that's recorded within this data set, how much distance had the vehicle traveled prior to achieving that 24.2 mile per hour?
62.
You guys ready for me to blow this chart up too? Here we go.
If you can make this interesting, then I will be very surprised. But
I will make this interesting, Ian. You know what's funny about this chart? There's nothing on this chart that demonstrates what data comes from the actual onboard vehicle computer and what was extrapolated from that data. Like,
I was going to say, I don't think anything's likely to be funny about this chart, but you mean weird, not entertaining.
Weird. So the distance, what was not made clear during that entire direct examination is that this is extrapolated data. This is based on calculations. So we don't know which numbers on this chart are constants, meaning which numbers came from the actual onboard computer, or which numbers were extrapolated and calculated. We have a hint based on the very top column, which shows the multiplication factors and how the numbers were derived. But we don't know how this is calculated. So when he says that I calculated 97 feet, that's based on some pretty big damn assumptions, namely that the miles per hour was being traveled on ground and not just vehicle spinning. So you have what's called compounding errors. You have the error in the first interpretation, which could be the vehicle speed, which is now compounded because you plugged that erroneous data into a calculation and created an extrapolated figure being distance, which is now fundamentally flawed if your original premise was flawed.
But you know, compounding errors is actually the name of Lolly's band.
So what is presented at 97 feet could be 5, could be 3. Because if the accelerator was depressed and pushed down 75% before the vehicle gained any traction, and those wheels were spinning at 25 miles an hour, and the wheels suddenly gained traction, and upon gaining traction, all of a sudden, Karen Reed or whoever's operating the vehicle realizes it and says, holy shit, this is fast, and hits the brake. The vehicle might have traveled, what, 5 feet?
Something like.
This was infuriating. And it all would have been solved with one question.
What, if anything, the fuck?
How does this data, how does the onboard computer calculate speed?
I like my question better.
I think so too.
$5.1 feet.
Thanks. Approach just to retrieve, Your Honor.
Yes.
Now, Paul, with regard to, based on your training and experience, with respect to this type of data and crash reconstruction in general, this particular...
I want to hear it from his lying mouth. I want to hear it. I want to hear it. I want to hear him say it.
No, you don't.
Data, from,
you just think you do.
Who's the name again? From 12,629 miles B. What, if any, type of collision is that data set consistent with, and why?
Yeah, there's a point there where it appears to be consistent with a pedestrian strike.
And why is it that your interpretation of that data you feel is consistent with the pedestrian strike?
It's the sudden change of speed at 24.2 to 23.6 and a half second, while the accelerator pedal is still at a consistent 74%. And also the
You mean when the tire gained traction and had to now move a 3,000-pound vehicle?
Yep.
This is why you were mad earlier, Ian, wasn't it?
Oh, there it gets worse. It gets way worse.
Sorry, 6,000-pound vehicle. That's my bad.
It gets way worse.
steering wheel angle goes left to 4.5 degrees and also goes right to 4.5 degrees and then goes back to left after that. So right at that spot is something that's consistent with a pedestrian strike.
Now, with respect
Now,
to,
I hate the word
pedestrian,
consistent when used by
collision,
experts. Every time an expert uses the word consistent, I think that they should probably just be yeeted out of the courtroom and into a ditch. So,
consistent doesn't mean proven beyond a reasonable doubt.
no, consistent just means the opposite of that. It means not disproven. You know what else is consistent with a, with a pedestrian strike? That right there, because
it's not inconsistent. It's not inconsistent with a pedestrian strike,
which means it's consistent with a pedestrian strike.
Could be.
So,
and I starred one of these comments, and it's I don't catch a lot of them. And guys, I do have the super chat starred. I will pull them up. I'm just trying to make sure I make it through the testimony before I lose my mind. EVR, Rob's explanation is more plausible. My explanation doesn't have to be more plausible at all. It just has to be a reasonable alternative, which means that any juror or any person could reasonably reach that conclusion. And by doing that, that is a mandatory not guilty. So I'm sorry, but someone tell me how this data proves beyond a reasonable doubt that this vehicle struck John O'Keefe.
It doesn't.
And when I have a trooper that's trying to sell bullshit math,
that's what we do here.
I understand why Jackson was furious at the end of the day.
Mm-hmm.
So, not inconsistent with a pedestrian strike.
What, if any, data were you able to see or review in relation to your reconstruction analysis in this case?
Say
As far as Mr. O'Keefe, what, if anything, did you learn about his injuries?
Like what types of injuries he had?
Yes.
Yeah, there were blunt force injuries. I mean, it was abrasions or lacerations, and blunt force injuries.
And the injuries that you observed or that you were informed about, that you learned this from the medical examiner, is that correct?
Correct.
And with respect to the injuries Mr. O'Keefe was recorded as having sustained, according to the medical examiner, what, if any, relationship did those injuries have to you in relation to a pedestrian collision?
Sorry, say it again.
As far as the injuries that you were informed by the medical examiner that Mr. O'Keefe had sustained,
yes.
What, if any, relationship did those injuries have in relation to a pedestrian collision?
They are consistent.
Is anyone else surprised that the medical examiner isn't testifying to this? Why are you trying to get the injuries and the cause of the injuries out of the person who's reconstructing the vehicle path?
Because the medical examiner probably doesn't agree with them.
I hate this prosecution. I don't understand it. Every time.
Oh, I understand it. They want a conviction. They're going to get themselves a conviction.
He's explaining the injuries and how the injuries are consistent with his observations of the data.
Listen, Rob, all of this stuff you're talking about, it just sounds like it's going to get in the way of a conviction. They just want to have a fair trial and then a hanging. That's
consistent with a pedestrian collision.
and how so?
Due to, I mean, we break down each injury, due to the arm, the lacerations of the arm from the tail light, the dent with the scratches for his hand.
You know what? I'm gonna
something
bet that the
would be
lacerations
consistent
of the
with
arm are
this
not
and
found by the ME to be consistent with the tail lights.
The lacerations of the arm are consistent with the tail light. Because, you know, this person is well attuned to testify to that. And you know what? I don't blame the defense for not objecting, because you know what? Let the jury hear this. Let them hear it. It's not going to make sense.
This particular case with striking the Lexus.
Now, specifically with reference to this case, what, if any?
Wait, I found out. This is the perfect opportunity for this.
You keep using that word. I don't think it means what you think it means.
So here's a question about the tail light and how the tail light's supposed to cause these injuries. When he's supposed to be struck by the tail light's supposed to still be intact, right? And so therefore, how does the intact tail light cause these injuries as it breaks when it hits him, as opposed to
at speed?
Like,
don't forget that part.
Yeah. Like, none of this makes any sense to me.
Up and down his arm, like the whole length of the arm.
Yep.
I'm not buying into conspiracy theory. I'm just saying you're not making these things line up.
I'm buying an incompetence theory.
They're not lining up. I'm not stupid. You can't tell me that this is consistent with when everything that I know in just practical life experience tells me otherwise. It's inconceivable.
You keep using that word. I don't think it means what you think it means.
Analysis did you conduct with regards to kinematics?
You need
yes,
that soundboard.
I did it.
I what?
You and that soundboard.
That's the one clip I have on there, and it makes me so happy.
A kinematics analysis of my report. Kinematics deals with the aspect of motion.
And I'm sorry, if you could expand upon that just a little bit and explain to the jury sort of what a kinematics analysis is.
So kinematics analysis is, like I said, it deals with the aspects of motion. Pedestrian crashes get labeled in certain types of how they interact. So in this particular case, I kind of labeled it as a forward projection crash with a side swipe. And what I mean by forward projection means that when a pedestrian gets struck by a vehicle, will basically.
Here we go. This is how the body ends up where it is. Ready?
This is the part that pissed me off, because this is now we're in a world of pure imagination.
Come with me and you'll see. Pure imagine speculation. And here, look, there's a book of calculations. I can make a vehicle hit anyone. Just give me
I can make an officer drop the C word.
the numbers and I'll prove it. If you didn't think I could do it. Oh my God.
So who had Rob singing on their bingo card?
Oh, that was pretty good album, though. I have to admit, like, I didn't think those words would fit together the way they did.
And if not, why not?
What, if anything, could you do to make this trial make sense? I don't know anymore. Okay. Ready for Ian to lose his mind? I am.
Is that principal impact forces are above the pedestrian center of gravity, as in this case where you get the higher back of the vehicle. When you get struck by something like that, it projects you forward in the direction of the vehicle. And in this situation where you get more struck through the side of the vehicle along the taillight area, that it projected him to forward and to the left due to this more of a side swipe manner.
Back and to the
Now,
left.
with respect to the, height of the vehicle, as far as the shape of the back of the vehicle, what, if any, relationship does that have?
This is literally sounding like the, the conspiracy theories about the shooting of Kennedy.
Yeah, due to being pretty flat. It's not the front of the vehicle where you have the hood and the pedestrian staying above the hood. It's the back of the vehicle. It's pretty flat and it's pretty higher up.
Now, with respect, you were also made aware through your review of the medical examiner's report that there was injury to the back of Mr. O'Keefe's head.
Yes.
And based on your training experience in particular.
Oh, this is my favorite part. This is the best.
By the way, anytime they ask a cop based on your training and experience, the next words that are coming out of their mouth are probably bullshit.
I wanted this expert, and I needed this expert to explain this to me. I really did. I wanted it. I'm so mad because this is what we got ready for this is what you wanted.
The pedestrian collisions. What, if any, significance did that have in relation to your opinion as to how Mr. O'Keefe interacted with the defendant?
So when you look at the damage, he would have interacted with that left side of the vehicle, and when he got struck by the vehicle on the left side, it would have caused his vehicle to rotate kind of counterclockwise. And then when that rotation, he could turn it into his back, and his back could have struck the ground. I noted at the scene that there was asphalt curbing, which could have somewhere he could have struck his head in there, or somewhere along any of the pavement would have caused damage. Most forward projection crashes have damage on both sides of the body.
Why is that?
No, we're not going to let that slide with all of the speculation, the rampant speculation that we heard in the last 2 sentences.
So he does this like pirouette as he gets hit, is basically their theory.
But it's to the left, Ian. To the left. Put everything this trooper owns in a box to the left. Just I'm gonna make a shirt that says "Come with me, and you'll be in a world of rampant speculation."
I've got to make one that says I'm not Thai exclusive.
They'll disappoint your expectations.
Also, I got to finish the brainworm shirt.
If you want to see evidence, simply look around and make it. Numbers won't do anything to break it.
Sorry, folks. It's now a musicals.
I am delirious in upsetness.
It's just going to be show tunes now.
If there's directionality to this, I have no idea where the directionality is. I told you I'd use that word again. All right, we're going to back up 2 sentences and listen to all the speculation, which quite honestly is, again, reasonable doubt that he's testifying to on direct.
Due to them, which could have it would have caused his vehicle to rotate kind of counterclockwise. And then when that rotation, he could turn it into his back. Could have struck the ground. I noted at the scene that there was asphalt curbing, which could have somewhere he could have struck his head in there, or somewhere along any of the pavement would have caused damage. Most forward projection crashes have damage on both sides of the body.
Why is that?
Due to them get projected forward, so they get hit from behind, they have damage to the back, and then when they get projected forward, they get damage to the front. So, in this case, he got projected and got spun counterclockwise due to where he got impacted the vehicle.
You don't know any of this. You're just making a guess based on pure bullshit.
Yep. Trooper O'Keefe is now a spinny top. That's what we have.
Now, with regard to the vehicle speeds, kinematically speaking, from your analysis in respect to that, what, if anything, can you say in relation to, just in general terms, as far as the pedestrian collision is concerned, how much of that vehicle speed would a pedestrian be assuming in the context of a pedestrian collision with forward projection?
Forward projection will have almost 100% speed post-impact. And more, like I said, in this case, it's more the fact that he didn't get 100%, like his center mass didn't strike the vehicle, so he would not have been thrown 100% of the vehicle speed post-impact. His right side would have sustained the vehicle speed, and that would cause him to spin out. So as opposed to traditional forward projection, if he was right there in the middle of the vehicle, he would have got projected forward, and he would have sustained, his full body would have sustained the vehicle speed.
Is that abnormal as far as the sort of forward projection?
Is it abnormal when a human body is hit by a 6,000-pound car for the whole human body to sustain the impact of the vehicle?
Oh, I hate this guy.
The fuck is these questions? Andrea, I see you. Where are you? There you are. No, there you are. Lolly is calling this. The kinesthetic analysis has me lolling. Yeah.
He is lolly.
For those of you wondering why this expert's allowed to testify to any of this, me too. For those of you who don't know Andrea Burkhart, Andrea Burkhart does phenomenal coverage. Koberger, in this case, please go check her out. Her analysis is phenomenal. She has a very interesting take on, for example, the shirt and the condition of the shirt. And I think that she even called it before the trooper pulled the shirt out of the bag and said, if this shirt is a bloody mess right under the nose region, that's it for her. Andrea's a boxer, by the way. So
yeah, and the shirt very much looks like a guy who got into a bar fight, not a guy who got hit. It's drip. It's blood drip.
we can talk about the trooper's drip right now because that's a nice tie. Solid.
Yeah, I liked Unetti's tie. Unetti's got a nice tie. This tie I would not steal.
Now I want to see. So we're going to listen to another 30 seconds of this because I think he's done after this, and then I want to go and we're going to play the last bit. Yeah, hang on. Where is she? You have a bloody shirt collection of your own? How'd you get the bloody shirts? Was it being struck? Andrea, were you struck by a vehicle going 24 miles an hour in reverse? Were you? Were you a victim of a crime? Or were you?
I don't believe that was the...
I know what you're talking about. All right, 30 more seconds and we're going to go to the experiment that he does that I replicated.
And type of pedestrian collision, what I'm going to ask is specifically to not having any contact with sort of the bottom of the vehicle or being run over or something like that. Can you expound upon that a little?
Yeah, due to the sideswipe manner that projected him off to the left, it wouldn't show that he would have been, the car would have ran over him and traveled over him. Like traditional.
Yeah,
the car
I'm
would,
going to ask you to slow down just a
Sorry.
little bit.
Sorry. Yes, so due to the situation in this scene where he got projected to the left and body rotated away from the vehicle, and his body would not have traveled under the vehicle, as you do in a lot of traditional forward projection crashes. The vehicle would get tracked forward ahead of the vehicle, and then that vehicle could possibly travel over that pedestrian.
So that is not what you found in this particular pedestrian collision, correct?
Correct.
I know you mentioned it a couple of times.
So frustrating. The vehicle yeeted the human body. That's the crux of that. No, it didn't go under the vehicle because the vehicle was traveling fast enough that it just yeeted the body. This was displayed somehow to prove that Karen Reed knew what she was doing. I don't know why the prosecution put this on. I don't know why they wanted to introduce this, because this clearly, well, in their mind, it proves that she knew what she was doing.
Trooper, if you could, please describe to the jury what we're looking at in this photograph that's now been marked as Exhibit 606.
Yes, this is the view from the operator as they would turn around and look to the back of the vehicle.
And Ms. Gilman, if I could have photograph 2616. And Trooper Paul, do you recognize what's up on the screen and has now been marked as Exhibit 610?
Yes.
And can you please describe to the jury what, if anything, we're looking at here?
Yes, that's the view inside the vehicle, showing the infotainment system and the backup cameras on it.
Now, as far as the backup cameras on this particular vehicle, what kind of view was able to be portrayed, or what did you observe on the screen when you placed the vehicle on the first?
Yes, so this has this straight backup camera and also has a 360 overhead view of the vehicle.
And as far as the cameras within this vehicle are concerned,
does the vehicle have automatic braking? Does it?
I'm sorry, I need to have that question asked in the form of what, if any?
What, if any, braking? And by that, I mean insofar as the way that a vehicle stops, if there is anything that you could possibly know, what, if any, braking might that vehicle have? Better?
That's properly lollied up.
It's my impression. My impression's getting better. I think I'm getting better at this.
Concern, are we talking about one single camera or how many cameras are encapsulating this 360-degree camera angle view?
It has the front and the sides and the rear cameras.
Now, if you could, using the laser pointer, just draw the jury's attention, direct the jury's attention to where you're talking about as far as the screen is concerned, depicting that camera angle view.
Okay. So the one on the left, that's the backup camera, and the one in the middle here would be the 360 overhead camera.
Now, in addition to what's depicted on the screen right now, as far as the vehicle on the 360 overhead, as the vehicle travels, what, if anything, in addition, is depicted on that particular portion of the screen?
Oh my God, I stand by my prior remark. My impression of Lolly is getting too good. I have to stop watching this trial. I can't do this anymore. But this is the empirical evidence, and I have to actually slow this down to real time because it doesn't make any sense.
The Contempt, please.
Accelerated at all. We're at 1.25, so real time. So remember, I told you guys at the beginning of the stream, I did an experiment on my way home. I went to a parking lot on my way home, and I put the truck in park, and I threw it in reverse, and I was focusing on two things: the rearview mirror and the speedometer to see if I hit 25 miles an hour.
And he only ran over 2 toddlers.
No, school's out for summer. No, there were no children, and no one was
Toddlers
present.
don't go to school. They're too young.
Empty parking lot. So I was curious about this. I imagine that I'm not the only person that did this on their way home or is going to do this weekend. I really don't.
Lots of people have.
So I just wanted, because the 24 mile an hour thing threw me. That sounds fast. Can I do it? And how long would it take to do it? I want you to remember that the data that was reported was that the vehicle went from 0 miles an hour to 24 miles an hour in a span of 5 seconds. That's something that Lolly didn't highlight on direct examination, which I'm sure Jackson will on cross. It wasn't so much that this period of time was 10 seconds. It's that from going in the forward direction to shifting the gear, once the gear was shifted to reverse and the accelerator was depressed from 0 to 30%, 5 seconds passed and the vehicle reached 24 miles an hour in reverse. So I tried to replicate that, and I slammed on the gas in reverse. And I got to about, I want to say about 17, 18 miles an hour before I realized that, holy shit, this was scary. Because the steering wheel wasn't pointed directly straight. So I ended up trying to recorrect it, and the vehicle recorrects too fast. I couldn't get 24 miles an hour. And then I tried to think about, could I have done this if I was 3 sheets to the wind? 9 drinks in, as per the prosecution's case. And
Rob, please tell me you didn't do an experiment with 9 drinks.
No. Then I thought about the conditions that night, and the snow, and the dark, and the alcohol, and the fact that the road itself is not a big open parking lot, but a very narrow single lane paved road that's plowed with a single lane of traffic. And in my head, I'm going, how the would I have reached 24 miles an hour and not completely lost control of my vehicle? That little 4.5 angle adjustment, you got to be kidding me. On a curved road, if you tried to turn your wheel a little bit in reverse 24 miles an hour, you're in someone else's yard. Oh no, Andrea, that was part of what scared the hell out of me. I need to know the RPMs at 24 miles in reverse. It's a low gear. It is. And your vehicle is screaming. So
your vehicle has opinions. The opinions are what and also the hell.
What are you doing? That brings me back to what I was saying is that other theory. If I were to look at the same damn chart, where was the damn thing? There it is. If I look at this chart, let me give you that theory laid out again. Theory number 1, prosecution's case. Karen Reed, 9 drinks in, on a curved road, dark at night, 12:30 a.m. in the morning, after 9 drinks, drops off John O'Keefe with almost no visibility because they testified there's no light over by where he was struck. Knowingly and intentionally looked in her rearview mirror or backup camera, hit the accelerator and reached 24 miles an hour in a span of 5 seconds, traveling 97 feet, and struck John O'Keefe with the rear back of her car.
It's impressive.
Or Karen Reed has tires stuck in the snow, hits the accelerator, and at the point in time when the tires shift a little bit because, hey, they've been spinning, and they have worn out the pavement, they catch pavement and shift the steering wheel 4.5 degrees, and all of a sudden, the vehicle and the tires, which are now not pushing anything, 24 miles an hour, now the tires are pushing a 6,000-pound vehicle and, of course, decelerate by a mile an hour or two because now they have to push something. And then you see the foot come off the accelerator. What's more plausible? Not even what's more plausible. That's not the defense's burden. The defense's burden is, well, nothing. The prosecution's burden is to prove to you that what I just described did not take place beyond any reasonable doubt. The prosecution has to prove to you that I'm wrong.
Apparently she does all of her own stunts.
The data that you're seeing here is sufficient to disprove the narrative I just laid out. I don't get it. Not based on what we saw. So here's the experiment. Here's the prosecution's experiment. I want you to tell me how fast this vehicle is going. Again, controlled environment, straight ahead. And I'll put good money they don't hit anywhere close to 24 miles an hour.
Also, they sure shoveled the hell out of that before they started.
Question, if you could, using the laser pointer, just direct your attention to where that is and sort of where it's going to be in relation to the camera angle.
Vehicle is right here.
Ms. Newman, if you could press it.
That was weird. So he backs up. It's the most awkward reverse I've ever seen. He backs up and can't back up in a straight line. The vehicle actually turns a bit. Yeah. We're trying to prove that she had 24 miles in reverse, not forward. Lexus got some good pickup. That's some pretty good pickup.
That you were conducting here with the relation to anti-lock brake system or ABS. What, if any, relationship does that have with regard to braking and what is then visible on the pavement?
It doesn't leave visible tire marks.
And why?
Unless it's on snow, in which case the ABS system doesn't react like it should. ABS requires traction, at least some form of it.
Listen, don't try to confuse them with like logic and
the brakes.
I'm so mad, Ian. I don't know how you're being so quiet.
I am very tired, but also I have spent a decade dealing with criminal law, and I will tell you, this is less surprising to me than you might think.
Okay. How about this part? Let's forward to the end of the day. End of the day. I know you're going to like this. Well, I know you're going to. Let me take that back. I know you're going to hate this. You're going to hate this so much. You're really going to hate this part.
You're not wrong.
The impact between the two vehicles. In respect to Mr. O'Keefe's vehicle, what, if anything, did you observe on his vehicle at that time?
At the photos or now?
Right now.
Oh, right now. There was snow on the vehicle.
And then with respect to the contact between the defendant's vehicle and victim Mr. O'Keefe's vehicle, what, if anything, did you observe to occur with relation to the snow based on the significance of the impact between the two?
The snow doesn't move.
And Ms. Gilman, if you could press play this.
All right. Can I see the other video? Please.
Give me the opinion.
All right. Thank you. Okay, could you turn the lights on, please?
Your Honor, if I could, there's just two photographs that I'd like to.
Sure.
Purposes. Ms. Gilman, if I could have what's now been marked as Exhibit 549.
And before you do that, what is the exhibit we just saw through your IT person? What
Your Honor, it's
number?
the same exhibit. It has not been enhanced in any way. It was just magnified for purposes of this, of showing it. In other words, the magnification is not embedded in the video. It's
Okay.
the same video.
Okay.
We just magnified it.
Okay.
Here you go.
All right. Thank you.
Sorry.
Go ahead, Mr. Lally.
And Trooper, do you recognize what's up on the screen now?
Yes.
And what are we looking at, and which area of the vehicle are we looking at?
It's the rear. Sorry. John O'Keefe's car.
The driver's.
Is my mic coming in that bad?
I don't think so.
I don't understand. People don't like. I'm trying, guys. I haven't done anything. Maybe I'm just moving away from it too much. But
Side, is that correct?
Yes.
And what, if any, relationship does this portion of the vehicle we're looking at here have in relation to the video that we just watched?
It was faced. Well, kind of you see it
Sorry,
from.
what was the answer? I didn't hear.
Sorry, it was faced kind of the same way you see the back left rear corner of the vehicle as you do in this picture here.
And Ms. Gilman, if I could have what's now been marked as Exhibit 559. And sir, is this the same driver's side rear of Mr. O'Keefe's vehicle?
Yes, it is.
Now, as far as your observations of these photographs, what, if any, damage did you observe to Mr. O'Keefe's vehicle in either the last exhibit or this exhibit itself?
There was no damage.
Now, as
Except
far
this
as
is the wrong part of the
impacts,
vehicle.
Let me ask, as far as the damage that you observed to the taillight area of the defendant's vehicle, what, if any, opinion do you have as to the amount of force necessary in order to cause that damage?
Objection.
We need a foundation on this.
So, Trooper, over the course of your, I'm sorry, how many crashes have you investigated over your time with the cars unit?
I've been primarily on 196 crashes.
And I know I'd asked you before about pedestrian crashes. Fair to say most.
How many of those did you personally cause?
Vehicles colliding with other vehicles.
Correct.
Now, with respect to that experience in relation to vehicle crashes, what, if any, training or knowledge do you have in regard to sort of physical forces of vehicles in a collision sequence, and what kind of damage you would anticipate?
So obviously, the higher the speed, the more damage. The lower speed, the less damage.
And what, if any, from the observation that you made in that video and the observations that you made of the defendant's vehicle, what you observed in the video, was that consistent with the damage that you observed to the defendant's vehicle?
Objection.
So I'm going to allow this for voir dire. I just need to hear this information.
Understood, Your Honor. Thank you.
It is not consistent with the tail light in this collision.
And why not?
One thing, the collision, the tail light is, what I say, 42 to 50 inches off the ground.
Yeah. I had a similar thought, Andrea. Done
Yeah.
196 crashes, therefore I can testify to what force metrics are required to dent stuff and to break stuff. I'm totally now a mechanical engineer. I'm a pilot. I've flown an airplane a lot.
I mean,
so that vehicle
could be.
Listen, they're letting Lally run the trials here, so we can't complain too much.
Are they though? Well, I can't wait till Cross. Cross is my favorite part. Can we fast forward to that part? Because he testifies that this is now that Karen's vehicle doesn't line up to the accident injury on this, and you're going, huh, that would have been really interesting to hear earlier in the trial. Why haven't we heard that earlier in the trial?
Oh, and then we're going to find out why we didn't hear that earlier in the trial.
We really are. And Jackson, if you guys want a preview of what Monday midday is going to look like, holy crap.
Oh, he's got some mad.
This is voir dire. You don't have to go to witness this hard in voir dire. Voir dire, you're just trying to prove that there's no jury there. You're not trying to make a point. You do this when you're actually pissed off.
Yes.
You said, well, one has matte finish and one has glossy finish, right?
Yes.
And you said, well, you'd expect one of them to like slide off of each other, and they could have done this and they could have done that, right?
Not slide off each other.
You were suggesting that the two cars wouldn't match up such that the taillight could make contact with any part of the traverse. That's what you were suggesting.
I'm saying it didn't match up because there's no damage to the traverse.
You didn't test whether or not the lens, the right rear lens on the SUV, could match up to any
YouTube, do not do this. We are right near the end. Let us get through, please.
part of the traverse, right? And make contact, physical contact with it, right?
When I see a picture of the traverse,
no?
when I see the picture
No,
of the
this
traverse,
is a voir dire. I need the information.
you're
Mr.
asking me a
Jack.
question.
Yeah,
And I said when I
yes or no question, Trooper.
I love that the judge chimes in and both of them are just still going at it. Like the judge has said, this is voir dire, I need to, and they're just going at each other.
I mean, to be fair, he's still a dick.
This is going to be great. I can't wait for Monday.
I don't think so, but
Mr. Jackson, just for there's no jury here. This is for purposes of what I have to rule on. The more information I have, the better off I am in being able to rule on it.
Let me take a breath.
So this is you trying to keep the evidence out. So you want to give.
Side note, I'm looking at that jury box again, and that thing looks so confining. He looks like Hannibal Lecter in like a small little thing being wheeled out. Like that looks so uncomfortable. Oh, lead attorney in the website. Hey, lead website in the stream. Hey, lead attorney. How you doing?
Hey, lead attorney. Good to see you.
Can you reach out to me? Because I have opinions on Judge Glanville, and I need a stable, rational person to help talk me through what I'm seeing in that case. Because
that's not me.
It's definitely not Ian.
I've got opinions, but they're strident.
So let's hear Action Jackson go at having been reminded that this is voir dire and the jury is not present. Deep breath, Jackson. Let's see if we can get through this.
Me the information.
Understood. Did you or did you not ever do a test where you backed the Lexus up against the Traverse?
we did not.
Did you or did you not ever do a test where you put the two cars together and measured them?
No.
Did you ever measure the taillight of the SUV, the black SUV, against any area on that Traverse?
No.
Did you ever do any force multiplier tests to determine the forces necessary to crack the SUV's convex taillight?
He's
No.
like, I don't even know what that
Did you ever
is.
do any testing to determine whether or not a plastic taillight, under how much pressure a plastic taillight would need to be subjected before it would crack?
No.
Did you ever do any testing to determine whether or not if a plastic taillight came in contact with a metallic portion of another SUV, whether it would leave any mark?
Haven't done any testing. I've seen crashes where headlights have struck other vehicles. That's kind of where the experience comes from.
Fair enough. But I'm guessing that those crashes are probably different speeds and higher speeds. Not this, right?
I've had multiple crashes at different speeds.
So have you ever had
yes.
a crash where you've investigated, the Massachusetts State Police has been brought in to investigate a crash where the car was going in reverse at about a half a mile an hour?
Half a mile an hour?
Whatever that was.
Are you saying the SUV Lexus is going half a mile per hour?
Well, you're the reconstructionist. Give me an estimate of how fast you think that SUV was going at the point of contact
I love that
with the traverse.
Maybe like 1-2 miles per hour.
Okay, fair enough. Have you ever been called in to a crash, to investigate a crash, where the cars have collided at 1 mile an hour?
I've had pedestrian crashes.
I would imagine that every cop has had that one domestic dispute or something. It's like, he hit my car. It's like just touch.
But they don't bring a reconstructionist in for that.
I want a report. I want the accident reconstructionist. I want everything. No, he hasn't seen this. Come on. Don't.
He's full of shit right now.
Crashes that have been at a very low speed.
Okay, that wasn't my question. That wasn't quite my question.
Okay.
My question is, have you been called in to a crash involving two vehicles
Yeah.
that have made contact at about a mile an hour?
I have seen testing for vehicles at low speeds. So
Not
next
the
time I haven't called
question.
to a crash, I go to fatality crashes, but I have seen testing for vehicles at low speed impacts,
Okay. How low speed?
like just the bump.
So like this?
Yes.
Did you see any damage?
Yes. All right. Well, minimal damage.
Right. In what circumstance? Minimal damage, like, I don't know, like a cracked taillight.
No, like just a little bit of rub off on the paint.
Right? Or you might see nothing, right?
Yes.
You've certainly seen circumstances in which two cars come in contact and there's absolutely no physical damage to either car, nothing observable, right?
Have I gone to
Sure.
crashes that have seen no physical damage on a car?
Or just in common sense, just everyday life, where one car backs into another car at the Jiffy Lube, makes contact and drives away, and there's no damage.
Not normally. It's usually something with car impacts.
Like, what's the something?
A crack or a paint, something chip, scratches.
A crack, huh?
Yeah.
A crack?
So if you put a piece of metal, in that scenario, if you put a piece of metal, steel, right,
Uh-huh.
against a piece of plastic, which one do you think is going to give way first?
You'll still see some damage to both vehicles at a speed.
That was the worst dodge ever.
Yeah.
Sir, I asked you if plastic or steel would give way first, and you answered you'd still see damage to both. Come on.
Which one would give way first?
Between metal, depends what speeds.
Yeah.
And what we're talking about, you're just saying plastic and metal. You're giving a pretty general broad plastic and metal
You're
analysis here.
weaseling, sir. Quit weaseling. Just
You admit, you got to agree with me, that there are circumstances in which low speed, very, very low speed contact between two cars can certainly leave damage on one and not damage on the other, damage on both, or no damage on either one. Observe.
Yes, I just said in that situation where the scratch on the side of her car
Right.
had a scratch mark and his doesn't appear to have anything.
And you said under questioning by Mr. Lally that certain circumstances like this could lead to a lens material, right, plastic material cracking,
Oh, ready for the good part? We're about here. We're about here.
right?
Say again, like on least.
Just a few minutes ago, Mr. Lally,
I'm trying to answer your question. Sorry. Yes.
Mr. Lally asked you
Oh, come on.
a question a few minutes ago, and you indicated that something might show up on a bumper. Something might, something might, like a taillight, might actually crack, correct? In a low speed impact.
A taillight might crack in a low speed impact?
Correct.
Yeah, it might crack.
Okay, now, Mr. Lally also said you saw this video where the cars come close to or make contact, right? That's how he worded the question. Remember that?
Come close. Yep.
Which one is it? Did it come close or did it make contact?
I said it might. I don't know if that scratch from the side is. It's something that's consistent with the height of the bumper. Like I said, I didn't measure them from side by side, but you can clearly see there's a scratch on the side, and that's.
He just played the video for you. Yes, Ian, I'm with you. He just played the video. You just testified to the video. He asked you whether there was contact or no contact, and you're like, I've seen cases where it's been like a rub on something, and I just testified that there's. What if you want an idea of what cross is going to be like on Monday? It's going to be Jackson painfully eliciting testimony out of this witness.
And the thing is this isn't super uncommon with police officer testimony. Cross-examining cops is often just annoying as hell.
Is the sky blue? I don't know. That day it might have been purple. I don't know. I can't recall. But
Andrea, I could totally sneak you a link if you wanted.
Andrea, if you want a link, you can jump on, because the spicy bits are my favorite part. And we're just about there, because he keeps asking these questions about Lolly asked you, Lolly asked you, Lolly asked you. And he's about to get to a point where it wasn't just Lolly asked you. It was, well, when did Lolly start asking you this question?
It's something that looks like that would come back. So as I look at the bumper, and I see the bumper, and it has that little divot, and I look at her side of her car with that scratch mark, that kind of lines up a little bit of why that could be where that was from.
I thought you said there was no damage on that car, on the Traverse.
There is no damage, and that's why I went to why there's this two different paint materials there. That why one could have showed up on her car because it's that flat, the glossy paint on there, and it could have scratched on it. While you have something that's a little more rougher texture with like a flat, flat color on there, so that wouldn't leave on there.
So you just described the circumstance in which two cars come in contact. You don't see any observable damage on one, and you do on the other. That's what
I suggested that when you asked me that a second ago.
Yes. With regard to the video, let's get back to the question that I asked, which was, in that video, did the SUV come close to, or did it come in contact with the Traverse?
Again, I don't know, because I'm saying based off the damage that is something consistent with that. So most likely it did come in contact with the bumper to bumper, but I don't know definitively because there is no damage to his car, but it's something that could explain why there's a scratch mark alongside the right rear side of his car, or her car.
Did you see?
Oh my God. Okay, hang on. Let's see if I can't find the actual place.
The tire move?
Moving. If it moved, it moved.
Well, I don't know what a little while means.
Like a year. No, it's been a little while.
Well, I don't know what a little while means.
Like a year ago, I think.
Okay. So you saw that video a year ago. Did you put anything about that video in your report, which is wherever it is, right here? I'm looking at your entire car's report. Yes. Put anything?
Side note, Jackson's little where's the report? I don't know. It's over here. So attorneys, at the end of the day, at the end of a trial day, you're roasted. You can't remember anything, and you're trying like hell to get through the end of that trial and get through that day, because you have to make phone calls. You got to prep your witness for the next day. You got to go home and review your binders. You got to do a ton of work, and you're just like, get me out of here, please.
Oh, absolutely.
I'm very much with the, where's your report? What fucking thing was this anyways? I'm surprised he doesn't start dropping profanities, because I've never done that in court ever in my life. Never have I ever done that at the end of a trial day.
Which, drop profanities in court?
Like a little hell here and there, or this shit is, but I never did it. ever.
I mean, it is sometimes fun when the witness
Thinking
is
that-
sworn, so you get to quote them.
Yeah, you release a lot of frustration by doing that. It's very
Like when you hear Jackson go, "You said she's fucked, didn't you?" It's like you can just get that out right there. And
sorry for anyone watching this channel who has sensitive ears. You have a warning. You have a 5-second warning before I give my Jackson impersonation.
Just don't drop the C word.
No, I'm not going to do that. But I'm going to very much agree that you agreed that she was fucked. Like, whoa.
And you picked up the cursey words just in time for Emily, who is notorious for having delicate ears.
You son of a purple-haired demon goddess. What the hell? Jackson, you would admit that 16 hours later, she was fucked. Wow. I've never done the full enunciation, like at the very, just a crisp.
Oh no, you got to have fun with it sometimes, especially in criminal law. So
well, and when he does, the fuck was my favorite because I can laugh at that. But I will tell you what caught me off guard was the hard C and the hard T at the beginning and end of that word. Oh my gosh.
Oh, that's another word you gotta just you gotta sometimes just throw in someone's face.
You can't pull the punch on that one, huh? So now
we're especially good is the moment which Jackson landed there of I'm gonna make you say it. I'm gonna make you absolutely lay out, what did you say? No, you didn't. You didn't say see you next Tuesday. You said it. So
he did that during
lay it out there, sir.
He gave us a preview of what cross would be like the full day prior. Like the day prior, Jackson's like, I object to you saying the C word. You're gonna say it. And by the way, tomorrow when I have you on the stand, I'm gonna make you say it a lot.
Yep. No, and it's especially fun when you've got, either a jury or a female judge.
Emily, if you want to see me annihilate the chart data, I have this is going to be the most. If Jackson is armed, which I imagine he is, with months of prepping for this cross, and I was able to just destroy that chart with 3 hours this afternoon, just thinking about it, Monday is going to be perhaps one of the biggest, these guys they might come to blows outside this courtroom. I don't know. But let's find out what this witness can testify to, because we now learn new things. This is now a trial. In trial, we learn.
Rob, now you're giving me a new life goal.
What's the new goal? To get into a fist fight in trial?
I've never actually been punched by a cop, so.
I've had a therapist take a swing at me.
What's that?
I've had a therapist take a swing at me.
See, that is ideal.
Oh, Emily, we know. He's prepped. He knows. Former prosecutor, right? So, yeah. This is fun, though. This part's fun.
In this Carr's report about watching that video.
No, because I watched the video after the report was done, and I watched it first time on Court TV. So
who?
Court TV with the shout out.
During this trial?
You hear Jackson do a full wait.
He does a full what the?
Wait, what? Did you just say what I think you said? Did you really do that?
Meanwhile, Court TV was like, clip that, put it in the ads, put it in the ads.
Yes, he did. He prosecuted Phil Spector. Also, didn't he also rep Weinstein? Trust me, this dude he knows his way around a courtroom, and he's not afraid of dangerous cross-examination at all.
Prior here.
No, when it was on TV at some point.
When did you and Mr. Lally have a discussion about you testifying about this video?
That was a couple weeks ago?
I'm sorry, I couldn't understand.
A couple of weeks ago?
What's a couple of weeks ago? Is it 10 days ago?
Days ago? 2 weeks ago? I mean, 2 weeks ago? Couple?
Okay.
Two?
Where did you two meet?
At the DA's office.
Was that at your request or was that at Mr. Lally's request?
It was a pre-conference hearing, or pre-trial hearing.
Right. Well, those
Or
are
pre-trial conference, sorry.
done.
So, yes.
We're talking over each other. I'm trying not to talk over each other.
I'm trying not either.
All right, that was a dick move by Alan. That's a dick move. Like, that was a little bit like, you don't got to do that, man. I'm going to call you out when you do it.
I mean, he does not like this guy.
No, they hate each other. And if you ever had a question about whether they did, lawyers don't usually do that part. Like, in voir dire, no jury present.
Let's both try harder.
Okay.
Who set up the meeting?
From my pre-trial.
Yes.
Okay.
Paul.
Yes.
Adam Lally.
Who was at the meeting?
Everybody sitting right here. Lieutenant Tully.
Lieutenant Tully, you, Adam Lally, Laura McLaughlin. I'm guessing Miss Gilman was not there.
She was not there. Correct.
How much you want to bet this list of characters comes up on Monday, regardless of whether he can testify about any of this? Because now Jackson knows who was there, and already he knows, and he's going to start having to go down the list.
Yeah.
Did Mr. Lally show you this video at that meeting?
Yes.
Did he tell you that he intended to ask you some questions about this video at that meeting?
Yes.
Did he ask you whether or not you could render an opinion as to whether or not the impact that you saw or lack thereof, whatever the case may be, was consistent or inconsistent with damage to the tail light?
Yes.
Did you tell him that you would give him such opinion if called upon at trial?
Yes.
Did anybody take any notes?
I don't know.
Were you taking notes?
Yes.
Where are those notes, Trooper
Wait,
Paul?
how do
I think
you
I just
not
won't
know
note
if
down
anyone
this
was taking
specifically, but
notes?
Just, you know.
Now we have written statements that weren't disclosed. Oh, this is getting so much worse. And Emily
Well,
just
and also,
on me.
how does he not know if anyone was taking notes if he was taking notes?
Emily just dropped private knowledge on me that I didn't know. Jackson was an Air Force jet engine mechanic before becoming a DA. He is going to annihilate this witness. Oh my God.
That is the best thing I've heard.
Legit mechanical engineer. This is going to be the most gnarly cross. What do I have on Monday? I have to look at my calendar. What do I have on Monday? Do I have to do anything on Monday? I don't want to do anything on Monday. Monday. I have one meeting. I'm all in, man. This is going to be playing full volume in my freaking office.
Most people just like blast Van Halen. Rob is going to be blasting Jackson.
Because this is going to be usually the battle of the attorney versus the expert. You have the attorney who gains a great deal of information via their own expert. They know a lot going into it. They don't usually have that foundation. They don't usually have that prior knowledge of how mechanics works.
It's going to be fun.
All right. Sorry. I got distracted. I apologize, chat. I'm sorry, chat. Moving on. We're figuring out about non-disclosed things, which are also significant.
Make sure I had, my everything checks and balance. And for what I want to talk about, what we're going to talk about.
Make sure you had
My
what?
checks and balances, sorry.
Checks and balances.
Just make sure I'm more on the same page of what we understand what's going on in the trial.
You want to make sure that you're on the same page with Mr. Lally about what's going on in trial.
Yes.
All right. Did Mr. Lally take notes?
I have no idea.
You were watching him. I mean, was he writing something down?
I wasn't paying attention to his note taking.
Miss McLaughlin was there. Was she taking notes?
I don't know.
You didn't see her either?
I don't know if there were people who were taking notes, writing stuff down, or what they're writing stuff down in relation to our conference.
Did you give him an opinion? We've asked whether or not you were asked to give an opinion, and you said, yes, 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 I was.
Yep.
Did you give an opinion at that meeting about whether or not you believe, in your opinion, the contact between the SUV and the Traverse, the Lexus and the Traverse, could result in the damage to the tail,
That's the magic question. Right there. That's the question. That's a very specific question.
Mm-hmm.
Because it appears that you're about to testify to that opinion, which we just went through your qualifications that I don't think you're qualified to make that opinion, but you just testified that you, an expert in accident reconstruction, formed this expert opinion on whether the taillight was cracked via this method. Funny thing about opinions by experts, you have to disclose them pretty far in advance of trial. Depending on your state rules, in Virginia, I have to disclose experts 90 days prior to trial. 90 days prior to trial, I have to disclose their opinion. Rebuttal experts, 60 days prior to trial. You know what's like a lot shorter than 60 and 90? Like 10 days.
10 seconds? Yeah.
So let's hear about the opinion and when people knew about it.
Yes.
What did you tell him in the meeting?
What we talked about already in the stand here.
Okay. So what you related to him was exactly what you've relayed in this court.
Yes.
All right. And he asked you, he told you that he was going to ask, I'm going to ask you to look at the video, correct?
Yes.
You're going to be asked a series of questions about that video, correct?
He told me the video and he said, okay, this is the video. This is what they think the taillight was broken. And these are the pictures of his car that they take. So they asked my opinion on, do you think that's where a taillight would be broken?
And he said, and he told you, you need to make sure that you tell the jurors that couldn't have happened in this impact, right?
All right, that's reaching Lolly. I mean, I see where you're going. Or not Lolly, Jackson. You're trying really hard. He's not going to say that. Come on.
I mean, this guy is.
He didn't tell me I'd make sure jurors. I mean, that's my opinion on. It doesn't.
Go ahead, Ian. Sorry, I didn't mean to cut you off.
This guy isn't exactly like Lex Luthor, notwithstanding the head polish, but I would have taken the shot too.
Did they all shave their heads in solidarity? Is that a thing? I don't know what happens.
I don't know.
Is it a trooper thing?
I'm going to assume it's a fetish thing.
Wow. That I didn't predict that. Okay.
Rob's like,
no.
Why?
Oh, I don't like that at all.
Appear to happen in that video.
Did he tell you that it would be helpful to the prosecution if you said that it would be, that it was inconsistent with the taillight break?
Objection.
I'm going to allow it. Did he tell you it would be helpful?
The hesitation in Bev's voice pissed me off there. You just let him openly speculate during direct, and like you overruled every one of Jackson's proper objections. You better let him get away with this. Like, come on, it's voir dire, just like you said.
To the case if you said that.
No.
But you knew it would be, right?
I'm just stating what I saw on my professional opinion on what it is. If it looked like it was consistent, I would say it's consistent. If it wasn't consistent, it's not consistent. I'm not going to.
I'm sure that's what you would say.
Okay, so comments are not appropriate for the jury. They're all.
Jackson's already been admonished. He knows the jury's not there. He knows that Judge Bev hates this bullshit, and he's still.
And that's the thing is.
Oh God.
That's the thing. People were like upset with Judge Bev on like was it the Monday or whatever when And I was like, she just hates theatrics. She just hates that as a thing. It's not that she's actually like, so.
To be honest, she would be within her right to start sanctioning the attorneys. Like every time you pull one of these bullshit like theatrical moves in front of me when we're arguing motions, I'm gonna hit you for $100.
Yeah, and that comment of shame on you, she could have dropped a financial penalty on that.
That could have been $5K. And I know judges that would very quickly hit him with a $5K punishment. Like,
yeah,
go to court 5,000 by Monday. So if Judge Bev really wants to change the back and forth, because they're both doing it, you want to change that dynamic, start hitting for $100 every time. We keep a running tally.
I heard of a judge at one point who was, what do you call it? Oh, fuck. This guy's shown up again. Goodbye.
Oh, we have a troll?
Yeah, we got a troll.
No, they happen.
He's a troll who obviously hasn't done his homework, but we got a troll.
Troll of you, troll of me, troll of all of us.
Oh, he's trolling me.
Oh, that's fair.
And he's a moron.
Okay. But you were in the middle of thought. You had a judge this one time.
Oh, yes.
I made the comment. Hit him for
There's a file where the judge like basically kept a running tally of penalties, and the penalties were to be paid to the other lawyer for them being shitty to each other. And so afterwards, one of them had to pay like $300 to the other with this like calculation of all of that. So,
but that's fair game. The judge is allowed to do that. Start hitting them for $100 each time. You don't like the behavior? Start sanctioning.
Thank you, Miss Christy B.
You don't get to hold them in contempt, but you can start hitting them with sanctions.
We're also not very good for me, Mr. Jackson.
Understood, Your Honor. Did you formalize your new opinion? Because this is a new opinion, right? You've never been asked this opinion before.
Yes.
Did you formalize this new opinion?
Well, that sucks for the prosecution. That sucks a whole lot. Brand new.
In any kind of a report or memorialize it in any way?
No.
Did Mr. Lally ask you to create a report of some sort that you then turn over to the defense so that we would know that you have a new opinion that you're going to testify about?
No.
Did you save those notes that you took about making sure that you were on the same page as Mr. Lally?
That's me.
Come on. I need this. I need to get through this. Come on, YouTube.
Yeah. I saved mine.
Where are they?
They're my report.
They're in your report?
Yeah. As I was writing a report, I just kind of like highlighted stuff that I want to make sure I.
Sir, I really hate to say it this condescending, but were you dumb enough to interlineate and write notes on top of your pre-published report? Please tell me you weren't. Because the second that you put pen on that paper, man, Ian, what happens? The second the witness puts pen on paper, prosecution witness, what happens?
I mean, he's got to turn that over.
The pen, the interlineated report with all the notes. Yes. Like even if the note says, Lally asked me this question.
Fun.
I memorize and remember my report.
Okay. I'm talking about notes specifically about this video, seeing this video and rendering a new opinion about this video.
No, I didn't have notes specifically about this video. I didn't write anything down saying I must do this on this video.
Did you write anything down about the new opinion that you had come up with related to this video?
No, I did not.
I'm just moving on.
Yep.
And your opinion ultimately that you imparted to Mr. Lally in that meeting was that the car did not move and the snow did not move, correct?
Correct.
I think that's all I have.
All right. Did you want to follow up at all, Mr. Lally?
No, thank you, Your Honor.
All right. So, Trooper, you are all set for today.
No, thank you, Your Honor. There's no undoing that mess that just transpired. I can't fix what just came out in court.
Well, and anything he would have tried to do to fix it just makes things worse.
So much worse. Now the judge gets to yell at both of them. And honestly, I'm with Judge Bev on the yelling at both of them part, because they both kind of they can't get the trial attorney out of them. They just won't shut up. They hate each other, and they're
both really pissed.
They hate each other. These guys have got. I think if you put them in a bar, you'd see them fight.
We'll see you Monday.
I would pay money to watch that.
The obligation to provide us with any new opinions that any expert's going to testify to.
My money's on Jackson in that
They've known
one.
about this witness for not months, for a year, for a couple of years. They've known exactly what this witness has memorialized in his official report. They knew that the only thing that we had was the official report. They met with him 2 weeks ago. This has become a pattern of conduct by the Commonwealth over and over and over. We're finding these witnesses getting on the stand, finding out that there's been a sort of preemptive strike in some sort of a prep interview.
Preemptive strike? Where does he get that? He's quick.
Where they're coming up with new opinions, new conclusions, new facts. It happened with Jennifer McCabe. It's a new fact about coming up, going to Michael Lank's house. It happened with Officer Sarah, coming up with a new determination about what was said or not said at the scene that we had never heard before. That was also a prep session of some sort, or I believe it was. And then this witness, literally, it's not even like just was it light out or was it dark out. This is a completely new opinion based on evidence that we presented, both in or talked about in opening statement and have presented variously throughout this trial. And this officer gets on the stand and now has a new central opinion about whether or not we're right and that taillight lens could be cracked. That's something that should have at least been reduced to writing. And even if it was reduced to writing, it should have been excluded because it's a discovery violation. It's late. We don't have time to prepare for it. And we're caught off guard. I use the word at sidebar ambush, and I know that rankles the court, and the court doesn't like it, but that's exactly what it feels like.
Well, that's been used both ways here, right? So it's a word. Let's just take it out of here. Make your point. Okay.
I'll see if I can come up with a synonym for it.
Well,
that's where I'm like, Judge Bev, you and I we're on the same page. They throw a lot of hyperbole at each other, both of them.
But the thing is, it's not. I don't hate the ambush, right? Ambush kind of feels correct.
Correct. The problem is when you have used, it's like the boy who cried wolf. When you have used ambush that many times in the motions leading up to this, and now you're using it again, the judge is like, can we get a thesaurus? Because I can't do with the same word over. And Judge, I'm with you on this one. I am. But Lolly hears the judge admonish Jackson for the theatrics. Hears it like multiple times. And what does Lolly do when he stands up?
I understand your argument. So focus on just continue where you were, but no comment whether I like ambush or don't like ambush. It's a word I've heard a lot on both sides.
I understand, Your Honor. My point is the evidence that now is being sought should never be presented in front of you. We didn't have opportunity to get this in advance. It's at least been in the Commonwealth's possession for weeks. He took notes about it. He now says, well, I didn't take notes about that specifically. I don't believe that as far as I can go. I think he did take notes about it. He was shown the video. He provided a new opinion. Mr. Lally knew that he was providing a new opinion. And then the first time he discloses this opinion is in front of the 16 jurors, 15 jurors. We would ask for its exclusion.
All right, Mr. Lally.
Yes, Your Honor. As far as the pattern, especially coming from counsel, I simply find it laughable. As far as Officer
Bold.
His first sentence, the judge just admonished Jackson like 3 times. And your first sentence is to go straight with the histrionics.
Yeah. It was a decision.
It's a choice.
Yeah, choices were made.
That gives you the idea. These two hate each other. They see red. It doesn't matter what Judge Bev tells them. They cannot let any of that slide. This is great.
Sheriff, I think what counsel was referring to was testimony that was in his grand jury testimony. It was crossed about whether or not it was in his report, but it was in his grand jury testimony. As far as Ms. McCabe is concerned, that was regarding reciprocal discovery that was given to the Commonwealth weeks into trial by the defendant. It was then shown to a witness, which is perfectly permissible. Counsel asked a question of Ms. McCabe on cross, and she was aware of the material based on the late disclosure of reciprocal discovery. So there's no violation there. As it relates to, and why I say laughable, Your Honor, is that I am still...
I don't like hearing you say laughable. Just
Understood.
Stick to what the arguments are. And
With respect to this witness...
Hold on. Quit the finger pointing, name calling, things like that, please. I
Yes.
know it's been a long week. It's been a particularly long day, but just focus on what you want to argue to me.
And I apologize to the court for that, Your Honor. With respect to this testimony, it's well within his realm as a crash reconstructionist. This is a witness who's responded to and investigated hundreds of crashes involving damage to vehicles. Simply making an observation of contact between 2 vehicles or purported contact between 2 vehicles on a video. The force is self-evident, and whether or not that force is sufficient to cause the damage that he personally observed on the defendant's vehicle is well within his expertise. And should be permissible as far as for this witness to be able to testify to.
What about the non-disclosure to the defense? So showing this video and asking for an opinion. What about that?
So, Your Honor, what I would say is I did not show this video and ask this opinion. This is a video that actually the trooper mentioned to me that he had seen over the...
Mm-hmm. We can do this.
Course of while the case was pending, probably over a year ago, that he had...
He didn't say that.
Seen that video. What I showed him was the photographs of Mr. O'Keefe's vehicle and asked whether or not he observed any damage consistent with the damage to the taillight observing or popping up on Mr. O'Keefe's vehicle.
Why wasn't that turned in?
In hindsight, it should have been, Your Honor.
And that's what I turned my ruling on, but I don't think she's going to do it. I don't know. I'm torn on this one. So she takes it under advisement. I had a request to go back to when this particular trooper leaves the podium or leaves the stand and walks past Jackson. Apparently there's a bit of... Let's see.
All right, so Trooper, you are all set for today. We will see you Monday morning.
Thank you.
Okay.
Let's go real time. Real time. Nope, no editing. Do that. Bro, you really hate him that much? You're staring a hole into his back. He's out of the courtroom. My God. Really?
Really doesn't like
Okay, Monday is going to be my favorite day. Monday is my new favorite day. Andrea, damn it, Andrea. Don't jump to my conclusion before I get there. Andrea's right. The judge is going to say that this was something that was known to the defense and that the defense was going to present the expert of their own. But because the opinion was not disclosed properly in the prosecution's case, basically in advancing their case. They can't introduce it in their case in chief, but in response to the defense expert, they can recall this person to testify as a rebuttal expert to something that they learned during the course of that expert's testimony. So Andrea's right.
I don't like that.
Beat me to it. God, too quick.
Action's got to have consequences.
They don't get to introduce it now. So we'll see. What it does is it changes the order of the presentation of the evidence. Wait, it's backwards. It's supposed to be that way. It changes the order of presentation where it allows the defense to present their expert first and get out ahead of it, and then allows the prosecution to come back and say, but our expert says this. So we'll see. That's the Jackson stare. So that's going to be Monday. Monday is going to be nuts. Ian is going to do a full breakdown at some point in time over the weekend. So my mouse has been crazy. Stop. Of today's testimony, because there's a lot more to go through that we hit in something like this, because we covered, well, Judge Glanville. So I've got to catch up on super chats or just prior to me doing that. Let me do this. Ian,
I may also die of exhaustion this weekend, because guess what else dropped?
No.
3 filings on
Braun.
Janet.
Say that. Are they good or are they bad?
I have only glanced at them so far.
What are they? What are the titles?
They're the responses to the to Janet's lawyer's filings. So it's just, reply times 3. But yeah, it's going to be interesting.
Well, so you'll be busy this weekend.
I will indeed.
I've got to pack stuff into boxes, but Janet is doing Janet stuff.
She's got no other way to be.
Emily D. Baker, who I did not know was a member, who has been a member for 5 months. Thank you for using the member chat. Chances the jury gets this in July.
I want this to be done before Baldwin starts.
Emily, I'm going to say 0, and here's why. I have no doubt the prosecution is going to rest probably, what are we thinking, Wednesday next week? Tuesday next week?
Might be Monday.
No, they are not ending with the brutal cross-examination of this accident reconstructionist and the ME on for 2 minutes.
Well, Tuesday is all voir dire.
Wednesday. They'll finish Wednesday. You're not giving this to the jury on the heels of this bullshit. There's no way.
It depends on whether he's got the ME.
Who else she got? Accident reconstructionist. She had the cell phone explanation. We need her cell phone. Her cell phone data we still need, right? We don't have that yet. So that's a half day. ME, you figure, what, 30 minutes
Yeah,
on
Wednesday's a day off.
On cross, or an hour and a half on cross. Wednesday's off?
Yep.
Thursday. They'll submit.
That sucks because I'm in court on Thursday.
So Thursday will be the end of their case. Move the counter. Thursday brings us to the 20th. Defense case will begin in earnest. So I imagine Thursday, prosecution will rest. A judge will take up motions Thursday afternoon, or she'll release the jury for Friday and take up motions on Friday. She likes just the short Fridays. So defense case begins in earnest on the 24th. They hand the case over for rebuttal on the 28th, 27th, 28th. They use the whole week. And then Lolly, I imagine, I would estimate that a good lawyer would know when to not put something on in rebuttal and know they've lost the jury on issues. Lolly's not going to do that. Lolly's going to take 2 days in rebuttal.
Those two things don't go together.
That's what I mean. Lolly's going to take at least 2 or 3 days in rebuttal. So I would say the jury is not getting this case until after the July 4th holiday.
Sucks to be Bev.
There's no way. I'm looking at the calendar. There's no way. Not with what's going on. Right? Like, I just did the math. That's so the jury will probably get the case, and you guys can troll me in the chat if I'm wrong. I think the jury's going to get the case on. You know what? I'm going to be bold in my prediction. We're going to do closings on July 3rd. Jury got the long weekend. No, we're not going to do that. What's she going to do? What's she going to do? Closings on the 3rd? No, she's not going to give them time after closing before deliberation. She's going to deliberate right away. They will reach the end of evidence sometime Wednesday morning, mid-morning. And Bev is going to say, this is my prediction. Bev is going to say, we're not going to do closings right now. I'm going to give you the holiday. Report back here on July 8th. I'm sorry that you have to come back. I know I said that you're going to get this done by the end of June, but circumstances are what they are. July 8th, we will do closing arguments, and the jury will get the case at the end of July 8th. That's my prediction. So there's just too much to go through.
It's going to be interesting.
Okay. So
I got a lengthy hearing on Thursday. It's going to be a pain in the butt.
What's the issue?
It is a firearms issue. It is whether I get to re-argue a certain issue that needs re-arguing because the court got it wrong in a huge way. So, yeah.
Well, Thursday's going to be tough, but I'm sure you're going to recap the hell out of that.
I'm going to figure it out.
Chris Bowman, I hope you're wrong. I don't think I'm wrong. Based on how this trial has progressed, Ian, do you think my time estimate's way off?
Not way off. I'm not sure I entirely agree with it, but
you think they'll get it by the end of June or July 1st?
Hard to say, but I think the judge wants them to.
Oh, I know she wants him to. But Lolly can't put together a question to save his life.
Yeah, she's going to start getting more and more frustrated with that.
Yeah, that's true. Other frustrations that exist. And the last topic, as I start going through super chats, is the
holiday here.
Ian, do you remember Sarah Boone? Or she remembers.
I do. She's running out of lawyers.
This one is asking to say bye-bye. So after the struggle session that existed in open court, where Sarah
I like how people in your chat are now starting to call Nightbot Fightbot.
No, they're not. Leave Nightbot.
Yes, they are.
Very nice. Sarah Boone, and this is going to be a 5-minute thing. Sarah Boone, after that struggle session in open court, where she said, I just wish my lawyer would be nice to me.
It's like, lady, that's not your lawyer's job.
So lawyer number 8, within a couple of days of that, files this motion to withdraw his counsel. So defense counsel Patricia Cashman respectfully moves the honorable court to enter its order, allowing said defense counsel to withdraw from further representation in the above styled cause. As grounds, therefore, defense counsel would state as follows. Defense charged above styled cause with second-degree murder. Undersigned counsel was appointed to represent Sarah Boone on February 9th of 2024. Trial is set for October 7th, which will allow new counsel time to prepare for said trial. No way. No. Let me give you a preview. Judge ain't letting her out. Either that, no. Judge not letting her out, or Sarah Boone goes solo. The Florida rule that she references as far as providing the grounds, it states as follows: representing adverse interests, except as provided in subsection B, which is the exception to this rule, a lawyer must not represent a client if 2, there's a substantial risk that the representation of one or more clients will materially limit my brain. No, I scrolled too fast. No, I didn't. Will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. Basically, this is taking all of my time, and I have other clients that I need to service and help. And I have my own life, and I can't deal with Sarah Boone. 4, irreconcilable differences, including but not limited to ethical considerations, have arisen such that counsel can no longer provide representation. Basically, my client is accusing me of malpractice. I can't keep doing this. Please, God, let me out. And
My client is a jerk face.
What?
That's what that means.
Oh, yeah. My client is asking me to do something I cannot do. So my prediction on this one is the judge is going to say, I am sorry, Ms. Cashman, this really sucks, but I have to keep you in this case unless, Ms. Boone, if you, understanding this, want to go solo, you can, but you recognize that by this lawyer withdrawing,
I think they're going to let the lawyer out because I don't see how they hold her on the ethical issues. And
the judge gets to inquire on those.
Do they?
Yep.
Where I am, they pretty much don't, because they can ask, and the answer is almost always, that's privileged.
Well,
and then the judge is like, okay, cool. I guess I'm stuck.
Those little ex parte hearings that are actually sometimes allowed. One of them at least in Virginia where I am, one of them is if I put something into a motion like that, the judge is allowed to have an ex parte outside the presence of the other attorney inquiry with me to go through whether the withdrawal is mandatory or permissive and whether the judge feels I can be let out. So I don't know. I think it's put up or shut up. I think she's going forward in trial. I don't think trial date's not getting moved. I don't think it's getting moved. So we shall see. That's what it is. I've got a lot of super chats to catch up to because I was putting a lot of them off because we were going through so much. We had Natalie on and we had a lot to cover. So I'm going to swoop to those. Ian, you're free to jump off at any point in time. I know you got videos to make. But you're welcome.
I am exhausted, but I will stick around for a bit and then, yeah.
Okay. We're going to swoop to super chat catch up. And what I am
You're
going
more
to
than 100 deep. You are.
That's what. Don't say that out loud. What I mean by that is I'm turning them off.
Hey, good problems to have.
Chat is very generous, and chat is also very opinionated about Karen Reed, Sarah Boone, and Judge Glanville.
Oh,
So,
absolutely. Also, Chad is asking who Janet is. Janet is the sort of nickname for Jeanette Braun. She didn't pick that nickname other than by putting it in a court filing is the thing that pisses her off, which means that it is now forever her nickname. Because when you tell people that being called something pisses you off, they will never stop calling you that. So now you might be wondering, why do you care about this random person? She is a lawyer who is suing several content creators based on allegations of defamation that are, in my opinion, super thin. And yeah, her filings are hilarious, and I enjoy going through them. Right now, the ones that we'll be going through as soon as I get to going through 100 pages of or more of stuff, I think it's like a whole pile of stuff, are the replies to her latest filings. So It'll be fun.
Janet she's a character, indeed. So, catching up on speed mode. For those of you who are wondering why I'm coughing so much, I still have a lingering cold, which is still an ear infection that hasn't gone away. But the cool thing is I got these headphones that are vibration kind, so they don't go in my ear. So actually, like, not painfully listen to what's going on. So still struggling, but the sickness is still there, and I just need to get going. And yes, I have been to a doctor. I've been through antibiotics at least once. So we're going to go through a second round because I need to be feeling a lot better going into the next couple of weeks. I had a big move thing scheduled in July. So I took all of my trials and I was like, cannot have trials during this period of time. What that did was it said, well, you can have them here in June and you can have them in August. So June and May has been a very difficult month. So that's where we are.
Rob, I just want to say for the record, you are not nailing speed mode.
I know. Sorry, buddy. Lucy Ray, thank you very much. Lost an appeal today because the client was pro se at lower court. Didn't preserve any issues for appeal. Don't go to court without counsel, people. Happy Friday, everyone. Very good advice.
Yes.
Very good advice. K-Rab. Proctor and his text messages were terrible. They made his testimony entirely unbelievable. I'm sure he insulted everyone in the jury in some way. He completely killed any progress prosecution had made. I'm inclined to agree, but I'm not going to speculate on what the jurors perceived. Tracy Fagan, I think the way he was talked about her medical conditions was the worst than name calling. It felt some kind of gross when I referenced to the balloon. I'm not going to repeat it. That made me uncomfortable. Lisbeth, if anything,
that was really gross. The whole, leaky balloon knot stuff.
It just, come on, man. That's zero class. Lisbeth, if anything, Lolly getting ahead of it took shock away, making it possible to focus on AJ's timeline. I don't think it took the shock away. It still hit me. Azam, this week was wild to say the least. It was mind-blowing indeed. Moondragon, today is my mom's birthday. Tomorrow is mine. Happy birthday to mom. And actually, right now, 12:30 a.m., happy birthday to you. So happy birthday to both of you. Hope you have a wonderful birthday week. Kendra Shelby, over here cussing this judge out. He's a little something for the yellow dollar sign. That would be in reference to Judge Glanville. Worthy of the cursey words. Absolutely. Kristen, a Natalie robot was planned, but I was put on a robot ban. Kristen, I have to build a whole new jury box. I have to build a jury box. I have to build a gallery. Keep making robots. And there's only so much space. Natalie is always welcome, and she's a very good friend of the channel. So I loved having her on tonight. It was awesome. Casey Cat Merchant said that what he did with the ex parte meeting in itself is absolutely reversible error. I'm inclined to agree. The higher court needs to step in now. They can't unless the issue is certified for appeal immediately. Rockfish Fish. Judges made an attorney write a 37-page paper for being late. He did, indeed. In this case, Glanville. And that's in the Young Thug trial. Ringa, was there ever a sidebar about this, or would that even be appropriate? It could be appropriate because that would at least give notice to the defense of what was happening, but that didn't happen. Marisma, cheers, Elroy, 16-year-old service pup crossing over the Rainbow Bridge. Cheers to Elroy, the service you gave and the family that you assisted. I'm sure that they will remember you forever and always, and may you find endless fields of joy full of all the tennis balls and treats you can ever imagine. Liz McFall, my dog's name is Dog Holiday. Phenomenal. The Chugi Show live. What do you think about the possibility she accidentally hit him, but Higgins or someone finished him by beating him up, and the people in the house are covering that up? How did no one see him in the yard? I don't know. The only thing I know for sure is I am so far away from from beyond reasonable doubt that I have all of the doubts.
The thing is I can come up with like at least 4 plausible ways for this to have happened. And if I've got 4 ways that it could have happened, and several of them don't involve, Karen being guilty, then I can't convict. Sorry.
That simple, the explanation I gave on the car data, that was just like a little bit of time thinking. If a juror has had experience with cars, that's reasonable doubt right there. The missing videos, the clips, all of it, man, I am so confused on how this made it to trial, especially on the issue of intentionality. Are you fucking kidding me? You're telling me that she, 9 drinks deep, looks in her rearview mirror, has the ability to navigate down a curved street that's snowed upon, accelerating to 24 miles an hour in reverse, and strikes John O'Keefe intentionally? And the prosecution,
apparently her last name is Wick.
Doubt. You said apparently her last name is what?
Wick.
John. Yeah.
Like she's just like.
Ashley Linnell on the stand today. Woody said he wanted to kill Young Thug. How's this going? I have no idea what's going on at all. Miss Christy B, thanks for for introing me to Natalie, and thanks for FNF while I sip vodka soda, craft hand-rolled papers, flowers. That's awesome. I'm glad that you're doing that and crafting those hand-rolled paper flowers. Those are so cool to see. Elizabeth Love, a lot of Georgia courts, DAs are decent in my opinion, but a few counties, courts, and DAs are so bad that redacted did not shoot myself in the foot. That's a fair redaction, and I think that that's a fair assessment. Terry, I like that name. That's really clever. Glanville asked prosecutor Love to explain his wrong. Just because I like candy from ATHF could be used in court. Mess up the mix up the mess. Come on down, yo. Here's the address at 612 Wharf Avenue, right next to the Gentleman's Club. Okay. Guess we could use that in court. Based on this trial, we could. The Young Thug trial. Bez from Quebec, my last proper pizza was 20 years ago. Celiac diet since then. Oh my God, I am so sorry. Ian's pizza is killing me. I am sorry that you had to witness any of that. Ian, apologize to Vez. That was terrible.
They make a gluten-free one.
It's true. Just because it says, sorry, it's I want candy. I want candy, bubblegum, and taffy. Okay. Cindy Collins had my cap and gown for my accounting program on Wednesday. Congratulations on the graduation. And on vacation this week. Been watching so much trial all week long. Well, seen some stuff. You have seen some things this week. Over Newman for the upcoming next Tuesday demonetization fund. Oh, the Monday is going to be a fun day indeed. Ian's recap on Monday is just going to be just one long goat scream. Just the entire.
We're just going to go until this thing runs out of batteries.
Then we're going to replace them. Keep on going.
Phrasing.
Got my eldest from uni today. So all 3 sons are home. Congratulations on the full and happy household. That must feel wonderful. Tracy Sires, I'd really like to know what it was that the grand jury saw that made them decide that the case against Karen Reed should go to trial. Grand juries want them to see. That's it.
Grand juries will indict a ham sandwich is the famous line. The prosecutor gets to present basically the evidence they want to present and leave out a lot of other stuff. If the grand jury doesn't return a true bill, as a prosecutor, it probably means that you need to not, because they'll send things to trial that are, that get just obviously destroyed at trial.
So. Oh yeah, because they're allowed to use speculation, hearsay, conclusions. So they're allowed to do damn near anything. So, Z, Ari, Runkle, and Bang Bang. You need to hear Turtle Boys. Okay.
Okay.
2008, celebrating my first night of summer vacation after a long year of teaching first grade special education with a Malibu and Coke and FNF. One, thank you for teaching, especially that grade and especially those children.
That's a little bit of heroism right there.
I hope it's remarkably rewarding. I imagine it is, and I imagine there's a lot of frustration, difficulty, tears, emotion that goes into it. So thank you for doing what you do. You definitely deserve that Malibu and Coke, and enjoy your weekend. Congratulations. So on finishing that. Lynn Britton, who, if anyone, is ready for Runkle Spice on Lolly? I
am.
Rachel Dueck, thank you for the gifted memberships. Very kind of you. And for all of those that gifted memberships, I pulled some of them as we were talking because it was impossible to you guys have made the channel so much fun to keep coming back to. And the support you give is remarkable and so very much appreciated, both for me and for all of my friends and for those who are around, for Mischief. You know how you can give even more support to the channel that would make me feel like a million times better? Runkle's recaps have been the coolest things in the world because he has Court TV show up in the chat, and it's great because you can actually engage with Court TV and you can troll them a little bit about the OnlyFan if you want. Actually talk back. It's really fun.
Court TV's actually got some pretty good hustle for engaging with the with sort of the YouTube community, and I gotta say they're also much more chill and much more cool than like Law and Crime ever was. Because Law and Crime was like, oh yeah, we're gonna start going to war with channels. It's like no. Court TV recognizes that we can build off each other, not we don't have to fight.
Yeah, Court TV realizes that this is part of our audience. Like they're feeding our audience. Like people watch recaps, but they'll go back to the live feed or they'll watch it live. Like this helps. So I love to see what they've done. But please, if you guys like the channel, if you like being here, I ask and beg you, please go and watch Ian's recaps. And when you're there, send encouragement, whether it's a membership chat, gifted memberships, super chat, or just the chat. Engage with people there. Please, please, please engage and like the streams when you're there. And for the 5,776 of you that are still here, I would like for you specifically, so I am struggling to make it through last of these lovely chat and conversations with everybody here. Please hit the like button on this stream. Very much appreciated. These streams, what's funny about it is the likes we get 1,000. The most likes that I've gotten on an FNF in the past 2 months, 4,000. So if we could exceed that, it'd be awesome. 5,000 of you here, so
hit the button. Doesn't cost anything for now.
Consider subscribing because, like I said, I'm not going to inundate your inbox with a bunch of notifications. You're going to get like one for Fridays. And by the way, when I do cover a trial, I go in depth like Ian does on the recaps. So I've been allowed one of those per year. Nuptials. It's part of the nuptials. One of those per year. Right. Serious question. Where do lawyers learn? What, if any? Do they learn it in law school or from bad mentors? Bad mentors. It's always bad mentors. The what, if any trick? Yeah, it's bad mentors. Mind your business. Love the name. Thanks to you and Ian and EDB for being open about ADHD. I was diagnosed at 30 and struggled with believing in myself. 33 now, and tomorrow I graduate with my psychiatry BA from my dream school. I hope to be a therapist. I wish I had. Hope to be the therapist I wish I had. I guess the therapist that was treating you. Appreciate y'all. Love, Lee. Lee, I'm so proud of you.
That is amazing.
Amazing. Like beaming with pride and happy that you are not letting anything hold you back or believing that anything could. ADHD can be a superpower when you use it right. That's so cool. Still my favorite messages. That's so freaking neat. Brandon, 24.5 kilometers per hour, maybe. I don't know. We didn't get testimony on that. Rossetti, expert lost credibility when they said tires don't screech with anti-lock brakes. Also, that they ignored the fact that hitting a human body at 24 miles an hour would maybe make a noise. Like, I've hit a deer at 30 miles an hour, and I will tell you right now, if there was a house right in front of it, they would have heard me hit the damn deer.
We're not going to test this, folks.
No, we're not. At all. Ever. Mama Bear of One, I need prayers. It's my mom's funeral tomorrow.
I'm sorry, Mama Bear.
Judging by the timing, Mama Bear, the funeral is today. It's going to be a very weird experience. You're allowed to cry. You're allowed to not cry. You're allowed to do whatever you need to do in that moment. Just know that it's going to be very weird wrestling with these emotions for the next few weeks, months, and perhaps years. Take it in stride and take each day, do the next thing. Before you know it, you'll be on the right path again. Also, don't stop talking to your mom. It's cathartic. Focus on the good. And if there's some bad stuff that creeps up, yelling at clouds does help. Actually, it really does.
Just like F you, Cloud.
Uh-huh. Yeah. Very therapeutic. Megan Easton, can experts be brought in for the right price? You see them in most trials on each side, wondering the lawyer's take on this. Oh, yeah. Experts will testify to what you want to testify to. Now,
There's a paper on this, and it's literally titled Courtroom Whores.
Yeah.
Now, there are honest experts, but there's a lot of experts who basically their opinion is whatever side you're on should win. So,
a good example, the experts that were hired by a certain defendant in a trial that took place in Fairfax County regarding defamation.
I don't recall any such trials.
No trial at all. Those experts clearly did not testify to whatever it was they were paid to testify to. No, they exist. Now, what I will say is that the expert testified this morning in this case, I didn't hate. I thought there were things that she left out, but I thought she was actually very, very honest. And it didn't seem like she was reaching when she got to her conclusions. Crazy Cat Queen, I'd call ER doc, ER nurse, and ME if defense. They're going to call a lot of people. Julie, my nurse brain doesn't believe he was hit by a car. My normal brain can't reconcile the injuries. Bruce West, it would have helped to know which direction John's body was facing when found. Thinking back through the testimony, I don't know that we got that.
I think we did, but I can't remember. So
we'll have to wrap it up in close. That'll have to be argued in close.
Yeah.
Potato Pirate, FYI, dog bites often do not connect with bottom jaw. I didn't know that. Very interesting. Chris Cat Queen, plot twist, Lolly didn't want to bring this case, but was forced to by LEOs. So he's tanking the trial by being terrible. Nope.
No, he very clearly believes in what he's doing.
He is invested. Julia, my 4-year-old was hit by a car. Driver drove off and claimed she didn't hit her. Luckily, there was video of it. I'm not convinced KR did that based on her actions alone. I don't know. Like I said, I don't know, which is a place I shouldn't be right now in this trial.
Yeah. 25 days into the prosecution's case, we should be feeling pretty sure.
Mispronounced name, but Rob the Commonwealth said so she must be guilty. That's their theory. KC Cat, Lolly doesn't want to call the ME because the ME isn't going to say what he wants. Plain and simple. The injuries don't match the story. That direct is going to be uncomfortable. That cross is going to be very weird to watch. Valerie C. Runkle never goes to Kenton. minus water equals male baldness. No. Sarah Jones, there are 3 key cycles that are in evidence between when they say she hit him and the testing, 1 getting Jen and back to John's, 2 to parents' house, 3 tow driver into the Sally Port, but CW only skipped 1. I have to go back and read that again. I have to go watch it again. I tried to do a little recap. I have very limited time from when this thing airs live to when I go and recap it. So I'll take a look again. I'm shocked Canton cops get special hair eating brainworms. Look for merch by Ian for the brainworms of Kenton. Alex Daviduke. Ian, you're not chopped liver. Your comments about Karen Reed trial are excellent. Made my positive comments about Andrea and Natalie before you were on air with Bob, who is also great. I go by Bob as well. I love Bob. It's a great name. Thank you, Alex. CSI Kenton, realizing that mass CSI still operates at the same level as the Salem witch trials.
Massachusetts CSI. Their symbol is like cross solo cops and a leaf blower.
What it is. Massachusetts CSI would like to be excluded from this conversation. This is Canton bullshit. That's what they're probably saying.
That probably works better with the leaf blowers being like the cross than the solo cop.
Oh no. Oh, can someone do that?
I am already pulling up the stock card.
Don't just that. Ian is Melody Hideki, who gave any measurements other than Canton? Other Canton police may be recused. The measurements are a mess in this case, and we don't have clear line-to-line measurements other than like a drone footage estimating where things are. You don't have pictures. You don't have tape measures. You don't have shit. You have a trooper saying that's right about where the body was, and then some other trooper taking a drone and looking over top and saying that's 10 feet from that location. You got it, trooper. John Duncan, this guy took 2 classes and he's an expert. He's also been to 196 crashes. Vague, imprecise, and made many assertions that were stabs in the dark and tried to present them as fact. That part pissed me off. That last part, the stabs in the dark, tried to present them as fact. And that is as much Lolly as it is the trooper. Lolly asked those questions, eliciting that testimony. Ladybug Lisa, I keep wondering if John O slipped in the light snow and hit his head on a fire hydrant. But the arm injuries don't fit that theory. Nothing is. Nicole O for the trial dictionary fund. We need one at this point because I'm fucking tired of what, if any, or in regards to, or with regard to, or in relation to. Find another way to start a sentence, Lolly. There are other ways. Look, I started one with there.
What, if any, other ways are there?
I want to stab you. Right in the arm. Or a blunted object. So it M2HMGHB. Being the son of a cop and a cousin of others, I can attest they drive fast and reversed. I have seen nothing saying Reed was the driver at the time. I don't know. I honestly don't. I think that Reed was driving the car is a pretty solid conclusion. Like the car going there and then back home because John wasn't driving it and it ended up back home. Aaron Olivia, glass on bumper did not match the cup. The cup bumper glass. Are you fucking kidding me with that? We're really going to try and say that the glass that's on the bumper was the shattered glass of an individual hole. Are you kidding me?
I just don't know with this case. Like, it's so odd that I just can't even.
Yeah, Kay makes a good point. He said her car couldn't hit his and break the taillight without damaging his car, but it could hit his arm and not shatter it and all the bones. Okay, sure. Okay? You and I do not disagree. I have a migraine today. I blame Lollipop, says Lucy Fair. That's Also fair. AZ
Lollipop.
OJO was blocking face.arm bent.dog top/bottom mark. Officer John O'Keefe was blocking his face. Arm bent dog top and the bottom was the. Okay, that's the theory. Mark Davis.
That to me looks pretty consistent with the injury.
Could be. Mark Davis, does privilege apply if your client says things in front of a prosecutor and judge in ex parte meetings? Nope, it's actually gone. Third parties. Really now, you have to be related to the corporal's coroner guy.
I don't know what that is.
Related to the corporal's coroner guy. Really now I really don't know what that's. Sorry. SK, I'm a BIE, so my entire job is data and data visualization. This chart is garbage. The explanation is to explain this is only going to confuse the jury more. Thank you. Scream it from the back. Thank you. Jason Heath, Rob, you're right. Val Kilmer says, I'll be your hucklebearer. Ian, no, Nat, y'all are wrong. I just watched the movie yesterday. I'm going to go watch it again. This is now, I'm going to watch it tomorrow. Peg Wardo, by the way, lead attorney believes Copeland attorney, which was on vacation. Buckets is filling in. Yes, I actually covered that earlier. This was the stand-in attorney who was, I imagine, caught off guard and didn't have the history in representing.
All right.
Period of time.
I just got to settle this one.
You're going to pull it up. I hate you.
This is the script for the movie Tombstone.
I'm your Huckleberry.
I'm your Huckleberry.
There you go.
Literally, the script says Huckleberry. That's
there you go.
That's it. So
it's solved. Now I will say that's
done.
That's just a random PDF. Ian. You didn't lay a foundation. You didn't authenticate. I'm messing with you. Don't you dare. I will not be here for another hour. Foundation. Just because the chart may be important and helpful, but it's so dense and hard to translate into a way that makes functional sense. You can turn the page just because, no, it was not dense and impossible to translate. It was easy to translate if you add the right fucking questions. Like, it's not hard. It really is easy to translate that chart, which drove me insane today. Also, Kath, why choose this key turn? This was that drive. That's their conclusion. Purple, Dragon Air. I'm screaming in mathematician at this chart. I don't think the expert even understands the chart. I agree. Karate Cat Bomb. It really is turning into my cousin Vinny. It is. We're going to have a, how many fingers? Lauren Rose, I've been able to catch a live in a long time, so I've been on replay crew for a while and still am tonight. Sigh. I just wanted to pop in and send some love to Rob Guest in chat. Thank you, Lauren Rose, and thank you for watching our replay. We love all of you chiming on replay. And Lauren, thank you for making the special exception and jumping into a live and dropping a chat. It is really very much appreciated. The ukulele is really cool too. So, Angela Eric Newman, the trial feels more like the roles are reversed between defense and prosecution. Does Lolly not understand data science? I don't know. Project Calm.
I think that the things that Lolly doesn't understand, you've probably got a whole bunch of options for that.
Scotty doesn't know, but it's Lolly instead. My brain hurts. My brain hurts. It's hurt all day. I was supposed to be in trial today all day long. Good news is it got resolved like yesterday, last minute. You know, the attorney-client relationship is a weird thing. It's very gaslighty sometimes. 1 minute, your client will be screaming at you, and the next, you are their best friend, and they want to buy you a beer because what you predicted came to fruition. And you're just kind of going, this feels kind of abusive.
You're like, pick a lane.
Love this job. It's hard, man. Project Calm. This is a guy used to dealing with strikes that are well known and otherwise observed and describing what happened to the victim versus investigating. Maybe, yeah. Partially stars, y'all. He admitted the Toyota proprietary software was so new to him he couldn't do it for a year. No one validated the extraction. We need to stop giving those numbers credence and get a real expert. That's my fucking question. How is the miles per hour measured? What did you do to measure it? Because I'll tell you what an expert does, a paid expert, they sing you a song like you could not believe, describe everything about how this thing is done. Bella Brat, for you, if we are sitting here debating and trying to understand this info, what's the likelihood the jurors are following any of this? I have no clue. I have no clue. Like Queen, I'm your Huckleberry equals I'm the one you want. Doc says it several times in the movie Tombstone. There you go, Light Queen. Ian just validated that as well. Koch, the Frankfurter, you could just see how relaxed and unimpressed the defense was during this hours-long testimony. Yeah, speculate away. Keep speculating because I'm going to roast your ass on cross. That's what Jackson was doing the entire time. He said, I'm going to let you testify to just about everything you want to do. Under oath. You can testify to speed, calculations, your theories on how it occurred. Hell, you can testify to the injuries because I'm waiting for cross. And one of us is going to walk away. The other one might need a wheelchair. Lindsay, I want to get through this testimony before I lose my mind. Can and will mischief attest to you being in possession of sanity to begin with? Nope, she would refute that. In fact, Minnesota knows the average lane width is 8.5 feet, just for reference. 12 feet was what was testified to as being the clear portion of that road, but it was also plowed. Need a mega pint. The next witness saw KR dancing with the devil, and she has a black hat and extra finger. Soft burn. That was good. Bop it. Prosecution peddling death by tail light theory, and I'm not buying it. I am confused. Ryan Mail YC, Lexus mimics Savage's yet another hapless adventurer. Bella Brat, for you. Oh my God, Rob, can you do a Lexus video like the bed one for Dep V Heard? Louise. P.S. I love your Princess Bride soundboard reference.
You keep using that word. I don't think it means what you think it means.
You mean that one?
Rob is also a child, but
I am never going.
We're here for it.
I will grow old. I will never grow up. Surf Anna, what, if any, lolly total is 1,668. 1,668 in 25 days of trial.
That's the point where you might need like an intervention.
You need an intervention. He needs a shock collar. Every time he says what, and then the next word is if, like it's. Heading on a throwaway, we need a full parody of Pure Imagination for downloaded and purchased by Rob. I think Come With Me and yeah, be in a land of pure speculation. It's probably clipped already, man. Freaking internet. It's probably out. Regret that decision. Gwynnie Bly, if not conspiracy, maybe incompetence plus overconfident confirmation bias, but still plenty of reasonable doubt. Day 9,000. Oh my God, that's a number I'm not going to even try. A whole lot of digits. Catastrophe, love the name. Lolly equals ChatGPT hitting a 5,000 word essay. ChatGPT, ask a question of a witness, but use 5,000 words. Yes, accurate. Project Calm, those physics totally work in Bollywood. Might. No. It's now it needs some tweaking.
It needs some tweaking, but it's a good start.
Don't hate it. I'm not mad at you. It's pretty terrible.
Is that not a good sort of symbol for Kenton CSI.
It's pretty good. That's not bad. I don't hate it. Miss Christy B, Law and Lumber, the musical. Thank you. Jennifer Johnson, you spin me right round, baby, right round. Winnie Bly, yes, I used every character count I could because, yep. Victim, all damage on/to the left tail light or the right. On the right of his body. No, left tail light. I'm now confused. All damage on/to the left tail light is on the right. Oh. As in, like, the body would have hit like crossways. Like, the tail light's busted here, but the damage on the vehicle is over here, 19 inches over the left. Interesting question. I hadn't thought about that. Good point.
And to the left.
Gwitty Bly, thank you for the gifted memberships. Stacy LeBruno, what, if anything, is physics? Lolly doesn't know. We don't know. Holly, hat size. Rob, they now make these. This is my Pinehurst hat in honor of the U.S. Open being played at Pinehurst. My last course I played with my dad was Pinehurst. Small, medium.
At large?
No, my brain's not that big. 70H, how can he hit his heads in the curb and then land 10 feet away? No, Stephanie, I was confused. He did a spinny top and then the bam and bow away like pirouette, and none of that makes sense. None of that makes sense. We are to believe that a 24-mile-an-hour vehicle, 6,000 pounds, struck an individual and he just collapsed, hit his head on a curb, got up, pirouetted, and fell over.
I mean, makes sense to. No, it doesn't.
My dog Snack Dealer, Ian put the symptoms of worms on the back of a shirt.
Oh, yeah. The cat and brainworm shirt.
Luna's mom, guys, and we have to wadir the FBI guys, and this guy just gets accepted as a car crash reconstruction expert. Make it make sense, please. By the way, he's getting admitted as an expert. An expert is someone, you don't have to be like the bona fide best person in the world that knows the stuff. You just have to have a specialized expertise, which is where they get to come in and attack your credibility and your credentials. So, yeah, he's an expert. How much of an expert? Let's see. Gwynnie Bly, more green needed. Then I'll be on replay crew. Hugs all. See you all day. On day 9,847. That's another lot of numbers. Dang it, broke super chat. Just a little last bit. The numbers, you try to put all the numbers in it broke the super chat.
Ashley, it's runkleofthebailey@gmail.com.
Yep.
Also, it's gonna be like the last day of like the Earth slowly the Earth's orbit decaying into the sun, and Lally will be like, Commonwealth rests.
The Earth.
The end of the trial, like everyone's got these big like epic beards. They're all like, everybody looks like the Crypt Keeper plus like a giant beard. The trial just keeps going on. It's like Commonwealth rests. It's like,
no,
why are we here now?
No. This is the trial that never ends. That song is what I reserve for the YSL trial. I sing that song for that trial. This trial is now the Willy Wonka. The come with me and we'll be in a land of pure speculation. Jack W, look at key cycles in graph at 355, 1164 when Paul tested, but 1162 is Karen. The car cycled at least 5 times on the 29th. MSP did the 24 miles per hour, not Karen. I have to go back and look at all of this again. If what you're saying is correct, I have no doubt it's going to be Brown and Cross, which is where I want to focus on Monday. Cross. Gwyn and Bly, thank you for the gifted memberships. Rayman YYC. Reversing at that speed is unstable because of the toe in a properly aligned vehicle. I scared the hell out of me. Jennifer Johnson, did the Asian house have torn up grass from the backwards? Asian house, I forgot about that freaking comment.
The Asian house was also not a great line.
Oh my God, it's so bad. House across the street was occupied by someone of Asian descent. And, well, all the cops on the street just call it the Asian house. Because why not?
Because, you know, they're super, like, yeah.
Just Boston, man. Lucifer, my dog Benson, has been watching you guys cover trials so long. Now we call him Benson Esquire. He represents himself and pretends he has a secretary. I needed this. That made me laugh. Thank you, Lucy. Alex, David Duke, Karen drove a Lexus. I drive a company 2020 model GM vehicle, and a colleague borrowed it and totaled it on a highway crash. And the black box, like an airplane, showed exactly what happened. I don't know. Chris Cat Queen Ian, have you ever had had Crown Attorney worse than Lolly? I imagine.
There's one guy who, like, it depends how you define worse. There's one guy who is a giant jerk. But I mean, I think Lolly's worse.
I've never had a lawyer struggle as much with questions as often.
I don't know if he struggles or he just yeah.
It hurts my brain. This trial is making me dumber. Devin, assuming the internet has correct gear ratios, 24 miles an hour is 3,242 RPM. That's not actually peak. I actually heard more ripping out of the truck. I don't know. I will check that. But maybe it's the Lexus. I don't know. Luna's mom, 24. Dr. Turtleboy posted his attempt in his Lexus on X today. Play it if you can. It's done on 34 Fairview Road in daylight and no snow. He hit the curb on the first attempt, got to 19 miles an hour on the third, and was scared. I don't know. Ian, what are your thoughts on that?
I
don't want to pull up a lot of the stuff because
if we pull it up, we risk copyright hits.
I don't want to get copyright hit. I'm not getting copyright hit. If you guys want to check it out on Twitter, it's on Twitter. I'm going to tell you that. It's on Twitter. But I will warn you. Here's my warning. The warning is people that are commenting about this trial, a lot of the larger names commenting about this trial are doing so with a lot of history in covering these characters. And they bring into this trial a lot of history and historical perspectives and opinions on what did or did not happen that night. So be warned that a lot of the people that are covering this trial and have been covering this trial have some very, very firm opinions in one direction or the other. So it's a fair warning. View what you want to view. Right now, I'm sticking to the trial. That's all I care about is the trial. So confused. John, Beatty Bot, risk of pedestrian death, 10% at speed at 23 miles an hour, 25% at 32, 50% at 42. All of this stuff is these stats, John, are very dependent and they're kind of skewed. Like of that 10% at 23, where did the vehicle hit him? How did it hit him? The circumstances.
And what was the mass of the vehicle?
Exactly. The circumstances of the collision are very significant factors here. So the stats themselves don't really play out. How's the vehicle the weapon? It very well could be.
I mean, vehicles make great weapons. I mean, you can't smuggle one into the bar, but people get killed by vehicles all the time.
Jeremy Morton, Rob turns into a very quiet Peanuts adult character when he tries to talk to a video being played. That might be the roadcaster. It might be catching, like playing the video. I don't know. it might be an auto adjust thing, but thank you for the comment. That actually helps a lot, Jeremy. I'll try to figure out what that is. Shiraz, this situation has all the hallmarks indicative of a lunatic in charge of a bunch of underqualified quislings.
You don't know what a quisling is?
No.
There, I forget the guy's first name, but the guy who was leading. So World War II, Norway. They managed to get the king out after the government basically said the king is going to have all the power, and then they smuggled the king out into Britain. And so this created a bit of a problem for the Nazis, who wanted to set up the official government, because now there was a sort of ruler in exile who actually legitimately had a claim to power and was putting out radio broadcasts and so forth. So who did they install? They installed a guy, Vidkun Quisling, or Vidkun, and was it Vidkun Quist or Quisling? I can't remember. Anyway, so Quisling means basically kind of sniveling traitor, weasel, piece of shit. And it is the kind of thing that if you go to Norway and you decide to call somebody that in a bar, you might get punched. Yeah, it's
okay.
Yeah, don't. It's one of those terms that is it's used casually here and more seriously elsewhere. So
I have learned a thing. I'm very happy to learn that thing. Don't say that word to anybody.
It's like the other one I caution people about here in Canada is the insult goof, because most people think goof is not very serious. If you say it to somebody who's got prison time under their belt and you call them a goof, you are in some shit. Don't it. I purge the word from my use, because it gets people upset here.
Okay. We have learned things. We have learned things tonight. Heather, Rob, how will all of this affect any prosecutions that Proctor has been or could be involved in looking forward? Well, I know that at least one defendant is asking for a review. I don't think it's going to do anything.
I don't think he's going to get it, but
after his behavior at the bad investigation. Nah, you need a hell of a lot more than just this guy testified poorly at this trial. It could, but not realistically. Matthew Felty, attacking the lame demonstration, not the data. Is that an accusation or I don't know. Okay. Greg, what this guy doesn't understand is he has a mechanical engineer crossing him. I learned that. Not just a mechanical engineer, a damn Air Force jet engine mechanic. So
that is like wonderfully entertaining.
It's going to be so much fun. Oh, God. I can't wait. I'm sorry. I'm like giddy. Matthew Felty. Never mind. He's trying to get him about the driveway video. Oh, that was in comment to the other one.
I feel like that cross is going to need to include the a quote from Fight Club. Can you guess which quote?
No. Start it.
This isn't love. It's
don't finish it. Baby Gator.
We're 5 hours in, but I'm still not going to finish that one.
Even with a case, my screen cracked. It has to do with the point of impact more than speed. That's a fair point. I'll take that. John Beatty Bot, great show. Please just don't tell Commonwealth that AAA website clearly shows that risk of death for a pedestrian crash is. Look, John, I get it. Those are the risks. Those are the stats.
That's the averages.
Those are the stats. You don't know the facts behind each one of those collisions. So I get statistical analysis, but there's a reason you can't use stats in a specific trial. They are inherently prejudicial because it doesn't lend to what took place here. Beach Rando, now they're gathering evidence via court TV.
I'm just going to say, maybe this guy isn't like the most stellar example of his profession.
He walked right into a trap that was pretty well set. When did you talk about this? I mean, how often has he testified as an expert to not know that certain things had to be disclosed beforehand?
I mean, to be fair, it's not his job, but yeah.
Nine Snails Gal, Australian people, what's the big deal with see you next Tuesday? Jackson's enunciation, Australian people. Now, when you say it like that, it's less friendly. No, I'm very, very fond of the British pronunciation where they throw the Y at the end. Like when someone is, can I say it? I can say it, right? 5 hours in?
No. It's the one word YouTube absolutely hates.
But when they're being that word, but with the E, they're being blank E.
If you turn like ads on later,
they hate that word.
Because if you turn ads on later, a single use of that word by the prosecutor in the Rust trial got my video like age limited.
So I'm going to explain it this way. I like the British enunciation of the word where it's like the blank E, like where it's like someone's being rather blanky. But when Jackson says it, hard C, hard T, oh, it's bad. Kathy Trout, do I hear you coughing on Sunday, Rob? That sounds contagious. You better stay in bed on Monday. Yes, I gotta figure out what is just dragging on with this. You know what it is? It's kids and the cesspool of germs that they carry around forever and always. Never. Elijah. Thank you. This theory ignores so many variables and borders on the fantastical. I have a Toyota with the same safety features. You can't ignore the lights, beeps, horns, and other alerts. The car would stop with cross traffic and braking sensors. That's a point that I'm pretty sure defense is going to try and bring up on cross. You make it here, so maybe the jury thinks about it too. Miranda Bowman, what are the chances that we'd get to see 2 rock star lawyers in action in the same week? Incredible. So who do you guys think won the week? Brian Steele.
Yeah.
No question. Steele. That was the most badass move I've ever seen by a lawyer ever in my entire life. And yes, I am including Clarence Darrow. That was a badass move. Solid. I take that back. Clarence Darrow's closing in Sacco Vanzetti was better. The filibuster close. Amy's Positive Pathways, my neighbor at Massachusetts State Trooper, is not bald. Will you have them pass the secret to all of the others? Oregon, better theory, brainworms. That's the creatures that cause baldness. Chris Bowman, John O'Keefe's family deserves better than this. They did. They do. Jackie Lind, they may be a troll, but they're not professional troll. That's me. My job is to make sure the target chuckles with me and someone does a spit take on their monitor and keyboard.
I have had somebody email me saying, "Hey, you owe me a keyboard." They were joking, but apparently I made them spit out what they were drinking when I was on the stream.
That's fair. I talk about Bruno. Those witnesses are bad at board games, I bet. Probably. KM944, Giglio, or lack of credibility of expert witness. Nikki Lewis, back up to Jackson, stare Paul leaving court. I did, and that was intense. Heather, I feel like Alan Jackson doesn't like any of the cops in this case because of how they investigated this case. He probably hates it so much because he was a former prosecutor. I don't doubt you. Plus, here's the thing about lawyers. It doesn't matter what side of the aisle you're on. When you become invested, you're invested. And you don't have good trial lawyers don't have a halfway button. I can't look at Ian and say, Ian, half-ass this case. No, he's either in or he's not.
It's whole ass all the time, folks.
Oh my God. Verbalized. And you all witnessed it. All 5,190. Guys, we are 5 hours in. You're 5,000 deep. Thank you for being here. I really do appreciate it. Thank you. I do have to get through these because my mods need to go to sleep, and I do too. Emily, I answered your question. What the chance the jury gets in July? I think July 8th is my date. That's my prediction. Catherine Dugan, did you see the comment that AJ said not too long after that at the end of the day about Jen McCabe? Commonwealth withheld a report from them until after testimony. I did see that. And you know what? A lot of gamesmanship happens in these trials, and both sides will point the fingers. And what ends up happening as a result of that gamesmanship is likely and most oftentimes, fill in the blank, nothing. It occurs. You fight it when you can, and you hope for the right rulings when you get them. Mrs. Squirrel, thank you for the gift of memberships. Kelly B, how do we finish this trial by the end of the month? It's been said prosecutor will be about 4 to 5 days left. I don't know. Lisa Amato, thank you for the chat. AKA the cat lady. No way defense only goes 4 days with Lolly on cross. No way. Lolly, take that back. I was going to say something nice. And then I realized that he's been leading all of his direct witnesses too. You know what? He's going to surprise me. I'm holding out hope. He's going to surprise me. He's going to be a rock star on cross. That's my hope, like sincere hope. Rock star on cross. Matilda, good morning, 6:19 a.m. from the Netherlands. Good morning to you, Matilda. Thanks for being here. Equality. My parents are flying from JP, Japan on Monday for my graduation. Congrats.
Awesome.
That's awesome. So cool. Probably haven't seen him in a while too. That's so much fun. Wheezy closing on July 3rd as a birthday present to me. Happy early birthday, Wheezy. July 3rd. Breathe. Lindsay, you didn't factor in Emily traveling for VidCon into your closing predictions. She'll be on airplanes. You know what that means. No, I kind of did, just in the back thought. I think it's going to happen. Brianna B77, odds at this point for dismissal when prosecution rests. No chance. It's going to the jury. It is going to the jury. There's no dismissal at this point. It's going to the jury. Joshua, thanks again for another great FNF and have a wonderful weekend, everyone. Thank you, Joshua, and thanks for being a mod and thanks for being and sticking around. Much appreciated. All the happy squirrels. It's been a really fun FAFO tonight. Missed this? Thank you. XCDA, thank you for getting memberships and thanks for being a mod. XCDA, jumping up. Julia 543, let's get Andrea 80K subs. Here's the thing. Andrea Burkhart is, I believe Ian will agree with me because there's 5,000 of you here, right? Ian is likely to agree with me, and I don't imagine he's going to refute this contention. Andrea Burkhart does more research for her videos than perhaps anyone I have ever seen.
She is real careful, and if I say something and Andrea Burkhart says a different thing, I'm like, oh crap, I'm probably wrong. So
I will disagree with a lot of people on the interwebs. Ian, Emily, Rick, Alita, Joe, pick your poison. When Andrea says something, especially when it has to do with a factual history in a case or a motion that was a pretrial motion that was ruled on, she's the only one that I really kind of go, I'm going to take that under advisement.
If Andrea sent me a DM going like, hey, you did a video and you said a stupid thing, I would probably pull the video down and then be like, I got to do my research because, yeah, thankfully she hasn't done that yet. But yeah.
No, and I find myself agreeing with her like 10 times out of 10, to be honest, especially in the Koberger coverage. The thing is, when Andrea
her Koberger coverage is there's just no one else in. no one else covering it like as well.
And that was the
Sorry to other creators.
I made the comment about when Ian takes a case to trial or when I take a case to trial, or you can't turn a lawyer and take them say do this half-assed, right? Andrea takes that approach with all of the cases that she monitors.
Yep.
She does not do it half-assed. Now, I say all of this because she was engaging the chat earlier tonight and doing a great job of participating with you guys in the back and forth. So here's what I want you to do. I pinned a link to her channel at the top of the chat. You got Natalie to 150,000 subscribers today. Andrea, right now, based on what I am seeing, is at 7,178.
She needs that play button.
She's at 78,900 subscribers. One, that's criminal. For someone that is that intelligent and gives this type of commentary, that's criminal. She needs to be over 100K. Two, there are enough of you that are currently live watching that you could make that jump over 80,000 with a click of a button. Like I said, Andrea Burkhart, back in Johnny Depp, had some of the most thorough research I've ever seen. And this is, I'm a practicing trial attorney. Like, I go into trial with binders and binders and binders and binders and binders. And I know the families that I represent more than the families know themselves. The prep work that Andrea does, I'm envious. It's envy. That's what it is. It's envy. Not to mention she fucking boxes.
Oh, I've seen the boxing. Somebody was like, "Do you think you could beat Andrea in a fight?" And I was like, "Fuck no,
no." Do you think I'm dumb enough to get in the ring? No. So yeah, go subscribe now. Honestly, it'd be really cool if she woke up and had over 80K. So please go do that. It'd be really neat. Be a big favor to me. Luna Dewdrops, you're at 4,200 likes. Love you guys. EDB, Runkle, and you, Rob, my fellow ADHDers. Love the ADHD crew, Spicy Brain crew. We love it. Thank you. Lady Los Angeles, thanks for becoming a member. Love seeing you back, by the way. Haven't seen you in a while. Ancient Maverick, family doesn't believe me when I try to explain this case. It takes like 30 minutes. I try to explain this case in like a 5-minute window. You can't do it. Good luck. Trish 818. Sorry, I didn't mean to say Trisha. I don't know if that bothers you. I don't know what Karen Reed did / not do. Miles per MPS and more are hiding something. Oh, Massachusetts police. Oh, they're hiding something. I don't know that they're hiding. I just don't think they've proven their case. Ernie, unflawless. You help make a tough week bearable. Thanks, guys. Thanks for being here. Very much appreciated. I'm sorry it was a tough week. Hopefully it's a better weekend, and hopefully that you can get some laughs and get outside and enjoy the sunshine. Lady Los Angeles, love that you covered the Karen Reed case. I've been watching it in the background while I'm doing like trial stuff. Like Ian's recaps, they are my nightly routine. So I pop in the chat and say hey and engage. But honestly, that's where I get a lot of catch up. So please go check those out. And Torin 3, Andrea B earned a braid from her coverage on this trial alone. That's awesome, Torin. I don't have mine displayed. I'm sorry, my friend. I don't.
I've got to build a proper display setup.
Yeah, mine's packed away, but it's going to be properly displayed in the new house. So to all of you that are still watching 5 hours deep, thank you very much. I did turn off super chats to make sure we got through the end of this madness. Thank you for being here. I really do appreciate it. I knew that it was going to be a little bit longer tonight with all the chaos that happened this week, but I very much thank you guys for sticking it out. Ian, thanks for being here as well, my friend, and enjoying and laughing along.
Thank you.
Natalie, lawyer.
Yep. I might have to pick a fight with the Ontario court system now.
Oh, do tell.
So they have a list about they have a media list and like for access to digital court recordings. And they also have a media report list. And so I asked for permission to be on their designated media list, and they said, no, we only do this for like legacy media. So I'm like, game on. Might be time to pick a fight there.
We'll pick the fight.
Yep, just to say, hey, you guys have to do this on a basis that isn't just, you can't just do this for legacy media. It's got to be available to others as well.
Let's pick the fight, man.
So
Ian is a very he's a very pleasant, calm, very sweet young man when you speak. Now he's aged like a wizard, so keep that in mind. Very sweet and kind. I know for a fact that changes when he goes into court.
I'm still very polite and so forth. It's just I'm down to clown.
Kate watches all these streams and does this. She volunteers and she puts out timestamps. So timestamps might be a bit delayed. Kate, you never have to do this, by the way. I appreciate the hell out of the fact that you do it. You never have to. Thanks for doing all you do, and thanks for the mods. Thanks you guys so much. Please, Natalie Lawyer Chick, Andrea Burkhart, they were great participants. Andrea in the chat, Natalie in the live. Also featuring in the chat tonight, we had Lead Attorney, so please go check him out, and Emily D. Baker, please go check out her, although most of you already do based on the metrics that I have. So cheers to all of you. Have a wonderful weekend. I hope it's not too hot where you are and you can get outside and enjoy the weather. Go make something, go feel better, spend time with family, be productive, and just make life a little bit better for yourself. Cheers to all of you. Ian, we'll catch you over the weekend.
Absolutely.
And on Monday. So good night, all. Much appreciated. Thanks for being here. Happy Friday. Now Saturday. So, cheers.